ಸೀರಿಯಲ್ ನಂಬರ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದರೆ ಇದಾ ಕೊಟ್ಟಿಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಇಲ್ಲ 35
ಕೊಡ್ತಿಷ್ಟೇನಾ? ಇದು ಕೊಟ್ಟಿಲ್ಲ. ಎರಡೂ ಕೊಟ್ಟಿಲ್ಲ. ಇದು ಲಿಸ್ಟ್ ನೋಡ್ಬಿಟ್ರೆ ನಿಂಗೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ಸುಮ್ಮನೆ ಅಲ್ಲಿ ಹುಡ್ಕೋಬೇಕು, ಇಕ್ಕಿರ್ತೀನಿ ಆ ಲಿಸ್ಟಲ್ಲಿ ನೋಡಿ. ಒಂದ್ಸರಿ ಮೇಡಮ್ ಹತ್ರ ನೋಡ್ತೀವಿ ಆಯ್ತಾ? ಅಂದರೆ
No, magari tu mi escono contro il zona che sono
ಇದು ಎರಡು ಗಡಿಪಾರ್ ಮಾಡಿದ್ದಾರೆ, ಗಡಿಪಾರ್ ಮಾಡಿದ್ದಾರೆ ಎಕ್ಸ್ಟರ್ನ್ ಅಂತ. ಫಸ್ಟ್ನೇದೊಂದು ಜಾಸ್ತಿ ಅವಲ್ಲ, ಇದು 4ನೇದು. ಹೇಳಿ ರಾಕೇಶ್ ಅವರೇ, ಕೋರ್ಟಲ್ಲಿದ್ದು ಹೇಳಿ. ಓಕೆ ರಾಕೇಶ್, ಓಕೆ ರಾಕೇಶ್.
The memo for posting is accepted and on the senior basis and the party person. And I asked the today the to be taken as an action. Today only they are supposed to post before. No, it's not. ಪೇರೋಲ್ ಇವತ್ತೇ ಇದೆ ಅಲ್ಲ, ಲಿಸ್ಟ್ ಆಗ್ಲಿಲ್ವಾ? ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದೆ ಇದು, ನಾಳೆಗೆ ಹಾಕ್ಸೋಣ. ಹೌದಾ, ನಾಳೆಗೆ ಹಾಕ್ಸೋಣ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಅದು ರೀಚ್ ಆಗಲ್ಲ ಸರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಇದು, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ್ ಆದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ. ಐಎ ಕೂಡ ರೀಚ್ ಆಗಲ್ಲ. ಅಲ್ಲ ಹಾಕ್ತೀನಿ, ರೀಚ್ ಆಗಲ್ಲ. 3 ಥರ್ಡ್ ಹಾಕಿದೀನಿ. ಥರ್ಡ್ ಸೆಪ್ಟೆಂಬರ್ ಬರುತ್ತೆ, ಕಳಿಸ್ತೀವಿ ಸರ್. ಅದೇ ಥರ್ಡ್ ಹಾಕ್ತೀವಿ. ಅಲ್ಲ, ನಾಳೆಗಾದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಆದ್ರೆ ಥರ್ಡ್ ಡೇ ಬರುತ್ತೆ ಆಟೋಲಿ. ಚಲ ಪೆಂಡಿಂಗ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇ ಸಬ್ಮಿಟ್.
ಕಳಿಸ್ತೀವಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇ ಸಬ್ಮಿಟ್.
ಸರ್ ಹೇಳಿ ಸರ್.
Item number 12 maybe on tomorrow. Item number tomorrow.
ಮಾಡಿ.
Court officer.
ಬರುತ್ತೆ.
Court officer.
ಯಾಕೆ ಅಂತಂದ್ರೆ ನೋಟಿಸ್ ಆಗಿರುತ್ತೆ.
Court officer may submit.
Yes. And 5 people left the. That was from Suraj.
Submit ಮಾಡಿ ಕೊಡಬೇಕು. Submission ಮಾಡಿ ಕೊಡಬೇಕು.
Court officer may submit.
ಇಲ್ಲ, ಇಲ್ಲಿ ಅಲ್ಲಿ
Court officer. Item number 12 maybe on tomorrow.
ನಾವು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Sorry. Yeah. Yes. Mention.
ಅಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಇರ್ಲಿ, ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ. ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ ಇವತ್ತು. ಸಿಗ್ನೇಚರ್ ಇಲ್ಲಿ ಮಾಡಬೇಡಿ, ಅದಕ್ಕೆ ಬಂದಿದೆ. ಆಫೀಸ್ ಇದೆ, ಅಲ್ಲೋಗಿ ಮಾಡ್ಬೇಕು. ಫೈಲ್ ಇಲ್ಲಿ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದ್ಯಾ? ಇಲ್ಲಿ ಇರುತ್ತೆ ಫೈಲು, ಟೈಮ್ ತಗೊಂಡ್ ಮಾಡಿ.
May court officer.
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ ಇಲ್ಲ? ಮಾಡಲ್ಲ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರೋದೆಲ್ಲ ಬರೀ ಪಾಠ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ, ಚಾನ್ಸ್ ಅಷ್ಟೇ.
Madam, item list, first list item number 12.
ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
Maybe on tomorrow.
Submission, make a submission.
Oh, okay.
ಅವ್ರ ಪಾಪ ಅವರು ಹೆಸರು ಚೇಂಜ್ ಬೇರೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನೀವು ನೀವು ಒಂದ್ ಕಡೆ ಬರ್ಬಿಡ್ಬೇಕು, ಬರ್ದು ಹೇಳ್ಬಿಟ್ರೆ ಈಸಿ. ಸರ್ ಯಾವತ್ತು ಮೊನ್ನೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಹಂಗೆಲ್ಲ ಮಾಡಲ್ಲ. ಅಲ್ಲ ತಪ್ಪಿರ್ಬೋದು. 71 ಅವ್ರು ಟೈಪ್ ಮಾಡೋದ್ರ ಮೇಲೆ, ಅವ್ರು ಏನ್ ಟೈಪ್ ಮಾಡ್ತಾರೆ ಅದ್ರ ಮೇಲೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ಅಲ್ಲ ಇದಲ್ಲ, ಇದು ಇವ್ರು ಅಪ್ಲೋಡ್ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ. ಈ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಟೈಪ್ ಮಾಡಿದ್ಮೇಲೆ ಈ ತರ ಬರುತ್ತೆ. ಇಲ್ಲಿ ಅದು ಹಿಂಗಿದೆ, ಹಂಗೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ಆಯ್ತು, ಬರುತ್ತೆ. 230 ಲಿಸ್ಟ್ ಆಗುತ್ತೆ, ಬರುತ್ತೆ. ಇದಪ್ಪಾ ನಾನು ಎಷ್ಟು ಸತಿ ಹೇಳಲಿ, ಅದು ಮ್ಯೂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮಧ್ಯಾಹ್ನದ ಧಾರವಾಡ ಕರ್ಕೊಂಡು ಬಂದಾಗ ಸೌಂಡ್ ತುಂಬಾ ದೂರ ಆಗುತ್ತೆ.
ಇದು ಇಲ್ಲಿ ಇದು ಲೂಸ್ ಆಗಿತ್ತು.
ಇವಾಗ ಅದು ಯಾವಾಗ್ಲೂ ನಾನು ಅದನ್ನ ನೋಡ್ಕೊಂಡಿರಕ್ಕಾಗಲ್ವೇ? ನಾನು ಮೆಕ್ಯಾನಿಕ್ ಯಾವತ್ತಿಂದ ಇದನ್ನೇ ಹೇಳ್ತಿದ್ದೀನಿ.
ಮಧ್ಯಾಹ್ನ ಬರ್ತಾರೆ.
ಲಾಸ್ಟ್ ಥರ್ಸ್ಡೇ ಇಂದ ಇದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
months, you make the application.
My lord, matter seeking masking of names in a matrimonial appeal, my lord.
Matrimony. When are those matters? Masking matters,
This is a
there's
fresh matter, my lord.
fresh man notice has to be ordered, not at all.
My lordship, only externment order has been challenged, my lord.
Obliged.
Have you been heard in the matter?
Yes, my lord.
Then section 59.
Yes, my lord. End of the
What
list.
is nade?
End of the list, my lord.
Not end of the
Monday, my lord.
Monday.
I'm a landowner, my lord. The developer is under CIRP that has lapsed over 1200 days ago, 1200 days ago. And although I have challenged insofar as my land is concerned before the NCLAT appeal is not coming up due to certain office objections. Meanwhile, what the CIRP has done is that he has issued an expression of interest on 15/8, my lord. And he is also, and
You have to clear your office objection, it will be taken up by NCLAT.
right, my lord, he has already posted, issued this Form G in the newspaper. my lord.
Correct. So you had time to come here, you can't comply with before the NCLAT.
NCLAT also, my lord, the difficulty is that because of this.
It'll be a waste of time here. Tomorrow we'll dismiss it. Third. Yes, madam.
My lord.
Hereditary exception. And the matter before the commissioner, before the deputy commissioner, cross-examination, I could not cross-examine the PW1. Filed an application seeking that order, that stage was closed, my lord. I sought for a copy, my lord. Copy was rejected saying we cannot give because the matter is pending, my lord. Matter is now listed for
Copy of
29.
the cross-examination cannot be given.
Order of rejection also, my lord.
Enappa idu?
Endorsement is challenged, my lord.
Tomorrow. Get serve it on Ms.
My
Shamla.
lordship, this is the.
Please don't interrupt in between.
My lordship.
Matter was posted on 12th of August. My oversight on the matter was last time on last.
Today, third year. End of the list. Please don't interrupt. Who has frozen the account?
End of the list.
So reply to the Garnishi order. Third. Monday, Tuesday, third. Not at all. No urgency. Is ESA, you have not paid ESA, therefore they have done it. So we serve it on the other side, Monday we'll take it up.
My lord, the police have banned me to arrest next.
You don't want it on Monday? Monday ಇಲ್ಲ ತಗೊಳ್ಳಿ ಅದು ಮೆಮೊ ತಗೊಳ್ಳಿ ಅದನ್ನ September 28th ಬರೀರಿ. Yes.
My lord, the police have banned me for the execution of the externment order. It may be taken up tomorrow, my lord.
Police are behind you for?
To arrest me and to execute the externment order, my lord.
So why are you not being arrested?
That's.
You have been heard in the 58
No,
55
my lord.
proceedings?
No, ma'am.
Tomorrow.
My lord.
Serve it.
Recreational club matter is covered. GM police.
Recreational club ಇವತ್ತೇ ಇದಲ್ಲ end of the list ತಗೊಳ್ಳಿ.
My lords, this is a tender matter. My lords has been kind enough to give the stay. I have served the notice to the respondent number 2, my lords. So
The pending matter will come in seniority matter. You have a stay in your favor?
Yeah, I have stay, my lords, but the tender, it has been held for a long time, so wish to kindly
Holding.
consider for tomorrow. And my lords, one
Regular course, seniority.
more, my lords. Passport, regarding the passport, my lord.
Fresh matter, pending matter.
Pending matter, my lords.
Pending matter in seniority. Fresh
Yes,
matter.
my
you-
lords. ಇದೇನಂದ್ರೆ my lords, passport expiry ಆಗ್ಬಿಟ್ಟಿದೆ, my lords. It's been
Madam,
already.
all pending matter will come in seniority. Fresh matter, pending matter. Tomorrow. Date was given today and it did not come up. Huh? Memo ಯಾಕ್ ಬಂದಿಲ್ಲ? Compliance is made? If compliance is made, it should be listed. Verify that tomorrow. What can we do? We can't do any selection.
The thing is, the selection committee has been suspended, my lords. And I am the athlete, my lords, who has won the first time bronze medal for the India, my lords, and I have not been selected.
Can the court select a sports person, Mr. Counsel? Mate.
The thing is,
If you come at the last moment, what do we do?
my lords, 2:30.
Tomorrow, third. Yes. At 2:30, third.
Association, registration,
Hmm.
by this honorable court in the previous occasion.
It's a pending matter.
Fresh matter.
Hmm.
Direction in the previous occasion to register, to appoint an administrator. Administrator was appointed, my lord, and there was a direction also to conduct an election after holding general body meeting. Now, my lord, without holding a general body meeting and without publishing the voter list, my lord, they are.
Sorry, Monday.
Election is there.
Then you have to come after election, for tomorrow. Hmm?
My lord had orally said that after the regularization of the deviated land, consequential orders are also have to be passed by the government. My lord. However, the second part with respect to consequential relief has been
Tomorrow, Monday though. Hmm?
Election matter, 1888 general body meeting election was declared. Tomorrow is an option for the nomination. Membership was suspended on the same day, my lord, because
Civil suit, all these election matters will be dismissing it. Civil suit, Supreme Court is clear on that. We can't intervene in this. No, Supreme Court judgment worthy tomorrow.
May I submit, my lord? May I submit?
Hmm? Hmm. Approved the undervalued document. So there is an appellate remedy provided to the IG. Appellate remedy to the IGR is available. Appellate remedy to the IGR is available. Ayat Kodi, Somara Mangalwara. Next week though.
Your Lordship,
You can argue then. Yearly. Reserve idre 90 days time ಇದೆ.
My lord, may I submit, my lord?
Just a moment, please.
My lord.
Hmm? You got your instructions, Jafar, in this? 2:30.
My lord, fresh matter, KIDB is cancelled and allotment in my favor. May I request for any day next week, my lord?
Next week, though.
My lord, GM police, the petitioner is being harassed by police since last 2 weeks. I had moved and memo 2 weeks before also, my lord. But
why is he being harassed for last 2 weeks?
my lord, just by issuing a notice under section 94 of BNSS, he is called to police station, made to sit from morning till evening. It's affecting his employment as well.
A copy.
Your Lordship, it's a
Tomorrow,
fresh.
my lord.
Come next week.
Your Lordship, it's a fresh matter and the petitioner company is declared fraud without giving any sufficient opportunity.
Sorry?
The petitioner company has been declared as fraud without giving any sufficient.
By whom?
By the respondents, Canara Bank, Your Lordship, without giving sufficient opportunity, Your Lordship.
Kodila.
Fresh.
I'm declaring as fraudulent.
Fresh matter.
My lord, goes before the appropriate bench.
This is the fresh matter, Lordship.
My lord.
Hmm?
Roster notification, Lordship.
Roster notification.
Reservation. Reservation.
Monday, Tuesday.
Lordship, tomorrow.
Lord, it's a pending matter, my lord. Your Lordship had so much included demands and sought a report on the petitioner's husband, who is a comatose state. My lord, on the last date of hearing, your Lordship directed me to notice is served on all the parties, including the ones who were abroad. It has been served, my lord. In fact, respond number 8, the Zurich Insurance has taken no objection to the petition.
They've been served and they've entered appearance?
My lord, they have said that they won't be entering appearance. I have an email to that.
Monday, though.
Monday. My lord, may I kindly request it on the 2:30 list?
My lord. My lord, fresh matter. Serial number 12. Fresh matter. Maybe on tomorrow.
Mr. Srikanth, can you hold your horses? Did we come to the VC?
Yes.
Why are you interrupting from that time?
Yes.
If you have no manner of knowing how to appear through VC, please don't appear through VC.
Sorry, my lord. Sorry, my lord.
ಅವ್ರು ಏನೋ ಹೇಳ್ತಾರೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಹೇಳಿ.
The fresh matter regarding tender matter, the video will be technical to open and that's what the entire notification.
ನಾಳೆ tomorrow.
I have one representative.
Serve a copy on the. They'll get instructions. ನೀವು ಫೈಲ್ ಮಾಡಕ್ 3 ದಿನ ತಗೊಂತೀರ, ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ 2 ಗಂಟೆ ಬೇಕು. ಕೊಡಿ. Tomorrow. ಏನಪ್ಪ? Next week already. Yes. Sorry? Hearing before whom? Go present your case. We are not going to decide that. Monday, you appear there. Fresh application for what? Parole relist on 3rd September.
Lots, the police complaint authority has directed to remove the name of the petitioner from the name of the history sheet maintained by the respondent police. Even after the order passed by the Karnataka Police Complaint Authority, they are not removing the name of the
next week.
But kindly, my lords, can it 2:30, my lords?
Everybody wants it at 2:30.
In the name of the surveillance, they are coming to my home. They
You
are threatening
want
the petitioner.
the matter to be taken up or not to be taken
Kindly,
up?
Subsequent to the freezing, I have earned income. I'm not able to pay my income tax. If this matter may be taken up for a direction to the enforcement directorate to directly pay to the income tax department.
Next week.
And my lords, the second matter, same petitioner and against the enforcement directorate challenging their provisional attachment. Same petition.
ECIR has been challenged?
ECIR, no, my lords.
In any matter, ECIR has been challenged. Then you'll have to move this there.
We moved it there, but the registry is telling it's supposed to come before my lords.
Check my ECR judicial order.
Third memo we're moving.
If ECR has been provisional attachment to alle hogu.
Check my. I'll move it there.
Posted before the appropriate bench.
Now the petitioner got a joint settlement memo. The respondent has been appointed for almost a year. The petitioner, the aged person, got into a joint settlement memo.
What are you moving?
It's a pending matter, my lord.
Pending matter will come in seniority.
My lords, rowdy list was been closed in the 2023, my lord. But now, even though there is no pending cases against the petitioner, my lord, they have reopened the rowdy list, my lord.
They have issued a show cause notice.
Please, my lord.
It's for you to reply to it.
No, my lord.
Not come to this court.
That was
If you reply to the show cause notice.
No, my lord.
We'll be imposing costs on all these matters if you start coming like this. We have been not doing that. When you have the alternate remedy, if you keep on coming here for unnecessary things, we'll be imposing costs. You want to move it, move it.
Lord, that Ramkrishna Pillai matter, my lord. Ramkrishna Pillai matter, my lord, senior.
ಏನಾಯ್ತು?
My lord, ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ ಬಂದಿಲ್ಲ ಮ್ಯಾಟರ್.
ಸೋಮವಾರ ತಗೊಳ್ಳಿ. He has been treated at Manipal Hospital?
Yes, my lord. And now he is in Baliga Hospital for further continuation.
So now he's doing well.
He is doing well. And another serial number 96. The sons of the Ramkrishna Pillai has filed one more petition.
So this also when it is 96 Monday or Geli Monday.
96.
Connect madbidi.
The respondent association is constructing a landfill illegally in the common areas without any proper documentation or approval from the regulator.
Society registered and society is registered now. Somvara told.
Notice also is not been issued. We have filed an amendment application to amend the petition.
Please don't be wasting the time during mentioning. It's a pending matter, it will come up in seniority. Alone board equity. Pending matters will come in seniority, don't mention.
Serial number 80, my lord.
One nimsha. Yes, VC, what was this mentioning?
Yes, serial number 12, maybe on fresh matter, my lord. Maybe on tomorrow.
Not tomorrow. Any adjournment will be 24th September. Is it okay?
May not be urgency. I was in out of station. Maybe on tomorrow or Monday.
You can always appear through VC. Otherwise, it will go to 24th
Yes, but
September. What do you want? To be adjourned or not to be adjourned?
Maybe on tomorrow. Tomorrow
Well,
it's possible
at
then.
the request of counsel for the petitioner, 24th September. Next.
My lord, for submission minutes.
Yes.
My lords.
List
My
number
lord,
1.
serial number list 1, my lords.
With regards to posting, my lords.
Wait till this is over.
Adjournments, list number 1, page number 5, serial number 34.
Did I mention, my lord, serial number 29, my lord?
I'm appealing for the petitioner 29, my lords.
HPCL matter, my lord, which my lord had heard.
Yes.
In principle, they have agreed, my lord. They will need a little more time to, my lord, file the memo for settlement, joint memo. Petitioner
for
is also,
settlement?
yes, my lord.
And for the petitioner, Millets, we have shared the copy. Some terms are being discussed, Millets.
Oh, this is the
The public
DRDO.
premises, DRDO.
DRDO, Millets.
Both the councils seek for and are granted.
It will be in the week starting 7th September, my lord.
2 weeks time to explore the possibility of settlement. We list on 9th September at 2:30 p.m. Under the
Grateful,
council
my lord.
Serial number 26, my lord. I seek for adjournment.
26. 26 at the request of council for the petitioner, 24th September.
Grateful.
Page number 6, serial number 35 to 38. Page number 7, serial number 39 to 42. Page number 8, serial number 43 to 46. Page number 9, serial number 47 to 51. Page number 10, serial number 52 to 58.
My lord, serial number 57, my lords, I appear for the petitioner.
At the request of council for the petitioner, 24th September.
My lords, the interim order may kindly be extended.
Interim order earlier granted.
Page number 11, serial number 59 to 64. Page number 12, serial number 65 to 67. Page number 13, serial number 68 to 72. Page number 14, serial number 73 to 80.
79, my lords. 79. Petitioner in this case.
79. At the request of council for the petitioner, 24th September.
My lords, interim order, my lords.
Interim order.
80.
80.
Author is not in space. Petitioner comes.
Responding inform madidira?
ಇಲ್ಲ ಮಾಡ್ತೀವಿ.
Madilla and don't mention, please. Next.
Page number 15, serial number 81 to 87.
Serial number 84, your lordships. For the respondents, we pray for time to file our objections.
You're for which respondent?
Respondent number 1, your lordships.
Have we informed the other respondents and the petition?
Respondent number 2 to 3, as well as the petitioner, we have informed.
84, the request of council for respondent number 1 released on 24th September.
Much obliged.
Page number 16, serial number 88 to 92. Page number 17, serial number 93 to 98. Page number 18, serial number 99 to 103.
Yes. 127.
Have authorization to appear in that matter, my lord. My name may kindly be shown.
The council submits that she will be appearing for respondent number 1. Registry is directed to print her name as such. It is unlikely to reach, date will be given later.
My lords, this is with regards to issuance of passport, which was listed 2 days before. So a date is given on 22nd of next month. So I have my travel dates on 10th of next month.
We will also plan our travel.
My lords, this honorable court has passed an order for issuance of passport because
if dates are given, don't please unnecessarily move it.
My lords,
what is the point in giving dates if you again
that's
try
a
to
fresh
advance?
matter, my lords. That's a fresh matter.
It will come on 22nd. Next.
Serial number 132, memo for withdrawal.
132 memo for withdrawal. Yes.
List number 1, fresh matter, serial number 1. Manjana MS.
Yes, Mr. Manjana.
Petitioner Lordship, I have challenged the collegiate compromise decree. Lordship, kindly appreciate respondent number 1 to 4 filed a suit, invoice number 10/2023 before the civil judge Srirangapatna.
Plaintiff is there?
Plaintiff Lordship, page number 68 Lordship.
Against Chiktayamma.
Yes, Chiktayamma is the family members. Then Lordship, kindly appreciate page number 72, address sheet 73. The matter is called before the National Lok Adalat, Lordship. By that time, actually the defendant placed expert. They filed a 907 applications, expert had to set aside, then entered into a compromise, collegiate compromise, Lordship.
How are you connected with this matter?
Lordship, the respondents 1 to 6, 1 to 5, and petitioners are nowhere connected. They are different family. Lordship, kindly appreciate, we filed a one suit for, in page number plaintiff. Lordship. We filed a suit for OS number 9/15. Petitioner 1 and 2 filed a partition suit. Lordship. Page number 28. Lordship. 2015 itself, we filed a suit in respect of the same compromise scheduled property.
28.
28. Lordship. Kannada version. Handwriting. ಅದರಲ್ಲಿ schedule number 1 ನಲ್ಲಿ compromised schedule property was made as a schedule item number 1.
21/1. ಇದು 125/1 ಇದೆ.
120 Lordship, actually 125. Lordship, kindly appreciate, there is a kindly come to page number 42. Lordship, there is a lease agreement executed by the
You
father.
said as regards same property, a suit had been filed.
Yes, yes.
But the schedule in that suit does not reflect survey number
Actually,
125/1.
Actually, that was amended. Lordship. Number
Show
was
us the
amended.
amended plaint.
Amended plaint.
ಇದು amended plaint ಇದೆ, ತಿರುಪತಿ ದಾವೆ ಅಂತ ಇದೆ ಅಲ್ಲ.
No, Lordship.
Page, what page is this?
That number was corrected.
28. 28 is the amended plaint. Is there a further amendment to this?
There, in respect of that, there was an amendment. What's
So is that amended plaint indicating that 125 is a part of that suit?
Lordship, kindly appreciate page number 40 on lease agreement. Lordship. Page number 42. Lordship.
Show us in the plaint first.
Yes, I will.
Lease. If it is a part of a suit earlier between the parties, and who are the parties to this?
Lease is executed by the father of the petitioner. Lordship. In respect of same compromise scheduled property.
So lease
It is was taken place in 2003.
Lease doesn't take away the ownership. Anybody can compromise on the property. The lease will be subject to the ownership.
Of course, Lordship. Actually, my submission, Lordship.
ನೀವೇನ್ ಲೆಸ್ಸಿನಾ ನೀವು?
ಇಲ್ಲ sir. Now lessers, sons and daughters.
You are claiming ownership.
Ownership.
So ownership you'll have to show us in the suit.
Yes, I will produce the amended plaint.
ಯಾವಾಗ produce ಮಾಡ್ತೀರಾ?
Next 2-3 days time.
Learned counsel for the petitioner, after arguing for some time, seeks to produce the plaint, stroke amended plaint, in a pending proceedings where the land in survey number 125/1 is a subject matter. Released on 3rd September.
Obliged.
Serial number 2, Bojana KZ.
Yes, madam.
Appearing for the petitioner, Lordship. Lordship, we have completed the project on 10/11/2021, Lordship. They imposing a penalty for filing the quarterly update for the year of 2022, 23, 24, my Lordship. We are not falling under this ambit of section 41 of RERA Act, my Lordship.
So you have to file an appeal, madam. There's an adjudicatory order.
My Lordship, we also requested the concerned authority by way of requesting letter, my Lordship.
You can't do request letters.
Yes, my Lordship.
These are adjudicating authorities. Adjudicating authorities don't act on letters. You have to file appropriate proceedings. You're not a party in person, so you find out what is to be done and do that. And AG accepts notice for respond number 1, Shri K. Rajshekar for respond number 2. Petitioner is before this court seeking for the following. What has been challenged is the recovery certificate issued under section 40 of the Karnataka Real Estate Regulatory Authority, and for a direction to the Real Estate Regulatory Authority to consider the representation which has been submitted by the petitioner, containing that the petitioner's project is a completed project which does not come within the purview of the RERA 2017. If that be the case, since there is a adjudicated order which had been passed by the adjudicatory authority, it is for the petitioner to avail of such remedies as are available under law and under the Act. A representation cannot be directed to be considered when an adjudicated order has been passed, reserving liberty to the petitioner to agitate the same appropriately. By following the due procedure, the petition stands disposed.
Much obliged.
Serial number 3, Venkatesh Sarbat.
Therefore, petitioner in this case.
Not considered. ಏನಾಗಿದೆ?
Government are challenge ಮಾಡ್ತಾರೆ.
The recommended prayer was not imposed. He was reprimanded and.
And AGA for respond number 2, issue notice to number 1, returnable by
22nd September.
22nd September.
My lord,
Counsel for the
IMA,
petitioner
my
is
lord.
permitted to take out hand summons on respond number 1. IA 3 of 26 is allowed.
Serial number 4, Rishikesh B.
Mr. Rishikesh,
Your Honor, fresh matter, Your Honor. First hearing, respondent counsel has filed wakalat prior to notice.
very good.
That is.
You are for the petitioner? I thought he was appearing for
Hearing
you.
for the petitioner, Your Honor, care home.
What is annexure A?
Your Honor, care home is a society incorporated under Karnataka Society Registration Act.
Was the notice issued, Mahesh?
And
Was the notice issued before annexure A was passed?
My lord, the annexure A, my lord, is a order passed in a revision petition, my lord. Originally, my lord, their application was rejected, which my lord will find it annexure H, page 40. That, my lord, was a response through an email by saying that it's rejected under so-and-so provisions. Impugning this, my lord, they filed a revision under section 32 of the FCRA Act.
It is their revision.
Yes, that revision, my lord, is the impugned order at annexure A.
Why are you saying that violation of national justice?
Your Honor,
Your own revision.
Your Honor, the mail was a single line mail saying that the renewal application has been refused under 2 sections. And after filing the revision application under section 32, they have issued the order after 11 months. In that order, Your Honor, point number 6, last sentence, it says so. As the permission already granted was not at all affected or revoked, the question of giving reasonable opportunity of hearing is not applicable in the instant case. Your Honor, the chance of personal hearing was also not given to us, Your Honor. And
Has he been heard?
in that order,
Not
Your
been
Honor, which
heard.
is a violation of
Lord,
the
while-
fundamental.
Initially, while rejecting, my lord, he has not been heard.
He should be
But
heard.
later on, my lord, the query has been posed, to which they have responded. That has been considered, my lord, and then that comes in the order itself, my lord. It shows that paragraph number 2 of the revision
He has
order.
filed a revision petition. It has to be listed on a particular date and he has to be heard in the matter. Then you pass your orders. You cannot say that there is no opportunity of hearing required to be given or not applicable. You
That
stop
opportunity, my
giving
lord,
you
has not been
opportunity now.
My lord, the issue, my lord, is that they do not disclose who the trustee is or the office bearer of the.
Whatever it is, you have to hear them and pass an order. You can't, you have decided by yourself, is it, that he is wrong?
Based on what they have of course raised, my lord. They have filed a petition in which, my lord, they have urged all these grounds, which has been considered.
Your Honor,
And then, my lord, the order is passed.
Your Honor, the points raised.
Good Shrikant accepts notice. Has filed Wakalatnama prior to issuance of notice. He accepts notice for respond number 1 to 3. Petitioner is before this court seeking for the following leaves. The main ground on which the petition is based is that there is a violation of the principle of national justice. In that regard, the learned counsel for the petitioner relies on the last sentence in para 6 of the impugned order at annexure A, which reads as under page 19. On inquiry, the learned counsel for the respondent as to whether a hearing had been provided to the petitioner, the learned counsel fairly submits that the grounds raised in the revision petition have been considered along with the document which have been filed. That, in the considered opinion of this court, would not comply with the requirements of the principle of natural justice. A hearing is required to, a revision petition having been filed, a adjudicatory order having been passed by a quasi-judicial authority, it is but required that before such an order is passed, the affected party is heard and the principles of audio alteram partem are complied with. The same not having been complied with, this court passes the following order. Writ petitions are allowed. The
One humble submission, Your Honor. The point raised in the order number 2 stating that the association has not applied for change of committee members for addition of Jason George and deletion of Jason M. George.
we are not the revision authority. You place your arguments there, they will hear you. The order date 10/3/25 passed by respondent number 3 at annexure A is set aside, the matter is remitted to respond number 3 for fresh consideration. The petitioner shall appear before respond number 3 without requirement of any notice on any particular day they sit or every day,
No particular date, my lord. Any date may be given then according to it.
without requirement of any notice on 10th September at 2:30 p.m. when respond number 3 shall provide an opportunity of hearing to the petitioner. Petitioner is also permitted liberty to file his written submissions in the said matter, which could be considered by a respondent and orders passed in accordance with law.
Much obliged, Your Honor. Serial number 5, C.R. Ravi Shankar.
Yes, Ravi Shankar. Yes.
This is the petition filed by the insurance company
Hmm.
on the ground that we have let the evidence on the toll plaza because that vehicle was not traveled on the toll plaza.
Hmm.
After this one petitioner claimants are fixed the vehicle and we have summoned to the toll plaza manager and deposed before the court and certificate is also filed. In spite of that, the tribunal has not believing that the toll plaza CCTV footage and other things, Your Lordship. It straight away rejected the
Which is the impugned order? Page number?
impugned order, that is rejection, Your Lordship.
Page number?
Page number, Your Lordship. Page number 41, Your Lordship.
The matter was posted for arguments.
Arguments and summons also is issued. You have filed the application as per the rules and regulations. They have produced the CCTV footage and he only come before the court and give the evidence, filing the certificate and everything. You must, judge wants to, you bring that one, this one here, in day by day the urgent and because on the crucial factor of the case of the CCTV footage only, because vehicle was not traveled in that toll plaza. He has fixed that vehicle and grabbed the amount from the insurance company. So Lordship well aware about nowadays, they are fixing the vehicle of that way, that type of the
We are not
grabbing
aware
the
of anything. What is the order which has been certified?
order, that is the rejection of the 63, Lordship. That is the certificate itself is rejected.
Where is the certificate?
Certificate is, Your Lordship can see in the page number 58. ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅದ್ರಿಂದ ಅವ್ರನ್ನೇ ಕರ್ಕೊಂಬಂದಿ ನಾವು ವಿ ಆರ್ ನಾಟ್ ಬಿಕಾಸ್ ಸಮನ್ಸ್ ಪ್ರಕಾರನೇ ಮಾಡಿದ್ದೀವಿ ಯಾರ್ ಗೈಡ್ಲೈನ್ಸ್ ಆಫ್ ದಿ BSL ಹಂಗೆ ಮಾಡೋದು ಸರ್ಟಿಫಿಕೇಟ್ ಇದು ಮಾಡಿ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾನೆ ಈ ಓನ್ಲಿ ಅದು ಹೆದರ್ಕೊಂಡು ಈ ಕ್ವಶನ್ ಮ್ಯಾನ್ ಗೆಟ್ ಓನ್ಲಿ ಪುಟಿಂಗ್ ದಿ ಸಬ್ ಅದರ್ ಕ್ವಶನ್ಸ್ ಟು ದಿ ವಿಟ್ನೆಸಸ್ ಹೆಲ್ಪ್ ಮಾಡಲಿ ಬಟ್ ಕ್ಲೈಮೆಂಟ್ಸಿಗೆ ಹೆಲ್ಪ್ ಮಾಡ್ತೀನಿ ಅಂತ ನಮ್ಮ ವೆಹಿಕಲ್ಗಳು ಫಿಕ್ಸ್ ಮಾಡಿ it is not norms ಅಂತ straight away dismissing the certificate. Evidence also led in by the witness through insurance company, that is the toll plaza manager. Date ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಡೇಟು ಟೈಮು ಎಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ. Accident occurred on the day of after the 5:30.
Issue notice to respondents returnable by 5th October, considering that there are no reasons made out by the trial court as to why the certificate under section 63 4C of the Bharatiya Sakshya Adhiniyam 2023 is not in accordance with the said provision. When to this court expressly it appears to be so, the further proceedings in MVC number 1556 of 2024, pending on the file of the district judge and MACT at Tumkuru, is stayed till the next date.
Yes, Your Lordship.
Process fee and copies to be furnished by end of day 28th August 2026, failing which the interim order will stand automatically vacated. Counsel for the petitioner is also directed to furnish serve the counsel for the respondents before the MACT and final acknowledgement with the registry on or before 10 September 2026, failing which the interim order will stand automatically.
I will do it, Lordship.
Serial number 6, KB Narayan Swamy.
Petitioner in this case. Petitioner made representation before the sub-petitioner, madam. These are the final decree proceedings. This is final decree, madam. The respondent issued endorsement, madam. 11 sketch will produce them. Endorsement issued annexed A. Food for partition filed with petitioner, food for decree.
Your registration will not identify the property, you will not claim anything as regards the identity or location of the property.
Final decree also.
Final decree, I agree. But you won't find you won't say that this is the location of the property and approach any of the authorities. And AGA accepts notice for respondent 1 to 3. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the respondents have not registered the final decree drawn up in FDP number 1 of 2012 by the second additional civil judge in JMFC at Kanakpura on the ground that the Lebanese sketch had not been produced along with. This court in, what is that order? Division bench order and
Division bench order.
this court and so and so has said that when a court decree is passed, there would be no requirement for production of Lebanese sketch. Then AGA would however contend that since the property has not been identified and the survey numbers and Fodi and Durasti as regard the said survey numbers not having carried out, if the registration is made, there could be a possibility of further litigation arising thereto and claims being made against sub-register and or the revenue authorities as regards such registration. Learned counsel for the petitioner would submit that the petitioner is only seeking for registration of the final decree, and as per the decree drawn up, the petitioner will not hold any of the respondent officers responsible as regards the extent or the location of the property. The said submission of the learned counsel for the petitioner answers the apprehension on part of the learned AGA. In that view of the matter, this court passes the following order. Writ petition is allowed. The endorsement bearing number so and so at annexure A is quashed. Respondent number 3 is directed to register the final decree issued by the second additional civil judge in JMFC at Kanakpura in FTP number 1 of 2012 within a period of 30 days from the date of receipt of a copy of this order in terms of the undertaking and submission made by learned counsel for the petitioner. The above registration shall however be subject to the result of the appeal pending before the Honorable Apex Court in SLP number.
I'll play it.
One word.
Serial number 7. Ashoka.
Paying for petition laws in this case, seeking for registration of FIR.
You speak loudly.
Please, my lord. Seeking for registration of FIR, my lord.
What is the complaint alleged?
My lord.
What is the complaint? What are the allegations?
The facts are, my lord, that respondent number 5 approaches me for purchasing of the property, my lord, for a sum of rupees 15 crores rupees, which I, my lord, agree. Thereafter, my lord, he takes Xerox copies of my sale deeds and khatas and everything. Then, my lord, after a period of 6 months, my lord, suddenly I receive certain cash amount in my bank. Upon verification, my lord, I find that this respondent number 5 has deposited it. And then I receive a summons from civil court for a specific suit for specific performance. In that, my lord, there is a sale agreement and token as one receipt. My signature is not at all there in that, my lord. It is a forged signature. Taking that by a shock, my lord, I approached jurisdictional police station filing a complaint. Police does not.
Civil suit which is pending. You can always raise all these issues there.
But, my lord, my signature is forged. He has to be, my lord.
Ask the court for reference to the Forensic Science Laboratory. There's already a civil suit pending. How can you convert a pending civil suit to a criminal proceeding?
The forging of signature, my lord, is a criminal aspect.
That is the allegation. File an application. If the FSL gives a report that it is so, then the question of that will come. Don't do the criminal. There's already a suit pending. That will be a ground for 482 quashing.
Page 57, endorsement is also issued.
And AGA for respond number 1 to 4. Notice to respond number 5 and 6 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reasons. The grievance of the petitioner is that the respondents, official respondents, have not registered an FIR in pursuit of the complaint submitted by the petitioner on 17/3/2026, and it is in that background that the aforesaid relief has been sought for. Learned counsel for the petitioner submit that respondent number 5 and 6 had approached the petitioners with the intention to purchase the property of the petitioners when photocopies of these documents had been furnished. Subsequently, petitioner received summons in OS number 319 of 2026 filed by respondent number 5 for specific performance before the senior civil judge and JMFC Anekal of an alleged agreement of sale dated 18/1/26. Learned counsel for the petitioner submit that the petitioners have not signed the said agreement of sale and the signature found thereon are forged, and in that background that the complaint was submitted. Since a civil suit is already pending in OS number 319 of 2026, the petitioner can always agitate the defenses therein and even get the document referred for examination to a forensic science laboratory. If a report is received from the FSL, then necessary action could be taken by the petitioner. Today, at this stage, when OS number 319 of 26 is pending, which indicates a civil dispute, the question of registering of a criminal complaint would not arise, reserving liberty to the petitioner to file a complaint after obtaining necessary orders in the said suit in OS number 319 of 2026. The petition stands disposed.
One other submission was this I filed this petition, my lord, during when the jurisdictional magistrate has sought a show cause notice. Why not the police have registered the FIR? Challenging which I have approached this court, my lord. Now it was argued and the matter is posted for orders on 5th of coming month, my lord. That should not.
Sure. Next.
Number 8, Siddharth Suman.
Not practicing advocate before this honorable court, my lord.
Don't say that everybody is the same.
Please, I'm not either way, my lord. Just to, as a background is so far as the petition is concerned.
Yes.
Now, there's a complaint which is filed, my lord, in CCB Chennai in 2024. Now, the allegation insofar as the complaint is concerned, my lord, is that there was a property which was mortgaged to Andhra Bank.
You filed this in Chennai.
My lord, may I just, I'll just convince my lord, because the entire transaction, whatever they say, my lord, is all here. It's in Bengaluru.
Mr. Counsel, if they had come here and investigated here without their permission, we would intervene.
Please.
Now they've asked you to go there.
My lord, now what I'm only saying, my lord, I'll go there. I have no problem at all.
Go there.
I'll go there. I'm only saying, my lord, let them not take any course of action against me.
We don't
because
have
I'm
jurisdiction.
May I just?
We don't have jurisdiction over the.
My lord, this was subject matter to a settlement in Lok Adalat before this honorable court's jurisdiction, my lord.
You are asking for action to be taken against the state of Tamil Nadu.
Please.
An order to be passed against the Secretary Home Department of the state of Tamil Nadu.
Please, please.
Over actions which they have not done in the state of Karnataka.
My lord, may I just take, my lord, why I would say, my lord, Karnataka has jurisdiction.
Where people have come out inside the state of Karnataka and taken action.
They
yes,
want
to
they want to arrest me here, my lord. They want to arrest me. That is why.
Where is that?
My lords, may kindly see. If my lords were to kindly see Annexure F, page 61, my lord. I had filed a recall. There was an arrest warrant which was issued, my lord, in Chennai. I sought for a recall. Recall was dismissed on maintainability, my lord, saying that there's no question of reviewing your own order. Now, my lord, they want to arrest me here. My residence is here.
Please don't be doing this swinging on both the boats.
I'm sorry, my lord.
If they have to be arrested, they'll be arrested through the jurisdictional police.
Please.
That they can always do.
Please. No, my lord, only.
If there's an arrest warrant issued by any court across the country, it can be enforced.
I understand, my lord. I'm only saying, my lord, insofar as the offense which is alleged, I'm not even named in the complaint. The only allegation against me is that, my lord, as a counsel, there is some
There is
amount
an
which is
order
transferred
passed
to my
in the year
brother.
2026.
2026, my lord.
On 13 July 26.
Please, please.
Last 1 month you have been.
My lord, I have been running around, nothing else, my lord.
In the wrong place.
I'm only.
Go to the
Lord,
right place.
The only limited, my lord, my prayer before this honorable court is that let them not arrest me, my lord.
Petitioner.
No course of action to be taken, nothing else. I'll cooperate with the investigation.
None
I've
can
already said
accept.
that.
None can accept notice on behalf of respondent number 1 and 2 since they are located. They are officers and/or departments of the state of Tamil Nadu. The petitioner is before this court seeking for the following leaves. The only reason why the above petition has been filed, both as a main prayer and as a interim prayer, is for directions to the respondent not to take precipitative or coercive steps against the petitioner.
That is it.
The main prayer and the interim prayer being one and the same. the reliefs cannot be granted by this court in view of the decision of the Honorable Apex Court in Cotton Corporation of India versus so and so 1982 AC 1272, AR 1982 AC 1272. Be that as it may, it is also required for the petitioner to have approached the jurisdictional court and not this court, which has no jurisdiction over respondent number 1 and 2. More so when respondent number 1 and 2 have not taken any action or done anything within the state of Karnataka that is within the jurisdiction of this court. The reserving liberty to the petitioner to approach the jurisdictional court, the petition stands disposed. Please.
Serial number 9.
Now we know why you started with that first line.
Because there's no role attributed to him, my lord, but then.
Go before the proper court.
Please, please.
Kiran Kumar.
Hearing for petition on this case law. But challenging the Annex J, the endorsement issued by the Forest Department, refused to renew the license in my name. Earlier it was in my father's name, the fifth respondent.
And AGA accepts notice for respondent number 1 to 4, issue emergent notice to respondent number 5, returnable by 29th September.
Serial number 10.
Petitioner is a borrower, my lord, his property is auctioned, amount is recovered, but they're not issuing, my lord, the no due certificate and deed of discharge. Earlier, my lord, the originals were not given to us, my lord, the item was issued at
State
annex.
Bank of India.
Please.
Vignesh Shetty.
Shri Vignesh Shetty is directed to accept notice for respondent, counsel for the petition. Furnish 2 sets of the petition along with annexure on the said counsel. Mr. Vignesh Shetty is directed to obtain instruction, make a submission as regard the prayers which have been sought for, released on 17th September.
Please.
Serial number 11.
Yes, Mr. Korea.
Challenges to the lookout circular, my lords.
Lookout.
In fact, we had filed this primarily, my lords, for compliance with the bail order. The bail was granted on 7/8, my lords. 19/8, we filed this petition. The bail number 3 and 4, who are petition number 1 and 2, and accused number 6 and 8. Incidentally, my lords, as far as petitioners 3 and 4 are concerned, who are accused 6 and 8, they have been charge sheeted, they have complied with the bail orders, and they have as well returned to their native. So we wouldn't want to press the petition as far as petition number 3 and 4 are concerned. Now, as far as petition number 1 and 2 are concerned, they have now been incidentally left out of the charge sheet, my lords. They are no more accused in the case itself. However, the lookout circular against them subsists.
One and 2. What is the status as regards accused number 1 and
Accused number
petitioner
3
1
and
and 2?
4.
Petition number 1 and 2.
They have been left out of the charge sheet, my lords.
They have been left out of
Please,
the charge.
the charge sheet was filed on 20th of August, whereas we had filed this petition on
State
19th.
agency, the originating.
I'll take notice and get instructions. I'll have to verify, my lord, whether they've been removed from the charge sheet. They say they've been removed from the charge sheet. I'll have to verify that.
That's what we have directed in the other matter also. If you have removed or no charge sheet has been filed,
There's no-
immediately instruction have to go to the authorities.
Please, my lord. Please.
You cannot keep a LOC alive.
Lordship may have this tomorrow, my lord.
Tomorrow they have to travel to tomorrow's Raksha Bandhan. They are residents of Delhi, my lords. But I seek for a stay, my lords.
So why did you come today? You could have come after Raksha Bandhan.
So
So there was no protection required.
we wanted initial compliance for that. At that stage, we had
The
appeared.
third accepts notice for respond number 1 and AGA for respond number 2. The submission of Shri Amar Kurial and counsel for the petitioner is that respond number 3 and petitioner number 3 and 4 have complied with the bail requirements, and therefore
there is no LOC against them.
There is no LOC which can be said to be pending against respond number petition number 3 and 4. Insofar as petition number 1 and 2 are concerned, the submission is that they have been left out of the
Of the
charge
charge
sheet,
sheet,
and
please.
there is no charge sheet which has been laid against petition number 1 and 2. And AGA, get it by afternoon.
I'll get it by afternoon. Please, please.
Seeks for a short accommodation to pass over.
Please, oblige.
Serial number 12, Arjan, 13. Govind Rajuke.
And for the petitioner in this case, my lord, I'm challenging the execution proceedings initiated against me in the consumer complaint, my lord. In this case, my lord, I resigned from the directorship on 6/10/2023 That was accepted, my lord. That's in annexure F, my lord, page 58. Subsequently, they have initiated consumer complaint. Consumer court directed to jointly and severally liable to pay a fixed deposit amount, my lord. In similar circumstances, my lord, in annexure G, in the same court, my lord, in other case, I filed a resignation copy and that was accepted and dismissed against me, my lord.
Have you filed it in this execution proceedings?
Sorry, my lord.
Execution proceeding file
I stated, they have filed execution proceedings. I have stated that this resignation.
In that other matter, you have filed.
In consumer complaint itself, I have filed, my lord. In this case, that was not served to me because address shown in the society.
You place it before the execution court, only
Executing court, I have submitted the resignation letter. This is the same court, my lord. But already passed the award in consumer court. They are not entertained, my lord. Issued arrest warrant against me also, my lord. That's the proceedings I have initiated. And
You were not served, you did not appear.
yes, my lord.
So you have to file an appeal.
Appeal, my lord, when I asked, we have to deposit 50% of the amount, my lord.
You can always
Jointly
ask for
severally.
the waiver.
But several depositors are there, my lord.
You can ask for waiver also.
No, my lord, there's no provision available. I asked there, my lord. Therefore, in
Allah,
similar
no.
circumstances, this court has passed
Look
the
at the
order.
law, don't ask somebody. When you can make that application, you have to look at it. What is the purpose in staying this here? Because nothing we are going to adjudicate in this matter.
My lord, they have to take action against the society, my lord. There is some.
Can we set aside
members?
the order passed by the district commission, district forum? That is not the subject matter of order remains. This order is valid.
This court in another case, my lord, against the person state that, my lord,
Tell me
annexure
there.
J, my lord.
Page?
Annexure J, my lord.
Page?
Page 108. That another director.
In view of issue notice to respondents returnable by 29 September in view of the order dated 26 March 26 passed by a coordinate bench of this court and on the ground of parity, the further proceedings in execution application number 76 of 2025 pending on the file of Udupi District Consumer Dispute Redressal Commission is stayed till the next date of hearing. Connect the above matter with WP 9307 of 2026. ಇನ್ನೇನಾದ್ರು connected matters ಇದಾವ?
ಇದೆ, my lord.
ಕೊಡಿ ನಂಬರ್ ಎಲ್ಲ ಕೊಡಿ.
Serial number 15 also is there, my lord. Same.
26685 of 26.
I will pass.
ಬಾಕಿ ಇನ್ನೇನಾದ್ರು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ, I will pass.
Numbers ಕೊಡಿ.
And
So and so.
notice to the 3 to 10 may be dispensed with.
Why?
They are the other directors, my lord.
They are
not
your
the-
friends, so get them. Process fee and copies to be furnished by end of day 28th August 2026, failing which the interim order will stand automatically vacated. Counsel for the petitioner to also serve a copy of the petition along with annexures on the counsel for the respondents who have appeared in the execution proceedings and file an acknowledgement thereof by end of day 11th September, failing which the interim order will stand automatically vacated.
14, Sumanth L. Bharadwaj.
Petitioner seeking mandamus to consider representation. Annexure A is the representation submitted to the respondents, my lords. The tender is for lifting of scrap materials. There's a shortfall to an extent of 64 kgs and odd, my
So you
lords.
file a writ petition for this?
To consider my representation, my lords, the response has stake within the meaning of Article 12.
That is not what your prayer is not for considering the,
My lords,
your prayer is something else.
my prayer is, my lords, by considering the representation, my lords.
It requires trial. And AJ for respond number 1, KUW SND,
Sumangala Gachinamat.
Sumangla Gachinmat for respond number 225, counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel, released on 10th September.
Serial number 15, same, 13.
Same order, 15, same order as 13.
Serial number 16,
Post before a bench of which SGRJ is not a party. Not before us.
17.
May I make one request otherwise. Monday, if your lordships can direct the
You
register.
can't give a date, it has to go before the chief. Your
I
client
know.
should have told you. It can't be taken up by a
Urgency was there, some urgency was there.
Tell your client, he should have told you.
I'm sorry.
17. Ankur Tripathi.
Yes.
Proxy counsel, the council on record has had a family emergency. Have we given any date, my lords?
What is this matter?
The challenge on the RERA order, my lord.
Appellate authority or
My lord,
adjudicatory authority?
my lord, by the authority, my lord.
By the authority. There is appeal available.
Oh, yes, my lord. It cannot be entertained.
The council on record is not well.
We'll give you time because of that, but please tell him also that it's not.
Please.
K. Rajshekar for respond number 1. You appear for whom, Pradeep?
There are two, my lord.
For respond number 2. What about the others? 3, 2,
Private
3, 4, 5, 6.
There are private respondents, the landlords and. Lordship, there is a CBI order. A Supreme Court has ordered the CBI to inquire on this project.
Next level.
Lordship, this is a project where my lord.
Fund capital, CF, asset, Acre. P. Raman Lerama.
J.M. Patil.
J. Patil for 12. State Bank of India.
Vignesh Shetty.
Vignesh Shetty for 13. Yes Bank.
Francis Xavier.
Francis Xavier for 14. PNB.
Francis Xavier.
Francis Xavier. India Infoline Housing Finance Limited. No, anybody who will appear for all these people?
I'm not, my lord, I'll.
As a request of counsel for the petitioner relist on 3rd September.
18. Latif B.
Latif.
The petitioner is the Waqf institution, Lord. It was registered under the Waqf as per Annexure A. And subsequently, in the year 2025, Lord, they adopted scheme of administration. In the year 2025, Lord, the annual general body meeting was held and a committee was, self-styled committee was constituted without holding a selection or election. Then, Lord, the Waqf board has directed to hold a election or selection and issued notice to the management committee, the self-styled committee. They did not convey and there was a law and order issue. They left the place. And the self-styled committee has continued for a year, which was constituted in the year 25. Now the term has been expired. Now we sought, Lord, for election or selection. A confidential election should be held. Then, Lord, now the notice has been issued to hold a, without issuing any calendar of events or anything. They decided to hold a general body meeting to constitute a committee. Without, as per the scheme of administration, the electoral list has to be published.
You have adopted the model bylaws.
Yes, Lord.
Model bylaws, this is what is provided.
They directly,
Work
they,
of Form 52. Model
42,
bylaws.
42.
42. Model
Please.
bylaws.
Once a scheme of administration was followed, the chapter 5 mandates on the general body meeting, they can select or elect. We given a representation, the confidential election should be held. Now, without the calendar of elements or the electoral list, publishing any event list
It's not
directly.
required. The scheme does not contemplate a calendar of events.
Yes.
Really, of course.
The chapter 10, Lord.
40.
Chapter 8, Lord, of the scheme of administration. I'll pass.
Chapter 8 of the model bylaws.
Please.
Chapter 8.
Chapter 8. First is the electoral list they have to prepare.
Yes.
Then eligible voters list and procedure of election, calendar of events at
It is
para.
not selected by consensus. First, the process is that the general body meeting has to be, general body of the Waqf.
In that, Lord, the chapter 5 says the general body meeting they can select or elect.
Correct. First is selection.
Two options. If prefers.
Selection does not happen by consensus.
Yes.
Then election.
Please.
Now first election is happening on 28th. If it doesn't happen that day, election, not, you can't
He
say.
given a representation for to hold a election. The kindly see chapter 4, 5, Lord.
Please see chapter 8 applies
Please.
only in case where the Manning committee is not selected by council. We have dealt with it in a detailed order.
Yes. Now they decided to hold a selection. We are objecting that the last time also the similar selection was held and there was no unanimity was happened and self-praise committee was constituted. Then Waqf Board itself issued a notice, do the election. That was the annexure
Just
G.
because you don't want to participate in selection doesn't mean selection should not go on.
Lord, there was a problem in the committee. They were did not
P. Usman
list
for
itself
respond
is
number 1 and 2. Respond number 3, what, there's a caretaker right now?
no. The self-praise committee itself is continuing.
Issue notice to respond number 3, returnable by 22nd September. Council for the petitioner is also permitted to record and summons on respond number 3.
But tomorrow, if they held the election
Not
selection, Lord, it will come in the way.
Of 26 is allowed. Will not come
Subject
in
to
the way of selection.
result of the writ petition. If any, the committee has constituted.
You want to participate, please participate. You can't hold the body to ransom
Let
by
them,
your non-participation.
let them do the election or selection, Lord, subject to the
It's
result.
made clear that the petitioner is free to participate in the selection process. If the petitioner were not to participate in the selection process, will not be entitled to consideration of any equities. Next.
Subject to result, Lord.
Not at all.
Venkatesh P. Dadwal.
The petitioner is a school. Initially, the fire safety standards were to be renewable up to 2 years, Mallards. Every 2 years they had to do it. Now, contrary to the orders, Mallards, and regulation, now they have reduced it to, extended up to 5 years. But so far as this fire equipment, Mallards, the safety equipment would lapse within 6 months to 2 years. I have produced the Mallards, Indian Bureau of Standards regulations. And for a high-rise building, my lord, the lordships have considered and granted interim order. So far as the buildings up to 21 meters, now, my lords, the renewal certificate is expected to be taken at 5 years instead of 2 years. Yeah, now
Still the difference in 5 years and 2 years?
My lord, your lordship would annexure F, the notification.
Page?
Page, my lords, page 52.
52.
52.
Yes.
Serial number 1. Once in every 2 years shall be read as once in 5 years. The equipments and the other material mallards for extinguishing fire would expire within 6 months to 1 year, my lord. This is a Bureau of Standards.
Who are you?
I'm the school, my lord. I run a school.
You want to take it every 2 years?
Every 2 years. It has to be applicable to everybody, my lord. And the lordships have granted interim, my lords, in the companion matter.
This is it a public interest litigation?
No, my lord. I am also personally aggrieved because I run a school. I have to take a permission after every 5 years.
You are not aggrieved.
No, my lord.
You want to do it in 2 years. They are saying 5 years.
My lord, even accepting that, my lord, I cannot do it in 2 years because there is no provision of law. Now, if lordships kindly consider that way also. If I want to renew it every 2 years, there is no provision at all. Now I have to go back to them only after 5 years. By that time, my equipments and everything, every safety measurement would have lapsed. These are all the chemicals, my lords, which are stored to extinguish the fire. And the third-party inspections are carried out by private parties, not by the respondents. Everything they have outsourced. My lord would kindly see the
Where is the government order of government notification 77/2011 original notification which has been amended?
My lord, that I would point out. But page 56 would refer to that, annexure H.
Refer, yes. Where is the original of? Where is the?
They issue a corrigendum, my lord. They issue a corrigendum.
Where is the original of?
Page 54, my lord.
77/2011.
I think.
Is it 24 to 26?
Page 48.
48.
48. My lord would kindly turn to clause 5, page 49. Last two lines. Once in every 2 years. Now, this came to be issued after, my lords, the public interest litigation, suo motu proceedings were taken up with the Honorable Division Bench at Annexure D. Where, my lord, they come back with the notification which I am referring to at Annexure E, page 48. This was a after, my lord, this infamous Carton House fire tragedy. Then, my lord, after Annexure D, my lord, government issues a notification 77/2011, where they say clause 5 that everything has to be renewed for 2 years. Now, this they issue a corrigendum, which I tried to point out, your lordships, at page 52, Annexure F.
And AGA for respond number 1 and 2. Who accepts? And AGA is direct secure instruction as to what is the basis of amending the requirement of obtaining a fire clearance by reducing by increasing the period from 2 years to 5 years. So the submission made by Shri Venkatesh Dalwai, learned counsel for the petitioner, is that many of the firefighting equipment in terms of chemicals would have expired within that during the period of 5 years. And most of them have a shelf life of just about 2 years. The affidavit in that regard to be filed by the second respondent. You have not made them a party, fire services, Director General.
I'm sorry.
Being of the considered opinion that, Ian, what is the name of the office? Director General, Fire Services.
Director General, Karnataka State Emergency Services.
The Director General, Karnataka State Fire and Emergency Services is required to be brought on record as party respondent. He is brought on record as respondent number 3, learned AG accept notice for respondent number 3. And affidavit in that regard to be filed by second and third respondent. Relist on 7th September.
It may be posted along with this
Connect with WP number
11977 of 26.
Carry out the amendment.
Yes. Lords, interim.
Interim order.
No, let them not implement this. That's the order passed by in the coordinate. Same order, your lordship.
Stay of annexure.
Stay of annexure H.
Same interim order as well.
Yes. Kindly permit me to carry out amendment.
Please.
PB Raju.
Yes, Mr. Raju.
The third respondent would enter into an agreement of sale with the petitioner number 3 on 7/6/2013. He claims himself to be a person of a weaker section. But he would file a suit for specific performance. But before the notice is served, I am petitioner 1 and 2, I am a bona fide purchaser. He then would petition the commission, SCST commission. The commission acting under section 10 would annul the sale deed of my sale deed and would direct the sub-registrar to execute a sale deed in his favor.
Where is that order?
My order is Annexure A, page 16. The operative portion is.
Your SCST commission, H. Chandramohan for respond number 1 and AGA for respond number 2 issue emergent notice to respond number 3 written by 29th September. Considering that the first respondent has only advisory power and does not have any power to issue any directions to state authorities, including the sub-registrar. as held by this court in WP number so and so.
I have mentioned W.
The operation of the order dated 23/7/2026 passed by the first respondent in case number 58 of 2026 at Annexure A is stayed till the next date of hearing. The member secretary of respondent number 1 is directed to file an affidavit as to how respondent number 1 is exercising jurisdiction over civil disputes between parties merely on the ground that one of the parties belongs to the scheduled caste or scheduled tribes category. Process fee and copies by end of day 28, failing which interim order is signed.
21, yes, Rajshekar.
Date can be fixed.
I appeal for petitioner, my lords.
Date can be fixed.
Date ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ.
29.
29.
Kindly go to page 57, my lords earlier order, directing the authorities to, my lords, consider and take appropriate action, which operative portion of the order is at page 62. They don't do anything, my lords, resulting in I file contempt proceedings. Lords, for having initiated contempt proceedings, my lords, now they have issued Annexure A, calling for, my lords, fresh application for, my lords, appointment of committee of management, instead of adhering to the directions issued by my lords, which is at page 22, Annexure A. That is under challenge now, my lords. They don't do anything with regard to, my lords, earlier applications filed by us in the year 2023. They obtain report from the competent authority.
Yes, madam.
Lordships, previously, my lord, 6/11/23 notification was challenged. Lord,
No, that representation have you passed any order?
that I have to seek instructions, my lord.
No
whether
order has
that-
been passed.
Passing any order, again you issue one more notification.
Now, my lord, the term is only for 3 years, my lord.
Committee is not yet constituted.
I'll seek instructions.
And AGA for respond number
1 to 3,
1 to 3. 4 is administrator. 1 to 4.
4.
She seeks for and is granted a week's time to obtain instruction as to whether any order has been passed on the representation as directed by this court on 3rd November 2025 in writ petition number 31740 of 2024. And if no order has been passed, how Annexure A has been issued. The operation of Annexure A is so and so is stayed till the next date of hearing, released on 3rd September.
My lord, may seek a pass over at least, my lord,
Pass
whether the application was considered.
Better pass over.
Please.
22,
A 1 of 26 is allowed.
Rohit Kawat.
Lordships, appearing for the petitioner, if I may just run your lordships through the fact in brief. Your lordships, this particular matter arises on account of the death of the father of the petitioner, who was the backbone of the respondent number 3 company, which is currently under strike off, your lordships. The company was struck off by an order dated 21/8/2018, your lordships, which is marked at Annexure D, page number 28. Your lordships, if I may just run your lordships through provision section 248 of the Companies Act.
How many directors were there?
Your lordship, there were 4 at the time. It's there at Annexure F at page number 32, your lordships.
How many directors were there? We'll go by what you say.
Indeed, your lordships. Your lordships, there were multiple directors, but however, it was the petitioner's father who was the backbone of the entire.
That cannot be a ground. That's why we asked you. The
Indeed,
other directors could have filed. 2 directors have to file it.
Your lordships, indeed, but however, they were not.
If there are
involved.
only 2 directors, one has expired, yes, we can agree with you.
Indeed.
They
lordships,
cannot
2
fire
directors-
from your shoulders.
Indeed, your lordship, 2 directors expired, but however, as on date today, it is the son who is currently.
How many directors are there?
Your lordships.
How many directors?
On the date of strike off, there were 4. 2 of them have expired. Currently, there are 2. Of which one is the son of the person who has already filed an application before NCLT. Annexure F1 has the.
You are
application-
fighting amongst yourselves.
Indeed, your lordships, some sort of inconvenience in that note. Your
Then
lordships, here-
ASGA is directed to accept notice for respond number 1 and 2. ROC also you will appear.
Indeed, your lordships. Your lordships, further, there is a small clarification, your lordships.
Served in this yearly.
Yes. Your lordship, Annexure H, there is a particular scheme called the CCFS scheme, which is a beneficial scheme which allows me to do all the compliances and rectify myself as a active company, your lordships.
When is the last date?
Last date is 31st of August, your lordships. I have approached before the NCLT in the month of June.
What does that scheme provide?
Your Lordship, it allows me it's called an amnesty scheme. So currently, as on date today, if I file it without the existence of amnesty scheme, my penalty comes to the tune of 46 lakh rupees.
This is a scheme.
Your Lordship, page number 127.
Just help Mark.
Particular aspect has
My lords, I was having some trouble being heard, my lords. I apologize.
Now we can hear you.
Yes, my lords. I I'll accept notice for respondents 1 and 2 in this matter, my lords. I've just received on behalf of Advocate Nayanthara BG.
Yes.
I'll accept notice, my lords, and
Yes.
the impugned order in this matter is 2018, my lords. So there's really no urgency for an interim relief or
Their
anything.
urgency is as regard the scheme lapsing on 31st of August. If you are
My
willing
lords,
to
it may
extend the scheme, then we won't grant them any interim order.
My lords, I've only received the papers I require.
Yeah, just
Instructions,
let
my
us
lord, a
hear him
short
for-
date may be given.
We haven't even issued notice. He's making a submission. Let us
Please,
see
my
if we
lords.
have to grant any order. Yes.
I apologize. I had difficulty being
No,
allowed
no
into the
problem.
courtroom.
We'll record your submission. Yes.
Your Lordship, at page number 129 of Annexure H is the
Mhm.
applicability of the scheme, Your Lordships. Now here on this, the reason why we are challenging the order that was dated 2018 was for twofold reasons, Your Lordships. One is under 248, if I may read the provision, Your Lordships. It says that there is a requirement under 248 1C that a 30-day notice period is required to be given, Your Lordships, before going ahead with an order for strike off.
That you are challenging after 8 years. That's
Indeed, Your Lordships. I'll come to that point, Your Lordships. Why I am challenging it as to the
The
particular.
submission was as regard the scheme.
Indeed, Your Lordships.
So what is it regarding the scheme that is time
Indeed, Your
sensitive?
At page number 129 is the application of the scheme, Your Lordships.
Hmm.
It says the scheme shall not be applicable against companies against which action of final notice for striking off under 248 of the Act has already been initiated by the registrar.
Hmm.
Now, if I look at it from the purpose of the scheme, I'm actually excluded from it, Your Lordships. And to be very honest, Your Lordships, I got to know that I was struck off only when I got a letter from the DIC of Kerala, which is marked at page number 31, Your Lordships.
Please tell us about
Indeed.
the scheme.
Your Lordships, indeed.
Now, it won't apply to if you've already been stuck off.
Indeed, Your Lordships.
So now you want to restore your position.
Indeed, Your Lordships. We have made the application before the NCLT in June of this year, Your Lordships. Once as I got to
From
know.
2018, anyway, there won't be any penalty liable to be paid by you.
But Your Lordships, if I want to revive myself, I have to make the filings. And if I am to make the filings, currently as on date today, my penalties come for the period of 8 years, which amounts to close to around 45 lakh rupees. But if I take the benefit of the scheme, I will be required to pay 4.5 lakh rupees. That is where the difference is about, Your Lordships. It's just about a matter of 40 lakhs. But however, when I have the bona fides to carry on the business, Your Lordships, I would like to cite the particular bona fides. One of the reasons why the company was taken across was to further the employment of the particular father of the petitioner. The father of the petitioner is more of the nature of an inventor, Your Lordships. At Annexure C, he has filed for certain patents, which is given at Annexure B at page number 26. Your Lordship, there are about 4 patents that he has applied, which are pertain to chemical and other particular aspects. On account of this, he was the only one who was actually involved in the entire thing of the business of the company, Your Lordships. At Annexure C at page number 27 is a.
When did he expire?
Your Lordship, he expired last month, Your Lordships. Last month, July.
That won't help you.
Indeed. Last month, July. Your Lordship, there is also.
Want to make a case on equity, you should make a proper case on equity.
Your Lordship, there is a page number
He did
27.
not do anything during his lifetime from
Page number 27, Your Lordship. If I may just bring your attention to page number 27, which is a health certificate given by Aster City, which says clearly that for the last 16 years, he's been having prolonged illness, Your Lordships. That is one of the particular reasons why he could not actively involve in the company and the particular affairs. That there is a 16 years gap, Your Lordships, over here.
Cannot grant you a interim order on that basis.
Your Lordship, just a particular last attempt on the impugned order itself, Your Lordships. If I may bring your Lordship's attention to the impugned order at page number 28. Your Lordship, the impugned order is dated 21/8/2018, Your Lordships. And it says that they draw reference to 2 notices. One is 23/6/2018 and a subsequent notice under which is 18 days, Your Lordships. Under 248 is the timeline that is required, Your Lordships. There's only about some 8 days that within which the subsequent notices have been
You're
issued.
speaking of 15 days after 8 years.
Indeed, Your Lordships. But however, Your Lordship, I got to know the delay and lashes is also explained in the petition, Your Lordships, as to the reason.
We tried to see if there's some equity which was there. There's no equity.
Your Lordships, the service of the
Nayantara
particular
accepts notice for respond number 1 and 2. What about respond number 3?
respondent number 3 is a company under strike of, Your Lordships. It cannot be represented adequately as such they've been placed on record.
Since respond number 3 has been struck off, nobody can represent respond number 3, hence notice is not issued. Madam, just find out if at least they can avail of this scheme.
I'll get back with
31st
instructions.
When is the
my lords.
last date?
31st of August, Your Lordships.
31st is Monday. 29th.
Taken on Monday, my lords.
No, Monday if we take it, they won't have time to file it. We will have it on Saturday. Saturday is a working day. Find out if they can at least avail of this pending, subject to the result of this writ petition, so that they can pay this 4.5 lakh of rupees and file the e-forms.
I'll
Subject to
get back.
result
I'll
of the
seek instructions and revert. my lords.
subject to result of the petition. If they fail in the first prayer, then they'll have to pay the entire
Precisely.
47 lakhs. But at least they don't miss the window of filing it, subject to result of the petition.
Please, my lords.
Just on Saturday.
Your Lordship, there are a list of citations which you have placed on record. We'll serve a copy as well to them.
So IA 1 or 26 is allowed.
Great.
Both of us are there.
ಅದ್ಯಾಕೆ ಇನ್ನ ಒಂದ್ ನಿಮಿಷ ಇತ್ತು
ಮತ್ತೆ ಬರ್ತಾರ ಸಾಹೇಬ್ ಶ್ರಮನ್ state is a party, no? State is a party.
Union of
What is this? This is your judgment, man. Where is the petition copy? So petition copy is not
ನಾನು
served.
ಏನು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ
Give me a copy of the petition and judgment.
ಪೆಟಿಷನ್ ಕಾಪಿ ನಾನು ಕೇಳಿಸ್ತೀನಿ
It's not in the AG's office, man. It's not complete.
They've received it for both.
ಸಾಯಂಕಾಲ ಟೈಮ್ ಅಲ್ಲ ಇವಾಗ ಕೊಡಲ್ಲ ಅದೇ ಇವಾಗ ಕೊಡಲ್ಲ ಸಾಯಂಕಾಲ ಕೊಡ್ತೇವೆ ಎಂಟ್ರಿ ಆಗುತ್ತೆ ಇಲ್ಲೆಲ್ಲ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಆಗುತ್ತೆ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇಲ್ಲಿ ಇವಾಗ ಅಲ್ಲ ಅಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನನಗೆ ಸಾಹೇಬ್ರು ಮುಂದೆ
No, ಇಲ್ಲ.
ಬೇಕೋ ಇವಾಗ್ಲೇ ಬೇಕಂತ ತಗೊಂಡೋಗಿ
No, anyway, I don't want to get on this, but see, it's not so. So do you have?
ಇಲ್ಲಿ ಮಾಡೋದು ಇದು ಆಫೀಸ್ ಅಲ್ಲಪ್ಪ ನೀವೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ ಅಲ್ಲಿ ಮಾಡಿ ಬರ್ಬೇಕು ಸಾಹೇಬ್ರು ಪರ್ಮಿಷನ್ ತಗೋಬೇಕು ಯಾಕಂದ್ರೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅದೇ ಬಂದ್ಬಿಟ್ಟಿರುತ್ತಲ್ವಾ ಇಲ್ಲಿ ಅಲ್ವಾ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಬಂದಿದೆ ಅಲ್ವಾ ಹೆಂಗ್ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀರಾ ಟೈಮ್ ತಗೊಂಡು ಮಾಡ್ಬೇಕು ಹೇಳಿ ಹೇಳ ಇನ್ನೊಂದ್ಸತಿ ಮೊಬೈಲ್ ತಗೋತಾ ಇಲ್ಲ ಶಶಿಕಾಂತ್ ಮೊಬೈಲ್ ನಂಬರು ಉಮಾಶಂಕರ್ ಅಲ್ಲಿದು ಇಲ್ಲ ಸೀಟಲ್ಲಿ ಇರ್ತಿದ್ದಾರೆ ಹಂಗೆ ಅದಕ್ಕೆ ಮಾಡಕ್ ಆಗಲ್ಲ ಏನ್ ಮಾಡ್ಲಿ ಫೋನ್ ಮಾಡ್ತೀನಿ ಇನ್ನೊಂದ್ಸತಿ ಮಾಡ್ತೀನಿ ಹಾ ಹೌದೌದು ನೋಡಿ ತಗೋತಾ ಇಲ್ಲ phone. ಏನ್ ಗೊತ್ತಾ ಇದೆಯಾ ಇವಾಗ ಅದ್ರಲ್ಲಿ ನಾಳೆ ಡೇಟ್ಸ್ ಇದಾವೆ ಫೈಲ್ಗೆ ಡೇಟ್ ಬಂದು ತೋರ್ಸಿದೀರ ಈ ಕೆಲಸ ಆಗ್ಬೇಕಲ್ಲ ತೋರ್ಸಿದ್ರೆ ಕೆಲಸ ಆಗೋದಂಗ ಆಗಲ್ವೇ ಫೈಲ್ ಎಂಡಾಸ್ ಆಗಲ್ವೇ ತೋರ್ಸಿದ ತಕ್ಷಣ ಕೆಲಸ ಆಗಂಗಿದ್ರೆ ಸುಮ್ಮನೆ ಆಗ್ತಿದ್ದೆ ನಾನು ತೋರ್ಸಿದ ತಕ್ಷಣ ಕೆಲಸ ಆಗಲ್ವೇ ಕೆಲಸ ತಾನೆ ಅದಕ್ಕೆ ತಾನೇ ಥರ್ಡ್ ಆಡ್ ಬೇಕು ಅಂತ ಕೇಳೋದು ಕೆಲಸ ಇದೆ ಅಂತ ತಾನೇ ಅಲ್ಲ ಇವಾಗ ಕೆಲಸ ಅವ್ರು ಕಳಿಸಿ ನೀವು ಕೊಡ್ತಿದ್ದೀರಾ ನೀವು ಅದೇನು ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ ಅವ್ರ ಮೇಲೆ ಯಾವ ಅವತ್ತೊಂದ್ ದಿನಾನು ಬಂದಿಲ್ಲ ಇವತ್ 3ನೇ ದಿನ ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಇದು ಫೈಲ್ ಅವ್ರು ಬರೆಯಕ್ ಆಗಲ್ಲ ಈಗ ಯಾಕಂದ್ರೆ ಈಚ್ ಅಂಡ್ ಎವ್ರಿ ಕೇಸ್ಗೆ ಡಿಸ್ಪ್ಲೇ ತೋರಿಸ್ಬೇಕು ಅವರು ಯಾಕೆಂದ್ರೆ ಅವಾಗೇ ಅಡ್ಮಿಟ್ ಕ್ಲಿಯರ್ ಆಗೋದು ಕೆಲಸ ಕೆಲಸ ಆಗ್ಬೇಕಲ್ಲಪ್ಪ. ಈಗ ಸಾಧತಲ್ಲಿ ನಾನು ಹುಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ, ಯಾರನ್ನಾದ್ರೂ ಕೂಡ್ಸಿ ಹೋಗಿ ಹುಡ್ಕೊಂಡು ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ. ಯಾರನ್ನಾದ್ರೂ ಕಳ್ಸಿ ಅವ್ರು ಮಾಡ್ಲಿ, ನಾನು ಹೋಗ್ಬಿಟ್ಟು ಬರ್ತೀನಿ, ಹುಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ, ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ಕೆಲಸ ಆಗ್ಬೇಕಲ್ಲ, ನೀವು ಮಾಡ್ತೀರಾ? ಇವಾಗ ಕೆಲಸ ಎಂತ ಮಾಡೋದು? ನಾನ್ ಯಾಕೆ ಕೊಡ್ಲಪ್ಪ ರೈಟಿಂಗ್? ನೀವು ತಾನೇ ಪೋಸ್ಟ್ ಮಾಡಿರೋದು, ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ನೀವು ಕೊಡ್ಬೇಕಲ್ವಾ? ನಾನ್ ಯಾಕೆ ಕೊಡ್ಲಿ? ಈಗ ಕೆಲಸ ಆಗ್ಬೇಕು ಅಂತ ತಾನೇನಪ್ಪ ನಾವು ಹ್ಯಾಂಡ್ಸ್ ಕೇಳೋದು.
2680 ಎಲ್ಲ
ಬೇರೆಯವ್ರನ್ನ ಕಳ್ಸಿ, ಕೆಲಸ ಮಾಡೋರ್ನ ಕಳ್ಸಿ. ಕೆಲಸ ಮಾಡೋರ್ನ ಕಳ್ಸಪ್ಪ. ಅವ್ರು ಯಾವಾಗ್ಲೂ ಅವ್ರನ್ನೇ ತೋರಿಸ್ತೀರಾ. ಅವತ್ತು ಇವತ್ತು 3ನೇ ದಿನ, ಅವತ್ತು ಅಷ್ಟೇ ರಾತ್ರಿ 10 ಗಂಟೆವರೆಗೂ ಬರ್ತಿದ್ದೀನಿ ಕಳಿಸಿಲ್ಲ. ಬರ್ದಿರಾ? ದಿನ ನಾನೇ ಇರ್ಬೇಕು ಅಂತಂದ್ರೆ ಆಗುತ್ತಾ? ಎಲ್ಲ ನಾನೇ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ ಆಗುತ್ತಾ? ಥರ್ಡ್ ಹ್ಯಾಂಡ್ ಯಾಕಿರೋದು? ಅವ್ರು ಯಾಕೆ ಬರಲ್ಲ? ಇದನ್ನೆಲ್ಲ ನೀವು ಪ್ರಶ್ನೆ ಮಾಡ್ಬೇಕು, ಕೇಳ್ಬೇಕು. ನಾನ್ ಕೊಡಲ್ಲ ರೈಟಿಂಗ್ ಅಲ್ಲಿ, ನೀವ್ ಯಾಕೆ ನನ್ನ ಈ ಬೋರ್ಡ್ಗೆ ಹಾಕ್ತೀರಾ? ಕೆಲಸ ಮಾಡೋರ್ನ ಹಾಕಿ, ಯಾರ್ಯಾರೋ ಹಾಕ್ಬಿಟ್ಟು ನೋಟ್ ಕೊಡು, ಕೆಲಸ ಮಾಡಲ್ಲ ಅಂತ. ನಾನ್ ಯಾಕೆ ಬರೀಲಿ? ಅಲ್ಲ, ನಾನ್ ಯಾಕೆ ಬರೀಲಪ್ಪ ನೋಟು? ನೀವು ಬರೀರಿ, ನೀವು ಬರೀರಿ. ಕೆಲಸ ಮಾಡ್ದಿರಾ ಇರೋರ್ನ ನೀವು ನೋಡ್ಬಿಟ್ಟು ನೀವು ಬರೀರಿ, ನಾನ್ ಯಾಕೆ ಕೊಡ್ತೀನಿ? ಈ ಕೆಲಸ ಆಗ್ಬೇಕಲ್ಲ, ಅದಕ್ಕೆಲ್ಲರೂ ವ್ಯವಸ್ಥೆ ಮಾಡಿ. ಬಂದ್ರು, ಇನ್ನೇನ್ ಮಾತಾಡಕ್ ಆಗಲ್ಲ. List 1, serial number 23.
23, I request for a PASO, my lord. PASO. Caste certificate matters. Jafar is appearing in those connected matters, my lord. PASO.
24. Kirti Krishna Reddy.
My lord, in this matter, I appear for the petitioner. The petitioner, my lord, is a builder, and my property happens to, my lord, be located in the foothills of Western Ghats, where there's a lot of streams. And for that reason, my lord, if your lordships will see page 29, my lord, I've produced a layout plan, which is my property is connected to the highway, but in between the highway and my property, there's a stream, there's a Kalway, for which I sought permission from the minor irrigation department to construct a culture bridge. That, my lord, your lordships will find at annexure C page 22.
22.
Please. I only showed the layout plan, my lord, so that your lordships could see how it's connected to the highway. But my permission, I mean, application for permission is at page 22, along with the culture design, the bridge culture design. This is dated, my lord, 17/10/25. I've sought for permission to build this along with the design of the bridge. They, my lord, give me this permission, my lord, at annexure D, page 25 on 24/10/2025.
Yes.
Now, my lord, this becomes important because here, what I'm challenging, my lord, annexure A, I'll point out. In annexure D, page 25, they give me the permission and they say that you can go ahead based on the design that I've provided. It is okay to construct this bridge. Last line, if your lordships will see, my lord, in page 25, that I'm allowed to construct this bridge, they say.
Yes.
Now, 24/10/25, 10 months later, they pass this notice. I understand it's an annexure A, page 14. Sorry, page 19, my lords.
This is 5th August 26.
Yes. 26 early, 5th August 26, they come up with this, they issue this notice to me saying that next page, if your lordships will see, my lord, page 20. It's for the very first time, my lord, that the assistant executive engineer says 156.734 cumex of water is flowing in this region. And therefore, my lord, I need to immediately stop with this construction. In my approval, when I gave my permission and everything, in annexure, what I pointed out, my lord, annexure D, there is no such mention. Shockingly, my lord.
Want your layout to be flooded?
No, not the layout to be flooded.
If you don't allow this kind of a flow of water, it will get flooded automatically.
No, 156.734 cumex of water is 1,56,000 lakh liters per second. That is how much water Karnataka releases to Kaveri. This is impossible. And yes, and And I understand this is a notice.
Where is this property located?
Chikmagalur, Western Ghats. There is rainfall, I understand, but I've taken precautions and I've constructed according to my design.
Accepts notice for respond number 1 to 4. He seeks for and is granted a week's time to obtain instruction, make a submission as regards the technical requirements indicated in Annexure A and the reasons for such requirements. Released on 3rd September.
Can I just make one submission, my lord?
Yes.
I'll just place on
I-126 is
record
allowed.
the photos. I've already constructed. It's constructed. Now they
If
are.
it is required, we'll demolish it. If it is not required, it will continue.
Yes, so in the
Memo with
meantime, now
document
without
is filed.
considering my no, they've issued me a notice and they said reply. I've replied also. Without considering that reply, I'll show my lordships that reply also. Lordships may see. Without considering my reply, they come in Annexure E. They come every day to the spot where the construction is going on and they say that stop it.
Construction is going on or completed?
It's underway. It's almost done. That's
Almost
why
done, stop it. Don't go continue the construction. It's not
there is no
completed.
water flow at all. If your lordships will see there is no water flow. My lord, even if there's little water flow, I understand.
Madam, it's not only now there are no rains. When there are rains, what will happen?
But that's what my lord.
Half of
156
Bangalore gets
cumecs of
submerged
water.
because of that.
156 points
Half of
is
Bangalore gets submerged because of those things. And then everybody screams that there is a water logging. Don't, because you do this kind of thing, it will happen. Let them get back. Petitioner is restrained from putting up construction of the culvert till the next date of hearing. Respondents are restrained from carrying out any demolition of the constructed culvert till next date. Both the things, maintenance status.
grateful, my lord.
25, Sidappa VD and connected matter.
For the petitioner. But there are two connected matters. This is only with regards to 25.1, your lords. Because the parties are up for settlement. The other
25.1?
One. In this, there are two connected matters, 25 and 25.1, your lords. 25.1, we are here before your lordship for the settlement. 25 talks are still ongoing, your lords.
Talks are still
Please.
25.1, Kodi?
Matter is amicably settled among the parties. Have settled among the settlement has been arrived by the party.
Filing the
Senior Citizen Act.
Please, your lords, please.
Between the mother and the daughter.
Please, your lords, please.
The petitioner in the other matter is another daughter.
Please, your lords, please.
She is another daughter.
What is the order passed by the tribunal?
They have stayed the gift deed, your lords.
To cancel the 3 gift deeds. What is the settlement now arrived?
10 lakhs, your lords.
What is the value of the property?
It is around 50 lakhs, your lords. It is around 50 lakhs, your lords.
Flat bearing ground floor. What is the age of the senior citizen? 64 years. How will 10 lakhs be sufficient to maintain her throughout our life?
That's the
You
party. In fact,
50 lakh apartment, you are giving only 10 lakhs.
in fact, the brother, I mean, the son is also come. He's also ready to take the.
We'll record everything together.
He's here only, lords.
No, even the other matter, give the complete
Let
thing.
this matter be disposed of, your lords. The other matter, the talks are
10
still
lakh
on.
of rupees. We'll reject it. If you want it, we'll reject it
No,
today.
your lords. The parties have amicably settled the matter.
We exercise the power of parents
Please,
patria in
please.
senior citizen matter.
Please, please.
For a 50 lakh apartment, if you are giving 10 lakh of rupees, we have rejected in some matters, we can reject it in this matter.
No, your lords.
10 lakh will not be sufficient to take care of her for her life. You already have suffered an order.
One humble submission, your lords. Out of the other side, I mean, the petitioner, your lords, is also the mother of 2. The husband is not with her. She has to take care of two children, and she is the
Then let her, she's an able-bodied person, she can take care of herself, not the senior citizen.
no, Your Lords, the mother and the petitioner, Your Lords, have come to a as Your Lords.
She cried before us last time.
Please, Your Lords. In fact, that is why the son
That's
is.
why we told you.
Please,
You are not even
no,
doing
that is settled,
anything.
Your Lords. The amount that is so to be paid has been settled by the son.
We are not satisfied with the amount.
In fact, son is also before Your Lordship.
All of them were not taking care of her.
Please. In fact, she is with the son, Your Lords.
All of us know what she told last time.
Please.
All of you were there.
No, that is settled, Your Lords. That amount that is owed is settled by the son.
Total amount is how much now?
10 lakhs, Your Lords. Last time we had paid around, we were decided with 7.5 lakhs, Your Lords. Now we have additionally increased 2.5 lakhs, Your Lords. Cumulatively, it will come up to 10
Increase it to 25 lakhs and then come.
lakhs. It will be heavy burden on me, Your Lords.
You are not even having the property right now. We just have to confirm it.
Please, Your Lords. But the only, I mean, again, humble submission is that I have two children to take care of.
This is not your property. When you earn your property, when you earn your
Please.
money, you buy your property and keep it. Don't give it to your children.
I understand, Your Lords. No, in fact, the mother is also okay with that, Your Lords.
Mother is desperate.
No, Your Lords. The son has taken care of the previous credit.
What is the total amount which will be available in her bank balance?
Another submission, Your Lords. She is also getting a pension of about 40,000 on a monthly basis. I mean, apart from this.
You want us to reject it?
No,
now?
Your Lords.
Yes.
I'm not on that, Your Lords. I'm just making this up.
If you want to increase it, please do.
Please, Your Lords.
If these are the kind of submissions which are being made by a daughter again, as regards the mother, we are not going to accept it.
Please, Your Lords.
As simple as that.
Suitable time may kindly be accommodated, Your Lords. Because for me, I'm working only as.
If you want, we'll get a valuation done of this property. It
No,
will
Your
be
Lords.
much
No,
more
Your
than
Lords.
that.
No, Your Lords. I'll try speaking to the parties, Your Lords. I'll speak to the parties.
It is 1,430 square feet in block 4 on the ground floor
I'll speak to the parties, Your Lords. I'll seek instructions.
in Bangalore. It
I'll
has
seek
to be worth
instructions.
at least 1 to 1.25 crores.
I'll seek necessary instructions, Your Lords. Please.
If your client is going to go ahead with this kind of thing, we will not accept.
Please, Your Lords.
Get the valuation notes. A compromise petition has been filed. Stating that on payment of sum of rupees 10 lakhs, respondent senior citizen is giving up her rights over the gift deed. Learned AGA is directed to secure a valuation through the district registrar's office of the property scheduled to the said compromise petition and submit the same. This court excising its jurisdiction as a parents patria, the excising parents patria jurisdiction over the senior citizen. It is a duty imposed on this court to ascertain if the settlement is proper or not. On an earlier occasion, when the matter had been taken up, the senior citizen broke down in tears before this court, stating that neither the daughters nor the son are taking care of her, and they have got the gift deeds executed in their respective names, leaving her without any property. The acceptance or otherwise of the above compromise would have to be decided on the basis of the valuation of the apartment. When will you get it?
Day after tomorrow.
Released on
Saturday.
Lots, at least 2 to 3 weeks time may kindly be granted, Your Lords.
we are not going to give you that much time.
I'll also seek instructions on the parties, Your Lords.
Released on 3rd September for further hearing at 2:30 p.m.
Interim order may kindly be.
Interim order stands vacated. We gave you opportunity last time
Lots,
also.
we were ready, Your Lords. In fact, that is why their enhancement has taken place, Your Lords. The 2.5 lakh.
Don't come back with 2.5
No, Your Lords,
lakhs.
I'm not.
That is nothing great that you are doing.
Please, Your Lords. That's one final opportunity may kindly be granted.
On 3rd, interim order earlier granted is extended. If you are not reasonable on that date, we get ready for arguing. If a reasonable offer is not made by that date, all the councils are directed to get ready and address their arguments.
Please.
Serial number 26, urgent, 27. Sukumar V, and connected matter.
I'm afraid for respondent, madam. The RV council is not feeling well. Requesting short accommodation.
Petitioner, madam.
7.1.
Last date of hearing, this honorable court direct me to
4
pay
and
the
5 has not been served. Yarama 4 and 5.
R4, Sukumar V, petitioner in first part.
Shri Shivkumar Uma Shankar.
Uma Shankar, party Uma Shankar. Council
5 yaru?
Shivkumar. 5 is Padmavati, not served.
You will accept notice for Padmavati?
Allah, ಇಲ್ಲಿ 5 is Mallanna B. Our last
In
date of hearing.
27.1.
27.1 ಅಲ್ಲಿ ನಾನು
I am
ಕಾಪಿ
petitioner,
ಸರ್ವ್
madam.
ಮಾಡಿಲ್ಲ my lord. The writ petition
27.1, I
copy
am
is
the
not
petitioner,
served.
madam.
27.1.
27 ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ರು ಸರ್ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್.
Padmavati, daughter of B. Mallanna.
ಪ್ಲೀಸ್
Nim client ಅವರುನು?
ಇಲ್ಲ ನಮ್ಮ ಕ್ಲೈಂಟ್ ಉಮಾಶಂಕರ್ ಪಿಟಿಷನರ್.
Padmavati nim client ಅಲ್ಲ?
ಇಲ್ಲ ಸರ್.
27.1. Shri Shivkumar V accepts notice for respond number 4. Process fee ಕೊಟ್ಟಿಲ್ಲ for 5.
I will quote this one.
Order sheet ಕೊಡಿ ಏನಾಗಿದೆ?
ಒರಿಜಿನಲ್ ಫೈಲ್ ಇದು ನಮ್ಮ ಫೈಲ್ ಸರ್. ಅದೇ ನಮ್ಮ ಫೈಲ್.
Is pending maintenance amount.
ನಾನು ರೆಡಿ ಇದ್ದೀನಿ ಸರ್ ಕೊಡ್ತೀನಿ 50,000 ಪೆಂಡಿಂಗ್ ಇದೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಎಷ್ಟಿದೆ pending?
I am the proxy counsel, madam. I don't.
ಲಾಸ್ಟ್ ಡೇಟ್
Kindly and short
ಬೇರೆಯವರು ಕೌನ್ಸಿಲ್ ಬಂದಿದ್ರು ಅವ್ರಿಗೆ ಗೊತ್ತಿತ್ತು.
Will you accept the money? ನೀವು ವಕಾಲತ್ ಇಲ್ವಲ್ಲ?
ನಾವು ವಕಾಲತ್.
ಯಾವಾಗ ಬರ್ತಾರೆ ಅರವಿಂದ್? ಸರ್
Monday.
ಶಿವಕುಮಾರ್.
Monday.
Clarification.
Relist on Monday.
Please.
Submission of learned counsel for the petitioner that he is ready to make payment of sum of rupees 50,000 by cash is placed on record. Learned counsel for respond number 5 is 27 ಅಲ್ಲಿ. ಇದರಲ್ಲೂ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? 27 ಕೊಡಿ. Learned AGA for respond number 1 to 3. 3. Arvind then was filed caveat for respond number 5, accepts notice for respond number 5. Notice to respond number 4 is deferred for now. Learned counsel for the petitioner submit that the total pendency of the maintenance amount as on date is rupees 50,000,000, which is ready to make payment of. On behalf of counsel for respond number 5, a request for adjournment is made. Relist on 31st August. Counsel for both the councils are directed to file the respective account statement as regards the maintenance amounts due for the purpose of reconciliation.
Serial number 28, C. Jagdish.
Yes, Mr. Jagdish. Non-serving copy on GA. You received copy?
No, my lord, not yet. I don't think so. Colleague is appearing in this matter.
Mr. Jagdish. Password.
29 urgent, serial number 30.
Yes.
We complied with the interim order, my lords. We were directed to deposit 30,000 to the bank account of the first respondent. We complied with that. The respondent have not
Time for the respondent.
Yes, Vijay, 35,000 you have received?
Received, my lord. I filed my objections to the petition. May kindly be granted a week's time.
Learned AGA is directed to accept notice for respond number 2. Both the counsel for the petitioner and respond number 1 confirm that the interim order dated 29/7/26 has been complied with and will continue to be complied with during the pendency of the above petition. Learned counsel for respond number 164 and is granted 3 weeks time to file a statement of objection. Objections, if any, by 18th September, relist on 24th September. The interim direction which have been issued will continue to be operational until the disposal of the above petition.
Interim order might also, protection also might be extended.
Hmm?
Interim protection might be extended.
Interim order is extended till next day. Direction extend will be continued to both ways.
31.
Mr. Chetan. Any other along with note to? Note anything?
Written statement not filed.
Pass over.
32.
Appearing for the responding 2 and 3, my lord. Kindly give short adjournment, my lord. Senior
Matter
is
can be,
coming back.
ಇಲ್ಲ, matter dispose ಆಗುತ್ತೆ.
32.
32.
ಇದಾ?
2 and 3.
ಅಲ್ಲ, ಯಾವ್ದು?
Mysore Development Authority.
ಇಲ್ಲ.
32 IPR.
ಇಲ್ಲ,
ಹೌದಮ್ಮ?
ಅದಲ್ಲ, wrong. ತಪ್ಪಾಗಿದೆ.
WP 23864.
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
4986. 4986.
Wrong matter, wrong matter. ಇಲ್ಲ.
Where now?
Sorry, my lord.
My lords, appear for
Yes.
petition in this matter, my lords.
Hmm.
My lords, it's a mandamus writ, my lords, seeking direction to respond number 1 to 5 to stop unauthorized and
This is the restoration of that crypt.
renovation of the crypt, my lords, Mysore Church.
Should have been in the nature of a PIL. Last date, your lordship wanted to dismiss the matter, giving them liberty to malad.
Lords, at least in accordance with law, let them consider the representation. my lords.
We don't have jurisdiction to direct them. It has to go as a PIL.
Lords, I understand, my lords, but
So what do you want? You want to convert this or you want to file a fresh petition?
lords, I'll file a fresh petition, my lords. Until then, let them not take any.
We have no jurisdiction to direct anything. And AGA accepts notice for respond number 1. 4, 1 and 4. Petitioner is before this court seeking for the following release. On it being brought to a notice of the petitioner that the release which have been sought for is more in the nature of public interest litigation. Counsel for the petitioner seeks permission to withdraw the above petition and file a public interest litigation. Serving such liberty, petition stands disposed.
33. Pune Ms. Patil.
Government has to file their objection.
Where are the other 2 matters?
So another matter is listed tomorrow.
we've-
Date given matter. Tomorrow it is listed.
Tomorrow.
Yes.
You received
Instructions
this.
are there. Notices have been issued to them. And accordingly, my lord, in fact, your lordships had passed an order. Just point that out.
Just 3 people from the same family have got.
We've issued notices and my lord, we've cancelled it.
How did you do it in the initial?
No, initially, my lord, it was done because the policy then did not have a bar
6 crore of rupees to one family.
to one family. Then we realized it in 2021 and my lord then passed another notification saying that family members will not be given.
Does not inspire confidence.
No, then we cancelled it. my lord.
That is tomorrow.
In fact,
33, connect with WP number,
25827.
relist tomorrow. You make your submission all these.
Great.
There are 3 petitions filed, alva?
Three, my lord.
No,
Two
two
other-
petitions. Only two petitions.
Only 2 petitions.
Father and 2 sons.
So third one you are not recalled. Yes.
Final hearing, serial number 34. Manmohan PM.
1 or 2 or 3 is dispensed with, or 4 or 5. Ready?
Let's, one submission.
Yes.
Let's, my instructions are that the ASG Venkatraman has placed the issues formulated by this honorable court.
Oh, this is that
IBC matter.
We had brought it to his notice. the other time.
Let's, ASG Venkatraman has placed the issues formulated by this honorable court before the honorable FM. And it is agreed, my lords, a committee will be constituted of undersecretaries and they will consider the issue, my lords. So it may be deferred by 3 months, my lords.
interim order ಏನಾದ್ರು ಇದೆಯಾ?
Lords granted in the last.
Restraint from initiative ಇದೆಲ್ಲ. The counsel for respond number 1 submits that, can we record what you have said? or
Please, my lords.
Submit that the issues which had been pointed out in the above matter, wide order dated 26/11/25 has been placed by the learned ASGI.
Before the finance secretary, my lords.
Venkatraman learned ASGI before the
Finance secretary.
finance secretary.
And the honorable FM is also updated on that.
And the honorable finance minister also being updated on the issues which have arisen. A committee is proposed to be constituted to study the issues and make its recommendation.
Yes.
Which is submitted would take around 3 months' time.
Yes.
Hence, relist on 7th December.
Yes.
Interim order earlier, 7th December at 2:30 PM. For further hearing, interim order earlier granted is extended till next date.
Great.
So you are going to bring about a change in the whole.
Is right, because this will have far-reaching repercussions, and a lot of people have.
Mr. Venkatraman was here last week for some other matter, so we also brought it to his notice this issue.
Please.
So you had discussion with Mr. Kamath and he is tax and.
Yes.
So we will take it up.
Grateful.
B group matters, serial number 35.
Mr. Mali Patil.
Preparing for respondent in this case. Connected other two WP matters are still pending on the same subject matter.
Same subject.
It may be connected and called
Connect
along.
with so and so. Service ಆಗಿದೆಯಾ? ಎಷ್ಟು ಜನ respondent ಇದ್ದಾರೆ?
Not received the petition copy yet.
Yes, you have not served a copy of the petition.
My lord, I'll serve it, my lord, today itself, my lord, kindly.
Mr. Rambhat is appearing.
Yes.
The Rambhat has entered appearance for respondent. Registry is directed delete the name of Shri KV Lokesh as that appearing for the respond. Connect with so and so. Counsel for the petitioner is direct furnish 2 sets of the petition along with annexure on counsel for respondent. Interim order earlier granted is extended till next date of hearing. Relist on 28th September, 29th September.
Yes.
36. Chiparani, unconnected matter.
Okay, RP.
For the, please.
Thank you for coming.
I'm sorry.
Yes. Respondent number 1 before the commissioner is one Devegowda who is dead as on the date of the order. His children is sought to be brought on record. That's an impleading application.
Yeah, the impleading application is not put up.
Annexure D page 60, my lord.
27/11/25.
Have you filed an impleading application in this matter or?
Yeah.
ಇದೆಯಾ ನಮ್ಮ? When did you file it, Mr. Lakshman? When was it filed?
27th November 2025.
26.1.
2025.
25.
IA number?
Sorry. 24820.
In 36.1.
0.1, my lord. I am appearing in 0.1.
36.1. Six A to F. IA 1 of 25 has been allowed, Alva.
Please.
Has been allowed on 2/12/25.
Sorry.
ಆಗೋಗಿದೆ 1 of 25 ತಾನೆ?
Yes, please.
Lord, the only short point is family deity, my lord, the deputy commissioner passed an order in 2001.
Which matter do you want us to take? 36.1 or 36?
1, my lord.
36.1.
24820.
ಇದೆ ಇದೆ. Yes, ಹೇಳಿ. Amendment also has been carried out.
Yes. My lord, along with the memo, my lords, I filed the document. I placed it on record.
temple. C category temple.
Page 41, my lords.
Memo dated?
IA for additional documents
IA for additional.
filed on 3rd December 2025, my lords.
Entire petition, yes.
Page 41, my lord, if your lordship takes. The
41.
deputy commissioner passed an order last paragraph. Sadari 3 jana archakaru.
41.
Page 41.
It starts earlier.
That is order dated 11/9/2001.
ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯ.
Yes, my lord.
Yes.
ಸದರಿ 3 ಜನ ಅರ್ಚಕರು ದೇವಿರಮ್ಮ ದೇವರ ಪೂಜೆಯನ್ನು ಸರದಿ ಪ್ರಕಾರ ಪೂಜೆಯನ್ನು ಮಾಡಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದೆಂದು ಆದೇಶಿಸಿದೆ. ಬರಾಬರದ ಅರ್ಚಕರ ವಂಶಸ್ಥರಿಗೆ ಸೇರಿದೆ ಹಾಗೂ ಸರ್ಕಾರಿ ನಿವೃತ್ತ ನೌಕರರಾದ ಅಳಸೇಗೌಡ ಮತ್ತು ಬಿನ್ ಅಜ್ಜೇಗೌಡ ಅಗರೆ ಗ್ರಾಮ ಇವರನ್ನು 4ನೇ ಪ್ರತಿವಾದಿ ಶ್ರೀ ಸ್ವಾಮಿಗೌಡ ಬಿನ್ ನೀರೇಗೌಡ ಇವರುಗಳು ಬರಾಬರದ ಅರ್ಚಕರು ವಂಶಸ್ಥರಾಗಿಲ್ಲದ ಕಾರಣ ಈ ಇಬ್ಬರನ್ನು ಅಗರೆ ಗ್ರಾಮದ ದೇವಿರಮ್ಮ ದೇವರ ಅರ್ಚಕರ ಹಕ್ಕುದಾರಕ್ಕೆ ಹಾಗೂ ವೃತ್ತಿಗೆ ಅರ್ಹರಾಗಿದ್ದಿಲ್ಲ ಹಾಗೂ ಇವರಿಗೆ ಯಾವುದೇ ರೀತಿಯಾದ ಅರ್ಚಕ ವ್ಯಕ್ತಿಯ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳು ಇರುವುದಿಲ್ಲವೆಂದು ಆದೇಶಿಸಲಾಗಿದೆ ಹಾಗೂ ಇವರ ಹಕ್ಕುದಾರಿಕೆ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. This order, my lord, is confirmed by the Commissioner for Endowment, which is at page 67. Page 67 on 15th of October 2011. Revision ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ.
This was filed by Karigowda.
Yes, my lord.
Karigowda was not a party to the earlier order.
He was a party, my lord. He is a party.
ಎಲ್ಲಿದ್ದಾರೆ? ಅವಳೇಗೌಡ, ಸಣ್ಣೇಗೌಡ, ದೊಡ್ಡೇಗೌಡ, ಸ್ವಾಮಿಗೌಡ. ಕರಿಗೌಡ ಇಲ್ವಲ್ಲ? Win Avlegowda. So
Avlegowda's son is the
Avlegowda's son had filed.
Is the Karigowda.
Yes.
Yes. Now, my lord, the page 67, the order dated 11/9/2001 is confirmed on a Sardi basis, my lord. Right to perform the puja has been confirmed. Then, my lord, the Assistant Commissioner issued an injunction after this order, which is at page 75.
Yes.
Page 75 is 19/5/2014. This order, my lord, has been challenged by the petitioner before this court. Of course, at that point of time, Devegowda, the impleading parties are also joined with us. This petition, my lord, has been allowed on the ground that the Assistant Commissioner has no jurisdiction to grant injunction, only civil court. And the order of the Deputy Commissioner, page 93, para 9, my lord. This is an order dated 23rd October 2020, page 93.
Yes.
The earlier left side, my lord, sentence, 7th line from the bottom. Earlier dispute is stated to have been resolved in view of the order of the Deputy Commissioner dated 11/9/2011. It was confirmed by the Commissioner on 15/10/2011. The Deputy Commissioner is of the view that puja in the aforesaid temple is required to be carried out on routine basis. Therefore, annexure U dated 15 passed by the Assistant Commissioner is by set aside and the matter has been remitted back for fresh right side minutes. The Commissioner are hereby directed to examine whether the Commissioner or the Deputy Commissioner can decide the dispute issue among the petitioner and contesting respondent to perform the puja in the aforesaid temple or not. Both petitioner and the contesting respondents are permitted to place their say in the matter before the Commissioner or the Deputy Commissioner. In this regard, a speaking order shall be passed and communicated to the respective parties within a period of 3 months from the date of the receipt of the order. Now, not based on this
The
order.
Assistant Commissioner is set aside.
Yes,
Matter was remitted to Commissioner and Deputy Commissioner.
yes,
Who of
the
them?
Deputy Commissioner.
Commissioner stroke Deputy Commissioner.
Yes. Now, the Deputy Commissioner first decided the dispute confirmed by the Commissioner. Meanwhile, the Assistant Commissioner granted virtually an injunction. We said he has no jurisdiction, therefore the matter was sent back. Then, my lord, the Commissioner again passed an order on 5/9/2003. 5/9/2023.
So this remittal was to the Commissioner or Deputy Commissioner?
Deputy Commissioner, this court said either Deputy Commissioner or Commissioner. Yes. Now the Deputy, under section 27A, initially the Deputy Commissioner has to resolve the dispute. First it was decided in 2000, that was confirmed.
2011.
That's the position.
Yes.
After remand, my lord, in the same compilation document, page 14, document number 1, the Deputy Commissioner again passes an order on Sardi basis. Page 18 minutes. ಹಾಸನ ಜಿಲ್ಲಾ ಬೇಲೂರು ತಾಲೂಕು ಮಾದಹಳ್ಳಿ ಹೋಬಳಿ ಅಗರೆ ಗ್ರಾಮದ ದೇವಿರಮ್ಮ ದೇವಸ್ಥಾನದ ಅರ್ಚಕ ವೃತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿಂದೂ ಧಾರ್ಮಿಕ 25(b)(6) ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಉಪಯೋಗಿಸಿಕೊಂಡು ಶ್ರೀ ಅವಳೇಗೌಡರ ಬರಾಬರದ ಅರ್ಚಕ ವೃತ್ತಿಯಲ್ಲಿನ ಸರದಿಯನ್ನು ಅವಳೇಗೌಡ ಶ್ರೀ ಮಕ್ಕಳೆಲ್ಲರಿಗೂ ಸರದಿ ಪ್ರಕಾರ ದೇವಿರಮ್ಮ. This is again confirmation of 2001 order. Now this order is again set aside by the Commissioner and remitted back. For what purpose we don't know. That is an order.
Deputy Commissioner confirmed by the Commissioner. Assistant Commissioner passed an order. This court remitted to the Deputy Commissioner. Deputy Commissioner confirmed 2001 order.
Yes.
Commissioner set aside
this order and remitted back. There is no purpose for the remand.
Where is the Commissioner's order?
Annexure D is the order.
D to the petition.
The impugned order.
Page number?
Page 68. Sorry, Annexure D, page 60 in the writ petition.
60, yes. So again, Karigowda challenged it.
Yes. Operative portion, my lord, 68. ಮೇಲ್ವನಿಯನ್ನು ಭಾಗಶಃ ಪುರಸ್ಕರಿಸಿದ್ದೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹೊರಡಿಸಿದ ಪ್ರಶ್ನಿಸ ಆದೇಶ ಸಂಖ್ಯೆ 5/9/2003 ಅನ್ನು ರದ್ದುಪಡಿಸಿದೆ. ಪ್ರಕರಣವನ್ನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ ಮರುಪರಿಶೀಲಿಸಂತೆ ಹಿಂದಿರುಗಿಸಿದೆ. ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮೇಲ್ಮನಿದಾರರು ಮತ್ತು ಎದುರುದಾರರು ಹಾಜರುಪಡಿಸಿದ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಗೂ ವಿವಿಧ ಪ್ರಾಧಿಕಾರಗಳು ಈ ಹಿಂದೆ ಹೊರಡಿಸಿರುವ ಆದೇಶಗಳನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಕಾನೂನುಬದ್ಧ ಸಕಾರಾತ್ಮಕ ಆದೇಶ ಹೊರಡಿಸುವಂತೆ. Where is the question, my lord? When the Deputy Commissioner order is confirmed by the Commissioner for Endowment, which has been accepted by this court when the matter is remitted back.
This court did not accept it. So all the orders which are being passed is.
Of course, my lord, observation is that is page. page 93, paragraph 9. Earlier dispute is paragraph 9, my lord, page 93. Earlier dispute is stated to have been resolved in view of the order of the deputy commissioner order dated so. And it was confirmed by the commissioner on 15/10. The deputy commissioner is agreed that puja in the aforesaid temple is required to be carried out on rotation basis. The 9th the turn will come, not for the one.
Is there a civil suit which has been filed by any of the
Civil suit has been taken adverse order against us.
against?
Against us. Of course, that is, the suit is not maintainable in view of section 75. There is a total bar. Now, what this Karigowda did is, based on the power of attorney executed by one of the petitioner, he is a unregistered power of attorney. He said, all brothers have executed a GPA to me. Therefore, I am the only one person who is entitled to perform the puja. That power of attorney was set aside and was recalled, and the same has been cancelled. But since it is the right to perform the puja is an inheritance right, that cannot be a subject matter of alienation. If there is an alienation, it can only be made by registered document. Even an unregistered GPA or unregistered agreement, it's of no
nation of a right.
In fact, I cited one or two judgments of this court where the rights, yes, that's the position.
Yes. So, Pudi, which is the citation you want to refer to?
I'm sorry, my lord, I did not bring the page 17, my lords.
It's not been filed here, Mr. Lakshman. We served a copy to the other side also.
We have certainly. And R1 is a dead person. Devagoda is an.
What this memo with documents and that you have citations? You don't have. We also don't have.
I will 2:30 minutes.
Pass out.
Thirty-seven, Imran Pasha.
Seek for 2 days accommodation.
You're not inspected still.
He has inspected, my lord. He has some queries that there are rocks existing on that plot.
Rocks and all.
ಇಲ್ಲ ಅದ್ರ ಪಕ್ಕದ lands clear ಇದೆ. So tomorrow he has a meeting with executive engineer. So he will get it clarified.
Ask your client not to be too avaricious. You got it.
Yes. So let it be taken off Monday, my lords.
At the request of counsel for the petitioner, released on 31st.
Obligement. 2:30, my lords.
2:30.
Obligement.
38, Rachita Rajshekar.
Rachita Rajshekar. Pass over.
39, M. Ramachandrappa.
Pass over.
40, Kavita Damodaran.
The petitioners in these matters, Your Lordship. Your Lordship, last date of hearing I had mentioned there was an encumbrance order that was to be charged, but however the charge was not created despite interim order by this court, and thereafter on.
So, my lord.
Your Lordship, last date of hearing also the same thing happened, and after that matter couldn't be
Pass over,
taken
rather
up.
it won't reach because there's a big list at 2:30. Everybody wants to be in 2:30 list.
And on 23.
We'll pass over. If it doesn't reach, it will be relisted tomorrow. Pass over.
Great.
41, Navina Jia.
For the petitioner.
Now, afternoon will take place. Pass over. Which are all those caste certificate matters?
42, yes, Ramamurthy.
For the petitioner, my lord.
What has happened on settlement?
No, settlement, there's no possibility of settlement. We have tried, parties have tried.
Now, I
How
tried
can
my
you say
level best,
no
my lord,
possibility?
but I tried my level best. I also had a discussion with my learned friend, but consensus is not arrived at between the parties.
Ian, where are you and where are you? It's somewhere in big gap or small gap?
ಇಲ್ಲ ಸಾಲ್ವ್ ಮಾಡ್ಬೋದು ಇವಾಗ ಇರುವುದು ಒನ್ ಪೋರ್ಷನ್ ಅವರಿದ್ದಾರೆ ಇನ್ನೊಂದು ಪೋರ್ಷನ್ ಇವರಿದ್ದಾರೆ ಅದನ್ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೋದು 8,000 rupees ಕೊಟ್ಬಿಡ್ತಾರೆ ಬೇಕಾದ್ರೆ as long as the parents are alive ಅದಕ್ಕೆ ಒಪ್ಕೊಳ್ತಾರೆ ಬಟ್ ಬಿಯಾಂಡ್ ದಟ್ ಅವ್ರ ಕೆಪಾಸಿಟಿ ಇಲ್ಲ
ನಿಮ್ದು ಏನ್ ಪ್ರಪೋಸಲ್?
But he is insistent on having the matter decided finally. I told him 8,000.
So
He's now hospitalized as well. They are very clear that they want the matter to be decided.
There's no counter proposal.
No, the counter proposal was that they come forward, execute a release deed insofar as so much portion of land. That didn't work out. No. The counter proposal was release it.
So when will you get ready? Ready now?
Ready now. Very short point.
Ready? Really? Who is Mr. Rajesh P? R326.
I am for the petitioner, my lord.
You, Mr. Amurthy, you're for the petitioner. Mr. Angad Kamath is for 2. Mr. Rajesh P for 3 to 6.
3 to 6 may not be relevant parties, no? But I don't know.
We'll have to put him on notice.
Because there are 3
3 to 6
sons.
3 sons and 1 daughter.
Okay. The counsel for the petitioner and respondent number 2 are present and ready to address argument. The counsel for petitioner and respondent number 2 firstly submit that the settlement talks have failed. Secondly, submit that they are ready to address the arguments.
4 sons are there.
None appears for respondent number 3 to 6. If none were to appear for respondent number 3 to 6 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner and respondent number 2. Relist on 3rd September.
The senior citizen, 87-year-old, is hospitalized right now.
That is why we have to put them on notice. If they are not there, you address your argument. If they are there, we'll hear them.
43, Veena PK.
Exists. Kindly pass over the matter, my lords.
You are for whom, madam?
For responding 6 and 7, my lords.
6 and 7. Readings are complete.
Yes, your lordship.
Pass over.
Oblige, my lords.
44, Manasa MB.
But 6,000 crores.
Nella pass over.
Similar.
25.
5, 6 acres short. They were claiming 30.
None appears for the petitioner. Relist on 17th September.
45, Bharat K.
Lord, please have a look at the order dated 23/10.
None of them on this side.
Because your lordship had directed conduct of a survey and they had undertaken before your lordship that if the survey is against us, we will vacate voluntarily. So now that report is against them, that's why they are not there.
Not coming for that reason. Mr. Bharat, Mr. Vishwanath. Lakshman, you are appearing?
The report is given to me yesterday.
Uh-huh.
I am appearing, my lord, in public number 18745.
Yes.
Lord, your lordship may take a page 35 of this petition.
Now the report is there. You want to file any objection or argue on it?
To file a short affidavit, only one day after.
You are accepting it. So
Yes, my lord, and kindly have a
What is
look
that
at the
order
order
you are-
sheet dated 23/10.
2310.
23/10 order sheet, my lord.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಸೇಮ್ ಅಲ್ಲ?
ಒಂದರಲ್ಲಿ ಕನ್ಸೆಷನ್ ಇಲ್ಲ ಅಂತ ಬರ್ತದೆ. This is 31.43,
Lord.
45.3.
43.3, that is where it is recorded. That is WPH.
31846.
31846 is the writ petition number. But I guess it's the common order in all.
Seeking parity on this, they have taken order.
31846 madam. Madam, para 3 of the
31846.
31846, yes.
But in this one, he has not made that concession in 18820, para 2 of the order.
If your lordship sees this order, para 3, in that way of the matter, jurisdictional ADLR with the assistance of the estate officer are directed to carry out a survey of the property of the railways, including property of the petitioner, commencing from so and so, and submit a report demarcating the property of the railways as also demarcating properties of the petitioner.
31846, Mr. Ajit. This is not there, so with WP 31846 of 2025. Sorry, in all the above matters, a survey report has been filed by the ADLR. The same is taken on record. 18820 Kodi first. Mr. Bharat. Order sheet. Idralena. Survey ಆಗಿರೋದು ಇನ್ನ ಮುಂಚೆ ಆಗಿಲ್ಲ.
Would your lordship have a quick look at the report? It's very clear.
It's not there, so we can't go on merits. We'll have to only dismiss on for default. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, petition would be liable to be dismissed for non-prosecution. 30447, Mr. Vishwanath. Same order. 45.3, same order. 45.2, when will you file your counsel for the 45.2? Counsel for the petitioner seeks for 2 days' time to file a statement of objections to the inspection reports, inspection or survey report? Survey report filed by the ADLR. Since the concession made by the petitioner in WP number 31846 of 2025 has not been made by the petitioner in WP number 18745 of 2025 as recorded in the order dated 28/10/25, he is permitted to file his objections. 35 of? Your writ petition in 18745.
Yes.
187.
Correct.
Page 35.
Page 35.
Yes.
Serial number 3, survey number 89.
Yes.
89. Total extent acquired is 2 acres 30 gunda. Boundaries have been shown. In this 2 acres 30 gunda. Total extent is 430. 2 acres is left out. Even in this acquisition, I am
Total extent 430 ಎಲ್ಲಿ ಇದೆ?
230.
right side.
That's assessment.
That is assessment.
That is assessment. But grant order that you will also get it.
This is our acquisition.
29.
Yes. Left side top number 89430. Top 89 430. Survey number. Now, Milan, this is re-granted to me. But I am instruct. Now the railway also had given a sketch earlier. Now the sketch given to us, Milan, is different sketch.
This is page 29 is only a noting which has been made. Where is the grant order?
That's the grant order.
Grant order. The case number 63 is noting, this is the officer's noting, and wide report on petitioner at number 50 and 32.
29
Huh?
left side 89.
1958. Our acquisition 1980.
4.3.
It's 35.
This is not a grant order, this is
It's not a grant
noting.
order.
Where's the grant order? Saguli chit irbeku, grant order irbeku.
And this is 58, our acquisition is 1981.
The applicants are so registered jointly as scheduled tenants under section 4 of the act. This is the special certificate of Karnataka. Based on this, acquisition notification, the railway has given a sketch which I wanted to place it on the card. The present sketch doesn't tally with this. That is why I'm requesting my Rajan.
That whatever you want to give it to him, you can argue the matter. So
But we will follow whatever the state government has now filed, you know, that is appropriate, we'll follow.
both of you can argue what you want. We won't say what you have to argue.
So that we can
Yes.
verify.
So if you can give it to him today, he'll require a couple of days to go through it. You file your objections.
And award is not passed, award has not been taken.
ಅವತ್ತು ಒಂದೇ ಸತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ
But that's way beyond the scope of this writ petition.
Re-list on 31st. Whatever you want to give.
Serial number 46.
Forty-six. Ravina Kumar Nirvani. None appears. If none appears on next date, dismissal, released on 24th September.
47. MS Raghavendra Prasad. Open ಮಾಡಿ.
Board is not updating a lot, so maybe that's why many people are not.
Board is not
Still at
updating.
28. It's still showing 28 on the board.
ಯಾಕಮ್ಮ? It's still showing 28. Pass over. Update ಮಾಡಿ ಇವಾಗ. Sudden ಆಗಿ.
My matter,
Yeah, probably that is why they are not here. Because first let the board get rectified.
47.
ಇನ್ನ 28 ತೋರಿಸ್ತಾ ಇದೆ. ಇಲ್ಲಿ ಅಪ್ಡೇಟ್ ಆಗಿದೆಯಾ? Hmm, 47, yes. Next.
47. MS Raghavendra Prasad.
Pass over, they might not.
48. Samit, yes.
49 Sarita Kulkarni's matter.
Suddenly it jumped from 27 to 48.
Understand.
You're ready?
I'm ready, my lords.
If pass over, it may not reach. That's another problem.
Any short date, my lords?
Released on 10 September.
Please, my lords. Grateful.
49. Sirajuddin Ahmad.
ಒಂದೆರಡು ನಿಮಿಷ ಸುಮ್ಮನೆ ಇರಬೇಕು ಅನ್ಸುತ್ತೆ. ಏನಿದು?
49. ತೋರಿಸಿದೆ ಸರ್.
ಅಲ್ಲ ಪರೋಲ ಏನಿದೆ?
ಪೆರೋಲ್ ಅಲ್ಲ.
Panini, who is appearing in 49?
I'll appear.
Instructions you have received?
I don't have the instruction. I'll take the instruction, my lord. Maybe posted tomorrow.
What is this matter, Mr. Sirajuddin?
Lords, for homemade food, homemade food, my lords.
Homemade food?
Yes. He is under trial prisoner, my lords.
In
Homemade
under trial?
food may be provided and
That AGA 6 fund is granted a week's time to obtain instruction, make a submission, released on 3rd September.
I may be, he shifted to Bangalore Central Prison. I may be permitted to add respondent number 4 minutes.
Fine, Madi.
50, Srinivas here.
Why we moved
Counsel
the
for-
matter when it is dated 3/9?
My lords, they are the senior citizens, and it was stated that the respondent 5 had vacated the premises, my lords, and nobody is in the premises, and the
Report has
doors
come.
and windows are
Report.
also open, please. my
Report has come.
lords. My lords, my only request is the petitioners may be put into possession by the concerned Tahsildar, please, my lords, or the police, concerned police.
They have handed over the keys. The daughter-in-law, my lord, has handed over the keys.
You have handed over the keys. To whom?
Handed over the keys to us.
What have you
There
done?
are no keys. In fact, there's no lock on the door.
It
It's
is
a- it's
Keys
a-
are for what?
It's a half constructed
Under
site.
construction building, my lords.
Please see the photographs, my lord. It's half constructed. If they want to take it as is where is, my lord, we'll assist in taking it as is where is. Sorry, my lord, the colored photographs are here. Court officer, sorry.
You should also get color photographs. You should not get black and white. You should tell them that they should give you also color photographs. This is that matrimonial matter.
Yes, please.
So in a care,
Yes, please.
transfer
my
to
lords.
that bank
Yes, my
account
lords.
and all that.
Already deposit has been done, and 10,000 will be transferred to the respondent's account, please, my lords.
She was living in this property.
Please, my lord. She was occupying one of the room in that under construction building. my lord.
So now you have the so-called keys.
Possession is handed over, my lord, is your lordship may take it. We'll assist, my lord, in them taking over.
And AGA submits.
But we'll hand it over as is where is, my lord.
As is where is.
Yes, please.
It was under construction, we have recorded earlier only. That AGA submits that respondent number 5 having handed over the possession to the Tahsildar.
Tahsildar.
The Tahsildar will hand over the possession of an as is where is basis to the petitioner. If the petitioners were to call upon the office of the were to be at site, call on an office bed at site.
Lordship
on-
may fix a date, my lord, we'll, sorry.
At site. Hence, the petitioner are directed to be at site at 10:30 a.m. on 31st August 2026, when the Tahsildar shall hand over the possession
31st.
of the premises, subject premises on as is where is basis. ಅದಾದ್ಮೇಲೆ ಏನೇನು ಉಳಿಯುತ್ತೆ ಇದರಲ್ಲಿ?
My lords, we'll have to install the keys and we'll start with the construction
Can
of.
do whatever, but what will remain in this petition?
My lords, let them report the compliance, my lords. It may be called up.
Reporting compliance relist on 3rd September.
Grateful. my lords.
Lord,
A re-
fix a time also, my lord.
A report,
August 10:30.
10:30.
a report of Tahsildar has been filed, the same is taken on record.
10:30, my lord.
10:30 on 31st.
Grateful, please.
51, Sonia Rajesh.
Party in person.
Your lordship 51. Item 51.
51,
Your lordship, this is a matter of
Yes.
a request to instruct the passport authorities to issue the passport for the child, your lordship.
Where
The-
is the respondent council? You should see whether, before you commence. Swamini Mohanambal, either online, either
ಇಲ್ಲ sir.
pass over.
52, Chetan Jadhav.
Yes, madam.
Rowdy sheet, Raman.
You have received instructions? And AGA 6 fund is granted a week's time to obtain instruction, make a submission. Released on 10th September.
Obliged.
53, Devendra Gowda.
List. ಇವಾಗ ಆಗ್ತಾ ಇದೆಯಾ? ಇದ್ರಲ್ಲಿ 53. None appears. Relist on 17 September.
54,
ಏನಿದು? Defreezing.
defreeze.
Hmm?
Defreeze.
Petitioner is directed to appear before the Cyber Command on 3rd September. Relist on ಯಾವತ್ತಿದೆ?
59,
15/9, 53, 54.
55,
Respond number 9 in this matter.
Currently, there's an order of status quo which is operating against both of us insofar as the subject property is concerned. We had filed this writ not primarily because the police was interfering with us. As of now, there's an order of status quo passed by the coordinate bench of this honorable court, which is why, my lord, I think it may be deferred for some period, for some time.
Plus the prayers they have asked are civil prayers, my lord. In the writ petition, they're asking not to interfere.
Want to address the argument, you can finish it.
No, my lord, I would request my lords defer this for some time because that order is operating as against both of us as in the state. My lords may because
So
the
no
issue is
order
that, my lord,
can inure to any
from
of your-
division bench to single bench that notifications not come in as yet. So we're just
There are
waiting for
already
that.
criminal
Siddharth
cases.
Suman has entered appearance for the petitioner, delete Manik BT. Sri CS Vinod has entered appearance for respond number 9, delete SK Mithun as that appearance for respond number 9. Sri Siddharth Suman submit that order of status quo has been passed in W.
In RFA, my lord, RFA number 602 of 2026.
RFA arising out of Bangalore or?
Bangalore.
It will be here only.
Coordinate bench, because, my lord, now the division bench, it's all going to single
In
bench.
RFA number so and so. Relist on 24th September.
Yes.
What is the stage of that?
My lord, now it is for admission before the, no, it is on hearing, my lord, because we have filed certain applications.
It will take some time.
It may take some time, so.
Relist on 23rd November.
October, not too far also, my lord.
By the time the
I will
transfer
take-
happens, it will be 1
In
month
fact, I've
less.
sought for a vacation insofar as that is concerned, because it's their appeal.
By the time the transfer happens, it will be more than a month. Then
That
it
is-
has to be heard.
It is an issue, please.
Take some time.
Please, obliged.
56, which is denied.
56. Relist on 17 September.
Serial number 57, urgent, 58. Sohan H.M.
It's a mandamus granting, seeking the permission for the transport of the woods, my lord. I'll seek instruction, my lord.
Consider the application then. It's only a mandamus.
No, mandamus, they are seeking the direction, my lord.
Yenanta.
Issue writ of mandamus directing the respondent to permit the petitioner to cut and transport the remaining acacia trees situated in survey number 10 and 11 of Tavarakappa village, Shivamogga, pursuant to the
And appears to the petitioner relist on 18th September. In the meanwhile, and AGA to secure instructions.
59, Prasanna DP.
None appears 18th September.
60, Bhupalan B, party in person.
Jane sir?
Yes. Mr.
Actually, yes.
Order sheet, could you?
20762 Lordship, please. Lordship.
20762
Lordship. Second case, Lordship.
There's some direction we had issued last time.
Yes, Lordship. Please, Lordship.
No, Kodi? Adರಲ್ಲಿ?
I am the victim of similar to Havana syndrome technology, Lordship.
Havana.
Yes, Lordship. Within second, fever, headache, vomiting, nausea, dizziness, causes of paralysis
Okay,
and
it asks
heart
them to
attack
get instructions,
could get,
just one.
Lordship.
That you have already told us 2-3 times.
Lordship, page number
Mr. Bhimaya,
229, please, Lordship.
we can't hear you. You're on mute.
My lord, now, is it, my lord, I am appearing for the respondents, my lord.
You're appearing for all the.
Yes, my lord. My lord, the petitioner prayer is only with regard to the writ of mandamus, direct the respondent to reply to my legal notices, so and so and so many letters, my lord. So what instruction is, my lord, let there be a direction to reply to that, and within 4 weeks will this writ petition may be disposed of, my lord, on that line.
Lordship, humble request, Lordship. They could give the reply, Lordship, but I am a retired army person, Lordship. Our colleague saw the technology being installed in some institution, army institution, Lordship. It makes the above said causes, Lordship. So that is actually the respondent should script that Indian Army is possessing the above said technology to cause schizophrenia, anomalous health incident, and electromagnetic stalking.
We can't ask them what you want to be said to say
Yes,
that.
Lordship,
You want a reply, they'll issue a reply. If they issue a reply, you can find faults with it
Lordship,
and challenge it.
Lordship, legal notice I sent, Lordship.
This prayer is only with regard to the reply, my lord.
O1 I sent, Lordship. I clearly state that, Lordship, but they never reply.
Now they'll reply is what they're saying. You have issued this notice on 17th January. They'll reply to it. That is in the second matter, Mr. Bhimaya. What about the first matter?
No, first, my lord, first matter only I am appearing, my lord.
Second matter, I am appearing.
Second
First
matter, you
matter,
are.
Yes, ma'am.
first matter, I have filed a memo appearance. And my
Now,
lord,
first
with regard
matter
to the
is-
prayer is concerned, my lord, only writ of mandam. Let there be a direction.
10166.
If I may,
So
Manoj,
second matter will come to you.
if I may, he has already preferred a petition before the Madras High Court, which culminated into a writ appeal and an SLP, which have
Place
all
the
been
orders.
dismissed.
Place the orders.
I'll place it on record, Manoj. That is all. I just wanted to file my preliminary objections as well.
When will you file it?
My Lordship,
Last
at the
time-
time, Lordship, I already here also at the Honorable Lordship Court also, I
All of
filed
that has
one
been suppressed in this
repetition, Lordship.
Whatever
But at the time, I did not
Maybe
have
suppress
evidences,
everything.
Lordship.
If
I
a
annexed
party-
the evidences, Lordship.
Just one more. If a party in person is appearing, you should file it so that it is not unnecessarily made to
I
come.
have sent the draft, Manoj. I'm only waiting for their
You
approval.
know the date of the matter. All the matters are dated.
Another week's time, Manoj, I'll file it and I'll serve him.
Councils will be here. Party in person has only come for this matter.
I understand, Manoj. A week's time, I'll file these.
WP 10166. Third.
Lordship, ISRO does not give reply to
Just one more.
RTA also.
They'll reply now. WP 10166 of 26. Petitioner is before this court seeking for the following reliefs. Case Bhimaya on instructions. Submit that a reply to the legal notices as contained in the prayers would be issued within a period of
4 weeks. 4 weeks, my lord.
4 weeks from today. That is on or before 24th September 2026.
Yes.
Placing his submission on record, petition stands disposed, reserving liberty to petitioner to challenge the reply if so permissible.
Much.
60.1.
Right.
Other disposal order, either daily order probably.
But
Shri
humble
Keshav
request,
M.
Lordship.
Latar has appeared for the respondent. Registry is directed to delete the name of Shri K.S. Bhimaya as that appearing for the respondent. Sri Keshav Datta submits that the petitioner had filed one other petition before the Honorable High Court of Judicature at Madras.
Madras, which culminated into a writ appeal and then an SLP.
What happened in writ petition?
Writ petition came to be dismissed. Writ
So,
appeal
Came to be
Lordship,
dismissed.
now in this writ petition, Lordship,
Let him make it, sir. Which came to be dismissed.
The writ appeal also confirms the order of the learned.
Writ appeal filed confirmed the order of the learned single judge.
The SLP also stands.
The SLP filed by the
Lordship,
petitioner was
now
also
annexure
dismissed.
why I attach Lordship, all the evidences, even fundamental rights violation, Lordship, ISRO does not give reply, Lordship. Then where I would go, Lordship? Honorable courts may take this case very crucial, Lordship. Because ISRO if gives reply.
If you have already questioned the same thing before the
No,
Madras High Court and there's an order passed, then we can't
Lordship,
again.
that is
reconsider.
another matter. That is two different.
Let us see, he's going to place it on record. When will you place it on record?
A week's time.
The Honorable Apex Court rejected the SLP. The Keshav Datta seeks for and is granted a week's time to place the said orders on record, as also to file a statement of objections to the petition.
Please.
Relist on, you are in Bangalore now or?
Oh, yeah, yes. Lordship.
Relist on 10th September.
Please.
Watch out.
61. The applicant time.
Not the petitioner, because the petitioner sought for certificate for quashing of a order by the Karnataka State Board of Works appointing one committee.
You are ready?
I'm ready, my lord.
Pass over.
62. Rohan Kotari.
Respond number 2, yaar.
Of the Union of India.
Shri S. Rajshekhar, who is appeared for respond number 1, is also directed to accept notice for respond number 2. None appears for the petitioner. Relist on 18th September.
63. Praveen Kumar Hiremat.
Yenidu?
The charge sheet is already filed, my lord.
It's
Invest-
for registration of company.
Please, my lord.
He's asked for transfer.
They've also sought for transfer of investigation.
Petitioner is before this court seeking for the following reliefs. Learned AGA submits that a charge sheet has already been laid.
CC number 23682.
In CC number
23682.
23682 of 2026.
2026.
If at all the petitioner is aggrieved by the said charge sheet and or seeks for any reinvestigation or further investigation, he is at liberty to make such application before the court seized of the matter. Reserving such liberty, petition stands disposed.
4. G. Jasinkapu.
Petitioner, my lord.
Mr. Anand. Same relates to cooperative society.
Yes, my lord. On the last occasion also, this honorable court passed an order to list before the roster bench, my lord. But
Court-wide
again,
order dated 14/7/26 had categorically observed that the matter relates to cooperative society and the registry is to verify the correct classification. The matter is once again listed before this court. Registrar Judicial is directed to personally look into the matter and do the needful.
please.
65. Prashant S.
It's appearing to the respondents, my lord. Respondent 60.
Ready?
That's 2 weeks time.
The board is now showing properly. None appears for the petitioner. Counsel for respond number 6 to 11 seeks for 2 weeks time. Relist on 15th September.
66.
May I appear for the fourth respondent, my lord, to execute the previous ex parte order granted in the previous writ petition. This writ petition is filed. Previous writ petition was
Number
dismissed.
4 yaar, private party na?
Please, madam, I may permit to pass over the previous order passed by
Where
this.
is Mr. Nityanand Naik?
Please. I'm appearing for the fourth respondent.
Hmm?
Fourth respondent.
You are for the fourth respondent.
Please.
ಮತ್ತೆ ಈ ಕಡೆ ಹಾಕಿದ್ರಿ ಈ ಕಡೆ
I apply.
Where is the petitioner?
Yes, sir.
Mr. Leela, Miss Leela. Leela P. Devadi.
The present petition does not survive for consideration, my lord, of the fact that to implement the interim order granted in the previous writ petition, this writ petition is filed. Previous writ petition was, your lordship was pleased to dismiss the previous writ petition, directing the reserving liberty to the petitioner to establish their lists as well as the rights before the appropriate forum.
None appears for the petitioner. That counsel for respondent number 4 submit that the above petition has been rendered infructuous. If none were to appear for the petition on the next date of hearing, petition will be liable to be dismissed for non-prosecution. Relist on 7th September.
67, P. N. Jaideva and connected matters.
Mr. Jaideva. What is this matter? Stamp. Matilva. None appears on 22nd.
68. One more.
My lord, I appear for the respondent number 2 in this case, my lord.
Yes.
My lord, I seek a 2 weeks time to file my objections, my lord.
I appear for respondent number 1. They have sought for mandamus.
Yes.
We have
Mandamus.
Issued an
19th,
endorsement,
19th we have issued endorsement. They may have to challenge
They
that.
may
by
have to
filing
challenge that. my lords.
Who is respondent number 2? Right?
My
He
lord,
represents
Nabad,
my lords. We have to take minutes.
ಬರೀ ಟೈಮ್ ಕೇಳಬೇಕು ಅಂತ ಟೈಮ್ ಕೇಳ್ಬಿಡೋದು ಅಷ್ಟೇ. Petitioner is before this court seeking for the following leaves. Land counsel for respondent number 1 submit that the representation of the petitioner at annexure H, J, L, M and N have been considered an endorsement dated 19th August 26 has been issued. Counsel for the petitioner seeks liberty to challenge the same. Reserving such liberty, petition stands disposed.
please, my lord.
Great. I make one request insofar as 62. I missed it. I missed the bus.
62, we have directed you to take notice for respondent number 2 also. Yeah. Petitioner, nobody was there.
Yes.
69.
My lord, I appear for the respondent, my lord.
Waiting for the petitioner, my lord. Kindly pass over, my lord.
Pass over won't reach, madam. Pass over. Yes.
70, Adi Narayanappa.
It's a good word.
Not for respondent, my lords. Kindly pass over, my lord.
Pass over.
This is only a matter, my lord, where the petitioner is seeking direction to prepare the voter list. He want to contest for MLC election. His grievance is that the voter list is not prepared as per the guidelines. So that's all. Some direction may be given to do according to.
Proxy council ಅಂದ್ರೆ ಏನ್ ಮಾಡು? Pass over. But only problem is pass over ಆದ್ರೆ reach ಆಗಲ್ಲ. Yes, pass over.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಏನು ತಗೊಳ್ಳೋದು?
71.
ಅಥವಾ it can be taken on Monday.
70. At the request of counsel for respondent relist on 31st September, 31st August.
71.
Tanish. None appears relist on 24th September.
72.
For the petition.
Hmm. 72.
Yes, my lords. My lords, they are not giving the CCTV footage, my lords.
CCTV.
Despite from the.
Who has directed them to give the CCTV footage?
My lords, this honorable court, my lords.
Page number? Where is the order?
It's just a minute. My
It's only your representation that you had.
lords.
Who has directed them to give the CCTV footage?
My lords, this honorable court in the interim order, my lords.
Page, in this matter?
Yes, my
What is the date of the order?
My lords, kindly pass on, my lords. I'll get all the documents, my lords. It is in another court. Sincere apologies from my side, my lords. Kindly pass on, my lords.
His DGP was directed to file an affidavit on 1/6/26.
Kindly pass over, my lord. My instructions are that, my lord, that 28 to 25 to 1325, they have received the footage. For that, my lord, they have also acknowledged, but the prayer is different, my lord. They are seeking in
24.
seeking for
to
24
comply
3
with the order
26 to
That appellate authorities order, what is the page number, madam? Appellate authorities order.
I have the endorsement, my lord, acknowledgement, my lord, for having received from 28 to 25 to
Look at it
1325.
and find
Let's kindly pass on, my lords.
also.
May I make one
One
submission,
request,
my
ma'am.
lords?
Serial number 83. ಅದು
Yes.
preliminary hearing ಇಂದು ಬಿ ಗ್ರೂಪಿಗೆ ಬಂದ್ಬಿಟ್ಟಿದೆ. It's a eviction order matter, public premises eviction.
83 released on 29th in preliminary hearing.
My lords,
83. 83, 31st in preliminary hearing.
my lords,
31st. First.
First.
my lords, 95, my lords.
Report. What number? Good number.
Listed on 230. This is a somewhat I am part of matter.
Impleading amendment. Impleading, who do you want to implead?
Shukmar has started impleading. Usually Shukmar has started impleading application.
You have any objection?
I have no objection, Moroda.
IA3 of 25 has been filed for impleading. Counsel for the petitioner submits that he has no objection for the said application. Hence, IA3 of 25 is allowed. Amendment ಏನಿದು?
Amendment, Moroda, I filed a necessary documents for amending writ petition.
What do you want to amend?
The writ petition are short for amendment.
In additional grounds,
Extend roads and allowing.
IA1 of 26 has been filed for bringing on record certain additional grounds and additional prayer. Accepting this reason stated in support of IA1 of 26, said application is allowed. Counsel for the petitioner to carry out necessary amendment, file amended petition. IA5 of 25 will be considered along with the main. Relist on 3rd September. ನೀವು ಇದೆಲ್ಲ ಮಾಡಿ ಹಾಕಿ. Yes, madam.
230, madam.
Serial number 135, my lord. 135, my lord. This is a matter, if your lordship remembers, my lord. I'm a student. I have been terminated from IISc, my lord. And your lordships had heard us at length, my lord. However, the opposite side had to file objections. My semester has already begun, but I'm not able to attend classes because I have illegally been held to be a respondent and grave orders have been passed against me, my lord. Your lordships heard this matter at length, my lord, and it was posted for the opposite side to file objections. However, till date is not being done, and I'm still suffering because the semester is ongoing.
135 released on 31st at 2:30 p.m.
My lords, 95, my lords.
Yes.
This is a fresh matter wherein your lordship was pleased to direct me to take notice. Day before yesterday, they have served me a copy. I need to file my objection as well as wakalat.
Have you informed the petitioner?
Yes, my lords.
My lords,
And my
appearing
name
for
is
the
shown
petitioner.
wrongly, my lords. My name is shown wrongly. I could not make out the listing of the case, my
Correct
lords.
the spelling of the counsel for respond number 1. Who is appearing for the petitioner in 95?
My lords, I appear for the petitioner in serial number 95. I apologize, my lords. I think there is some slight issue with the video on my device, my lords.
How long do you want?
3 weeks, my lords. I need to file objection as well as wakalat, my lords.
2 weeks time is granted to counsel for respond number 1 to 3 to file wakalatnama and objection.
Obliged. My name may be shown correctly, my lords. I'll
Correct the name. Relist on 17th September.
oblige.
Grateful, my lords.
My lords,
133, I am student, the petitioner is a student seeking for the direction from the passport office.
133.
Please, Your Lordship.
Relist on 31st at 2:30 p.m.
My lords, serial number 123, my lords, I'm challenging a tender notification. My lords, my instructions are tomorrow is the last day for receipt of tenders. My lords, may I kindly have it
File
tomorrow.
amendment application.
Yes, my lords, I had to change the prayer. There was a corrigendum which was issued.
26 has been filed seeking for amendment of the petition. Accepting the reasons stated in support thereof, IA 3 of 23, 6 are allowed. Counsel for the petitioner is permitted to carry out necessary amendment, file amended petition.
My lords, can I have it tomorrow? I'll comply with that, my lords. Can I have it tomorrow?
29th. Yes. IVF matter. '88 relist on 31st at 2:30 p.m.
44, my lord.
Hmm?
My lord, extremely sorry, I cannot appear when the judge was called, my lord.
44.
Into 17, my lord.
Ah.
Date, my lord, next week, any day.
ಯಾವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ
17/9.
17/9 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಿಲ್ಲ
serial number 112, my lord. 14% respondent 5, my lord. ಅದು ఒక ಎಕ್ಸ್ ಪಾರ್ಟಿ ಸ್ಟೇಟ್ ಅನ್ನ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ అని ಅದನ್ನ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಪ್ರಿಲಿಮಿನರಿ ಬಿ ಗ್ರೂಪ್ ಮಾಡಿ my lord.
IA 1 of 26 will be considered along with the main relist on
Writ preliminary B group act, madam. Hearing
10th September. Yes, Mr. Vish. It won't come up before us. It will go before the company judge. Your matter is a company petition.
Company judge, this is illegal. I have already clarified on paper. Registry is making a mistake. If it is totally in breach of the statute, if the lordship calls for the file, I'll explain it here. If you feel-
Advise ಮಾಡಬೇಕು 107 ಏನು 107 ಹೇಳಿ
Directed the government advocate to produce the report from the administrator.
Report from the
Administrator appointed.
direction ಇದೆಯಾ ಆಲ್ರೆಡಿ ಬಂದಿದೆಯಾ ಮೇಡಮ್
My colleague is appearing. I'll ascertain.
Monday ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ.
I'll ascertain.
ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದಾರಾ IA 2 of 24 will be considered along with main relist on 31st.
31st at 2:30 madam.
We are no longer sitting in the company jurisdiction.
Lordships 118 I wanted to mention.
Check ಮಾಡಿ. Yes, Mr. Kumar.
Lordships 118 I wanted to mention.
118, yes.
Lordships.
What about 118?
It is a Kingfisher's pilots case, Lordship, which I happened to mention a few days back also. So I want to request that in case it's not being heard today, some other date where it can be fixed.
You want another date?
I don't want Lordships, but if it is not being heard today, was because possibly Lordships is getting a
1 of 26 will be considered along with the main relist on 17th September.
On Monday, I'll explain it. If you feel it, then you can just get
ನೋಡಿ
that.
ಅದು ಮೆಮೊ ಒಂದೇನಲ್ಲ
One second, please.
Sir, 123 ಯಾವ ಡೇಟ್ ಹಾಕಿದ್ದಾರೆ?
Memo for posting.
Lunchtime will answer the call. Before that, you won't answer. So many matters.
Now you perform on the memo and number.
So many matters came up.
ನಾಳೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 93 ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
93 ಇನ್ನ ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್, ಗೊತ್ತಿಲ್ಲ ಡೇಟ್.
ಥ್ಯಾಂಕ್ ಯು.
ಒಂದ್ ಕಡೆಯಿಂದ ಹೇಳ್ತೀನಿ. 45 31/8.
Can you just check what date she's given in that?
94.
I gave you one memo, no?
ಇದೆ 94 ಇದೆ.
Can you just ask her what date she's given?
ಡೇಟ್ ಇವಾಗ ಕೊಡಲ್ಲ. ಕೇಳ್ಬೇಕಿತ್ತು, ಇವಾಗ ಎಲ್ಲರೂ ತಗೊಂಡ್ರಲ್ಲ, ನೀವು ತಗೋಬೇಕಿತ್ತು.
It's gone to 72.
ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಫೋರ್ತ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಅದಕ್ಕೆ ಮುಂಚೆ ಕಲಬುರ್ಗಿ ಒಂದು ಮಾಡಿ, ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಪ್ರೊಸೀಜರ್ ಹಿಂಗಿರೋದು ಯಾವ ತರ ಲಿಸ್ಟ್ ತಗೊಳ್ಳೋದು ಅಂತ. ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಒಬ್ಬರಿಗೆ ಹೇಳ್ತೀನಿ, ಯಾವ ನಂಬರು ನಂಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಊಟಕ್ಕೆ ಮಾಡ್ತೇವೆ.
ರೀಚ್ ಆಗ್ತೀರಾ ಇರೋದು 17/9 ನೆಕ್ಸ್ಟ್ ಡೇಟ್. ರೀಚ್ ಆಗ್ತೀರಾ ಇರೋದು ಹೌದು. 64 ಅದು ಇಲ್ಲಿ ಬರಲ್ಲ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟೀಸ್ ಮ್ಯಾಟರ್.
29 ಅಂತ ಹೇಳಿರೋದಲ್ಲ
53 79 ಇದೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 99 ಡೇಟ್ ಹೋಗಿದ್ಯಾ ಮೇಡಮ್?
47 ಪಾಸ್ ಅವರು
ಮೇಡಮ್ 88 31st 230 ಹೇಳಿದಲ್ವಾ?
88 ರೆಕಾರ್ಡ್ ಆಗಿರುತ್ತೆ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. 31 8
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 99
73
ಲಿಸ್ಟ್ 1
123
140 112 ಇದೆ.
123 29 8
112 10
ಈಗ ಹೇಳಿದ್ನಲ್ಲ ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಡ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 99 ಲಿಸ್ಟ್ 1 ಡೇಟ್ ಹೋಗಿದ್ಯಾ ಮೇಡಮ್?
ಅದೇ ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ಡ್ ಓವರ್ಸ್ ಎಲ್ಲ ಯೂಶುವಲ್ ಆಗಿ ನಾಳೆನೆ, ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಇರುತ್ತೆ.
Code master madam.
ಎಲ್ರಿಗೂ ಹೇಳ್ತೀನಿ.
Code master madam.
80 ಇದೆ.
Can you hear me, Code master madam?
ಇರಿ ಒಂದ್ ನಿಮಿಷ ಇರಿ. 59 189
Code master madam, can you hear me please?
120
Code master madam.
128 ಇದೆ.
Code master madam.
ಅದು ಕೊಡಲ್ಲ, ಅದು ಅದಕ್ಕೆ ಬಂದಿದೆ ಅಲ್ಲ ಇಲ್ಲಿ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತಾನೆ ಇದೆ ಅಲ್ವಾ ಬಂದಿರೋದೇ ಅದಕ್ಕೆ. ನೀವ್ ಅದ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಸ್ಟೇಜ್ ಬೇರೆ ಆಗ್ತಿತ್ತು, ಇವಾಗ ರೀಚ್ ಆಗೋಗ್ತಿತ್ತು. ಬಂದಿರೋದೇ ಅದಕ್ಕೆ. ಅದ್ರ
ಎಕ್ಸ್ಕ್ಯೂಸ್ ಮಿ ಮೇಡಮ್,
ಇವಾಗ ಹೇಳಿದೆ ಸರ್, ಕಲ್ಬುರ್ಗಿ ಫಸ್ಟ್, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಡ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
Code master madam.
ಮೇಡಮ್ ಇದು ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 99 ಡೇಟ್ ಹೋಗಿದ್ಯಾ ಮೇಡಮ್?
ಮಧ್ಯಾಹ್ನ ಹೌದು. ನಾನು ಇವಾಗ ಹೇಳಿದ್ನಲ್ಲ ಆ ಸೀರೀಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಲ್ಲ.
Serial number 118 madam.
ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ, ಯಾರು ಟೈಮ್ ತಗೊಂತಾರೆ, ನಂಗೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ. ರೀಚ್ ಆಗ್ದಿರಾ ಇರೋದು ಹೌದು.
Madam serial number 118.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಇವಾಗ ಹೇಳಿದ್ನಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ ಟೈಮ್ ಎಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ, ಯಾರು ಎಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ, ಯಾರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂತಾರೆ ಗೊತ್ತಿಲ್ಲ.
Ma'am serial 118 madam.
62 ಇರ್ಲಿಲ್ಲ ನೀವು ಕೇಸ್ ಕರೆದಾಗ. 62 89 54 59 ಹೌದು ಪಾಸ್.
ಮೇಡಮ್ ರೀಚ್ ಆಗದೆ ಇರೋ ಕೇಸಸ್ ಯಾವಾಗ?
ಹೌದು, ಕಲ್ಬುರ್ಗಿ 2 3 4 ಆಮೇಲೆ ಪಾಸ್ಡ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಲಿಸ್ಟ್. ಅದೇ ಗೊತ್ತಿಲ್ಲ ಸರ್, ನಂಗೂ ಗೊತ್ತಿಲ್ಲ ಯಾರು ಎಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ, ಯಾರು ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ತಾರೆ, ಯಾರಿಗ್ ಗೊತ್ತು. 62 ಏನ್ ಬೇಕು 62 ನಲ್ಲಿ? ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ, ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ. 89 ನಿಮ್ದು ಪಾಸ್ ಓವರೇ ಹೌದು. ರೆಸ್ಟೋರ್ ಆಗಿದ್ರೆ ಓಕೆ. ಫೈಲ್ ಅಲ್ಲೂ ಆಗಿದ್ಯಾ, ಸಿಸ್ಟಮ್ ಅಲ್ಲೂ ಆಗಿದೆ ನೋಡಿ, ಅದೇ ಗೊತ್ತಿಲ್ಲ. 65 59 ಡೇಟ್ 59. ಫೈಲ್ ಆಗಬೇಕು. ಅದ್ ಅವಾಗ್ಲೇ ಕೇಳ್ಬೇಕು. ಫೈಲ್ ನಾವು ನೋಡಿದ್ವಿ, ನೀವು ಕೊಟ್ಟೋದ್ರಿ. ಫೈಲ್ ಇಲ್ಲ ಇವಾಗ ನನ್ನ ಹತ್ರ, ಸ್ಟೆನೋಗ್ರಾಫರ್ ಹತ್ರ ಇದೆ ಫೈಲು. ಸ್ಟೆನೋಗ್ರಾಫರ್ ಹತ್ರ ಇದೆಯಪ್ಪ ಫೈಲು, ನಮ್ ಕಡೆ ಇಲ್ಲ. ನೀವ್ ಆಗ್ಲೇ ಕೇಳ್ಬೇಕು. ನೋಡಿ ಅಲ್ಲಿ ಡಿಕ್ಟೇಷನ್ ಆಯ್ತದು. 59 ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ, ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ. ಯಾವುದು ಇಲ್ಲ ಇಲ್ಲ, ಯಾರು ಇರ್ಲಿಲ್ವಲ್ಲ ಕೇಸ್ ಕರೆದಾಗ. ಅಲ್ಲ ಈಗ ನಾನೇನ್ ಮಾಡ್ಲಿ ನಿಮ್ಗೇನ್ ಮಾಡ್ ಫೈಲ್ ಇಲ್ದಿರ ಇರೋದ್ ನಾನು ಹೆಂಗಪ್ಪ ಕೊಡ್ಲಿ ನೀವ್ ಆಗ್ಲೇ ಕೇಳ್ಬೇಕಿತ್ತು ನಾವ್ ಹಂಗಿದ್ರು ನೋಡಿದ್ವಿ ನೀವು ಹೊರಟ್ಬಿಟ್ರಿ ಆ ಫೈಲ್ ಬಂದಾಗ ಮಾಡ್ಬೋದು ಇಲ್ಲ ಬ್ರಾಂಚ್ಗೆ ಹೋಗಿ ಮಾಡ್ಬೋದು ಇಲ್ಲಿಗೆ ಬಂದು ಹೋಗುತ್ತೆ ಯಾವಾಗ ಬರುತ್ತೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಆರ್ಡರ್ ಸೈನ್ ಆದ್ಮೇಲೆ ಬರೋದಲ್ವಾ ಬಂದ್ ನೋಡಿ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದ್ರೆ ಮಾತ್ರ ಬನ್ನಿ ಇಲ್ಲಾಂದ್ರೆ ಬರ್ಬೇಡಿ ಸೈನ್ ಆಗಿರಲ್ಲ ಅಂತ ಯಾವಾಗ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೋ ಅವಾಗ ಆಯ್ತು ಇವಾಗ ಯಾವ್ದು ಇಡ್ತಾ ಇದ್ದೀರಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಮೂರ್ ಅಷ್ಟೇನಾ ಆಮೇಲಿಂದ ತಂದಿಟ್ರೆ
Leave it. They will see, then they will say no. Oh, I will tell Ranjit. I will tell you. How you said, huh?
ಫೈಲ್ ಆಯ್ತಾ ಇದ್ದಪ್ಪ ನಾನು
Table is not
ಫೈಲ್ ತೆಗಿತಾ
working.
ಇದ್ದೀನಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಲ್ಲೇ ಇದಕ್ಕೆ ಡಿಸ್ಪ್ಲೇಗೆ ಹಾಕಿ ಫೈಲ್ ಕೊಡಿ ಸಿಕ್ಕಾಕೊಳ್ಳಿ
Yeah. This is also fine.
2762 ಇಲ್ವೇ ಇಲ್ಲ ಅಂತ
Full tight, huh?
ಇಲ್ವೇ ಇಲ್ಲ ಡಿಸೆಂಬರ್ 2
Coming up.
ಸೀಲ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ ಇದಕ್ಕೆ ಓಕೆ ಸೀಲ್ ನಂಬರ್
ನೀವು
ಮ್ಯಾಮ್ ವರ್ಕಿಂಗ್.
ಆಗ್ಬೇಕು ಅದಕ್ಕೆ ತಾನೇ ಒಂದ್ ವಾರ ಆಯ್ತು ಹೇಳಿ ನಾನು ಅಲ್ಲ ಮಾಡ್ಲಿ ಅವ್ರಿಗೆ ಹೇಳಿ ಹೇಳಿ ಸಾಕಾಯ್ತು ಡೈಲಿ ಇದೆ
ಸರಿ ಕೇಳ್ತಿದ್ದಾರೆ. ಓಕೆ ಸರ್ ಕೇಳ್ತೀನಿ. So one of the person is sitting at the city. Because it has to be, like every time it has to be removed as because they have to operate it. After removing the persons and also they can. It has to be placed there only and the ES can operate it. So the things we cannot both are working fine. Both are this, so the PC side, is working fine, no issues. Now left with the cable, replace one cable and test it. Then later you can go for the casing piping and all, whatever it is. That is a
Cable right now we don't have cable, no?
No, from anywhere you say.
Anywhere from anywhere, everything we have to open.
Yeah, that's what.
So it will
Everything
definitely
has
time,
come
it's not
from
right
the
now.
rack only.
I'll check with the and I'll update you.
Okay.
Hey, Ranjit, that this cable is connected there? That side.
ಇಲ್ಲ ಇವ್ರು ಬರ್ತಾರೆ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬರ್ತಾರೆ, ಸಿಸ್ಟಮ್ ಚೆಕ್. That one has come from where?
Document to understand. That is not see. It came, but it will work there, not here. It will work there, not here, man. This cable is fine. That also we have to remove. I'm pulling that cable.
No, check it where it has come
I have gone like inside
this casing.
Completely.
Try once.
It's not possible, sir.
Okay. Oh.
Wireless, wireless.
First row Kalburgi, number second is, third is, fourth is, first row, seventh. Last one. 61 passed over. ಹೌದು. First Kalburgi, second list, third list, fourth list, passed over, seventh. ಇಲ್ಲ ಇವಾಗ ಹೇಳಿದ್ನಲ್ಲ. ಏನಾಗಿದೆ? ಇಲ್ಲ ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ ಒಂದೇ ಒಂದು ಮಾಡಿದ್ದೆ ಅದಾದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಫೋರ್ತ್ ಲಿಸ್ಟ್ ಈಗ ನಾನೇನ್ ಮಾಡ್ಲಿ ಫೈಲ್ ತೆಗಿಯಕ್ಕಾಗಲ್ಲ ತುಂಬಾ ಫೈಲ್ ಇದೆ ಇವತ್ತು ಇಲ್ಲ ಹಾಕಿ ಕೊಯ್ರಿಲ್ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ಸ್ಟೇಟಸ್ ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ ಅದ್ರಲ್ಲಿ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಬರುತ್ತೆ ಟ್ವೆಂಟಿ ಆದ್ಮೇಲೆ ಏನ್ ಸರ್ 11 ಫಸ್ಟ್ ಇಸ್ 11 ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಅಲ್ಲ ಇವಾಗ ಅದಲ್ಲ ಇವಾಗ ಕಲಬುರ್ಗಿ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಲಾಸ್ಟ್ ಥರ್ಡ್ ಡೇ ಬರುತ್ತೆ ಯಾವ ಕಂಡೀಷನ್ ಇರ್ಬಾರ್ದು ಥರ್ಡ್ ಫೈಲ್ ಆದ್ಮೇಲೆ ಥರ್ಡ್ ಬರುತ್ತೆ ಯಾವ್ದು ಒಂದು ಅವ್ರು ಇಟ್ಕೊಳ್ಳಲ್ಲ ಎಲ್ಲ ಫಸ್ಟ್ ಆಗ್ತಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಮಾತ್ರ ಬರಲ್ಲ ಇದೆ ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಫೋರ್ತ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಬೇಡ ಆಟೋ ಲಿಸ್ಟ್ ಬರುತ್ತೆ ಇದು ಸರಿ ಇಲ್ವಾ
Remove my mouse.
126 ಅಡ್ಜನ್ ಆಗಿಲ್ಲ 127 18 9 ಎಸ್ ಎಸ್ ಲಾಸ್ಟ್ ಟಿ ಎಂ ಪಿ ಅದೇ 132 ಡಿಸ್ಮಿಸಲ್ಲು ಆಮೇಲೆ 127 ಅಡ್ಜನ್ 132 ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ 132 127 ಇದು ಗ್ರಂಥ ತರ ಇದೆ ತಿರ್ಸೋ ಅಷ್ಟರಲ್ಲಿ 96 31 8 84 79 86 ಇಲ್ಲ 86 ಇಲ್ಲ 79 57 29 ಅಷ್ಟೇ ಲಿಸ್ಟ್ 2 and 3 ಆದ್ಮೇಲೆ 4 46 24 9 ಅಲ್ಲ ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಫೋರ್ತ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಇದೆಲ್ಲ ಮೋಸ ಇಲ್ಲ Huh?
Court officer.
ಬರ್ಲಿಲ್ವಾ ಅಲ್ಲಿ ಕೇಳಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ನಾವಂತೂ ಮೆಮೊ ಕಳ್ಸಿದೀವಿ ಅವ್ರು ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡಿಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಹೇಳಿ ಸರ್
Court officer, how many matters are there in Kalburgi list?
only one matter sir
Only one matter, because I needed to mention, should I mention after the Kalburgi list or when the court resumes?
before that only mention sir
As soon as the
yes sir
Honorable Court commences
ಇದು
proceedings.
ಎಷ್ಟಿದೆಪ್ಪ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎರಡೇ ಮ್ಯಾಟರ್ ಆದ್ರೂ ಅಷ್ಟೊಂದಿದೆ ಅದರಲ್ಲಿ
But ನಾನು ಮೆನ್ಷನ್ ಮಾಡಬೇಕಾಗಿರೋದು ಬೆಂಗಳೂರು ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್.
ಬಂದ ತಕ್ಷಣ ಮಾಡಿ ಸರ್
ಓಕೆ.
ಎಷ್ಟೊಂದು ಕನೆಕ್ಟೆಡ್ ಇದೆ ಅದ್ರ ಜೊತೆ ಇದು 4 o'clock ಇದು ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್
Lord, may I make one mention?
For yesterday, my lords, senior counsel Vikram Hulgul sir mentioned about the matter to be listed, my lords. It's not listed. The disposed matter, my lords.
It's not listed.
Not listed for hyper committee, my lords. Here, very mentioned.
Tomorrow 2:30 probably.
ನಾಳೆ 2:30
Serial number 23, Milad, it is relating to issue of caste certificate. The purpose of submitting to the KPS.
We will take it up. There are 5 or 6 of them. All 5, 6 is there.
41.
Lord, may I make one mention, Lord?
Yes, Mr. Agade.
Lord, item number 116 in list number 1, Lord, the connected matters, the two types of matters, Lord, they've been connected together.
What is the mentioning that you are making, Mr. Agade?
And my Lord, they are to be connected. Lord, there are number of writ petitions, only few of them are there.
Many more number, give the number, it will get connected.
And two different categories have been connected, my Lord. They'll have to
Get
be
connected.
segregated.
We can't be making orders at the time of mentioning. Give the list. Connect with so and so and relist on.
That will be passed on, Lord. There in the
24th September. Yes.
Obliged, my Lord.
Kalburgi bench matter Naresh V. Kulkarni.
My lord, appearing for the petition.
My lords, I appear for respond number 1 and 2, my lords. The report has been submitted before your lordship, my lords.
Report has been submitted. For the hearing. Order sheet ಕೊಡಿ. So now sites have been allotted.
Yes, my lord. Sites have been allotted, and one of the in fact, 3 petitioners have approached the respondent number 3 and paid the amount. One respondent is on the next week will be going. So if one more week is granted to me.
Why do we need to keep it pending, Mr. Kulkarni?
Yes, ma'am.
Is it required to be kept pending? Make the application, they will do that.
Yes, ma'am. It may be allowed, and as per we have sought for mandamus, and accordingly they are allotted these sites.
A report, status report, has been filed by
Respond number 3.
the ULMS department. The same reads as under. the above is in compliance with the general direction issued and the general direction are complied with. Disposal court. Petitioner is before this court seeking for the following leaves. During pendency of the matter, which of the petitions have been allotted?
My lord, all the four have been allotted. The three of them have already approached the respond number 3 and deposited the amount. Respond number 1,
Which of the three?
uh, petition number 2 to 4.
2 to 4. The pendency of the above matter. Respond number 3 had allotted a site each to each of the petitioners. Petition number 2 to 4 have already made payment of the amounts and the formalities completed. Insofar as petition number 1 is concerned, the allotment having been made, the formalities are yet to be completed. Directing the respondents to complete the formalities, the petition stands disclosed.
Obliged.
Very.
List number 2. Fresh matter, serial number 1. DT Najesh Gowda.
Number 2.
Matters pertains to spam.
Yes, madam.
Lord, communication has gone from our office, my lord. They need some time.
How much more time?
I have personally brought to their notice, my lord.
Who has to come up with this policy? You have been saying you'll come up with the policy.
Home department, my lord. I have communicated PRS also, my lord, today. Concerned minister has to, the SOP is formulated, my lord. It is for
Minister
approval.
has to approve it.
Please,
Serial number 1 and AGA accepts notice for respond. Benefit of the interim order date so and so is extended to the petitioner. Connect with 2. Learned AGA submit that the SOP having been formulated. The said SOP is pending pending approval of the Honorable Minister. She seeks for and is granted.
2 weeks time.
ಯಾವ್ದು ಒಂದು ಡೇಟ್ ಹೇಳಿ ಯಾವತ್ತು ಮುಗಿಸಿ
4 weeks, my lord.
4 weeks time. Released on 29th September.
Obliged.
Serial number 2. Same.
Number 2.1.
List number 3.
List number 2, my lord.
List number 2, same. Everything is the same. 2.12,
2.24 and 2.25.
ಏನು?
Same.
Entire 2 series is that only.
Interim orders are there.
Interim order is 2.9. Why are you not allowing them to open, madam?
4 weeks. I'll instruct them, my lord. I'll instruct.
2.9, Learned Counsel for the petitioner submit that despite the interim orders, the petitioner is not allowed to function. Learned AGA is directed to instruct the concerned to comply with the interim orders.
Please,
2.22. Interim order ilva adರಲ್ಲಿ 2.22 benefit of interim order and so on so is extended to the petitioner. Anything else? Interim order ilva benefit of interim order. ಇದರಲ್ಲಿ ಎಲ್ಲದರಲ್ಲೂ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಯಾವ್ದ್ರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲೋ ಅದು ಹೇಳಿ.
2.12, 2.24 and 39. The respondents not relating to. Despite all the interim orders.
Why only in your case they are not permitting?
No, your options. Different matters.
I'll see.
ಮಾಡಿ ಇಲ್ಲ.
Lordship, 2.16 is a recreational club matter. 2.16.
We did not know. ಏನ್ ಹೇಳಿ?
Lordship,
The whole batch is the same matter. You should.
2.7 entry model is similar.
I'll install.
2.27 entry model.
I'll install.
ಎಲ್ಲರೂ ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದ್ ಸತಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಅದಕ್ಕೆ ಇವಾಗ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರು. Compliance closed, matter disposed.
List number 3, serial number 1, Sirajuddin Ahmad.
Sirajuddin. Yes, madam.
Oksamala.
Okso.
Yes, 6 years, 7 months he has undergone, my lord. This is the first parole he is seeking, my lords. His custody certificate at page number 20, my lords.
10 years imprisonment.
Yes, my lord. His imprisonment is 10 years, my lord.
AGF so and so. 6 years, 7 months, 20 days, highest being 10 years. You've been granted parole for one occasion, na?
Yes, my lord.
One occasion for 3 months. 90 days commencing from 7th or 15th? 7th. 7th September.
Serial number 2, Tejas VK.
The petitioners, my lord. The
Life
custody certificate
imprisonment, my lord. 2 years, 5 months, my lord.
Where the certificate?
14 minutes. Page number 14. My lords, bring to notice page number 17, my lords.
Only been incarcerated for 2 years, 5 months.
Yes, my lords. Page number 17, my lords. Emergency parole. There's a medical certificate.
He'll get medical treatment at the hospital.
My lords, kindly.
The prison. This is not something which requires any major this one.
My lords, kindly page number 23, my lords. He's consistently, he's getting treatment, my lords. He has to get operated. Based on these reports, they get an opinion from Sparsh Hospital, my lord. That is in page number 37.
Get him evaluated, madam.
Yes.
There's surgery required. And AGA accepts notice for response. And AGA is directed to, respond number 3 is directed to constitute a medical board to examine the petitioner and the requirement of surgery, if any. Relist on 3rd.
Serial number 3, KB Monesh Kumar.
My lord, this matter for extension of parole, my lord.
Extension?
Yes.
You have to file it there.
29,
months
8,
aita.
26, he has to serve.
6 months gap aita.
No, my lord. Yes, yes, yes. According to my understanding, 90 days is a cooling period. I leave it to my lords.
Whatever the cooling period
No,
is,
he
you
will
make
surrender and let.
Serial number 1,
has been made is before this court seeking for.
start from 7.
The above petition being for extension of parole, it would be for the petitioner to surrender to the jail authorities and thereafter make necessary application for grant of fresh parole after the cooling off period. Reserving such liberty, petition stands disposed.
Serial number 4, Pradeep Patil.
My lords, in this matter, this is for extension on a medical. He has put on stents, my lord. If we come out now, we'll have to remove stent and come.
Extension.
This matter. The earlier occasion, my lords have granted him the 30 days of time, my lord. This is exception.
This court had granted parole for 30 days on account of medical grounds. A medical report had been placed on at Annexure C indicating that stents have been operation has been carried out with laser lithotripsy and DJ stenting. The submission made by the counsel for the petitioner is that the detainee would require continuous monitoring for a further period of how long?
My lords, earlier, my lords have granted 30 days. I have
monitoring ಎಷ್ಟು ದಿನಕ್ಕೆ?
My lords, for safer side, I'll take 60 days, my lord, in this matter. Because this is an exceptional case.
Safer side would require monitoring. Hence, 60 days from. We have, when is the earlier this one coming to an end?
My lord, on 1st of September, my lord.
Commencing from 1st of September. It is explicitly made clear that in view of the extension order, the detainee would not be required to surrender to the prison authorities on 1st September when the earlier parole granted by this court comes to an end.
Biplab, please.
5, Pratap SS.
My lord, this matter for premature release, my I have placed
Approve
on
ಆಗಿದೆಯಾ?
record, the board has recommended, my lord.
Board is recommended.
At page number 10, serial number 32, I have mentioned this. Mr. Krishnappa Tande Dasappa.
Is recommended 90 days commencing from 7 September.
Obliged.
Serial number 6,
Yes.
He is in custody for 7 years now. Earlier, my lord, he has been granted a interim bail for 37 days, and he has not misused that liberty, my lord, which has been granted by the.
Imprisonment for
Kindly come to
20
page number
years,
13, my lord.
20 years, 6 years, 9 months. We've been granted parole?
Parole, no, my lord. He has not filed any parole application, my lord. This is the first time, my lord, but he has been granted interim bail,
Interim
my lord,
bail
for
was-
34 days.
That is different.
My lord, kindly come to page number 13, my lord.
3 days commencing from 7 September.
Much.
serial number 7,
Extension.
In extension, medical grounds or
No,
then you
allowed.
surrender and after surrender after cooling period.
At the next serial number is same, my lord. And serial number 17
Cooling
also.
period, liberty reserved.
And serial number 17 as well, my lord.
17 same order.
Obliged.
serial number 9,
Mr. Aditya? What is this one?
Filed on 12 to 26, my lord. It's decided for the house repair. It's deciding in Tamil Nadu, my lord. First, we have sent requested for the report from police station.
House repair is in Tamil Nadu.
Yes, my lord. They have directed us to seek the report from Vellore police station, my lord. We are waiting.
No, outside the jurisdiction can't be granted. None appears for the petitioner, learned AGA. But it's served, no, it's served, access notice. Access notice for respondent number 1 to 3. And AG on instruction submitted the house that the petitioner seeks for repairing is situated outside the jurisdiction of this court. Released on 3rd September.
10,
Kiran? What about this?
Petitioner, my lord. This is general parole, my lord. Custody
In
certificate.
ground in agriculture activity. No?
Yes, my lord. Custody certificate.
Why was it rejected?
My lord, we applied on 16th.
Rejection order illa?
My lord, we applied, my lord. Application is still pending, my lord.
Consider it.
16th.
Application for parole is still pending. Directed to consider the said application and pass necessary orders within 15 days from date of receipt of a copy of this order.
Much.
B group matter, serial number 11, Sirajuddin Ahmad.
Yes.
That's in the last date of hearing, application was handed. Application, I have handed.
The court has directed us to clarify whether he has filed a parole application after cooling period. It is submitted, but police rejected, my lord. Last time I had submitted, he has filed before 6-month cooling period. After cooling period, he had submitted it, my lord. That's rejected. Police,
Rejected for what reason?
police has rejected, my lord.
Same, usual. And then now anyway, we have directed you to do that. We'll get the full list. Rejected. No reason. You had been granted parole earlier?
Yes, my lord.
In December, he was granted, my lord.
Granted parole twice for a period of 90 days each. Cooling off period having been completed, commencing from 3rd, 90 days.
12, Rakshita.
Which I appear for the petitioner, my lords, which I seek for a week time, my lords. They had to file objection, my lords. We will do. If they file objection.
Parole ಅಲ್ಲಿ ಈ ಕಡೆ ಟೈಮ್ ಕೆಡೋರು ಕಮ್ಮಿ.
Only objection in this, my lord. He has committed a crime in the prison, my lord.
He's committed a crime.
In the imprisonment certificate under
In what crime has he committed?
possession of ganja, my lord. Under 42 of Prisons Act and 27.
How did ganja find the way into your prison? File your objection, we'll direct an inquiry. Ganja, mobile phones, all.
Yes, 27-2, my lord, and 42 of Prisons Act.
Have you filed your objections? You have not filed. You have been authorized to make that submission that.
My lord, it's in the imprisonment,
Idea.
my lord. It's in the imprisonment certificate also, my lord. The pending case, the second one. He has 3 pending cases, my lord.
2 pending cases. Page 11 of the.
No, not aware.
42 of Prisons Act, 22B of NDPS. The peril of the imprisonment certificate indicates that during the time that the petitioner was incarcerated, an offence has been committed by the petitioner to 424 IPC, read with 42 Prisons Act and 21 bracket small b and 22 bracket small b of the NDPS Act. It is rather shocking that such an offence could have been committed or alleged to have been committed in the prison. Hence, respondent number 1 as also Director General prisons are directed to look into the matter and submit a report by next date after inquiry. The remainder of life doesn't mean that he won't get parole. He won't be eligible for premature release.
Parole also is not eligible. Reminder of life is there.
Supreme Court clarify ಮಾಡಿದೆಯಲ್ಲಪ್ಪ.
I'll clarify.
None appears for the petitioner. Released on 24th September.
14, Lakshmikant K.
I'm for the petitioner, madam.
Yes.
Madam. Meaning page number 9, madam. The rejection order. Parole matter.
Page 9.
Page 9. Him and the petitioner are one day
Certificate
village
ಅಲ್ಲಿ.
anta.
Where is the imprisonment certificate?
Imprisonment annexure C, page number 11, madam. He has already spent time about 5 years, 10 months, madam.
5 years, 10 months, 9 days. 30 days. First time parole, huh?
Also,
Commencing from 7th. 30 days.
grateful.
15, Aditya SK.
So the petitioner had to submit the bail obtained copies. My lords, there are 2 pending cases, my lords. Page 6.
Get instructions. A memo along with copies of the orders in 4 matters has been placed on record. Learned AGA. See, a copy thereof has been served on learned AGA. Seeks for a week's time to obtain instruction, make a submission. Released on 3rd.
Please.
16, Satish Kumar.
Emergency parole for 60 days, my lords. On last date, my lords have directed the AGA to submit imprisonment certificate, my lords. Since we could not obtain. There is emergency since our wife is suffering from uterus problems, my lords. That is at page number 10, my lords. And also, since he is the only bread earner, my lords.
302. 1 year, 8 months.
Lords, kindly come to page number 10, my lords, for a moment.
Cannot be granted.
Since he is an agriculturist, he is the only one person, my lords.
That he should have thought of before committing the offense, not now.
And also he has two children, my lords. There is no one to look at since our wife is suffering from uterus bulk, my lords. She cannot go and
Then
do
why did you commit murder?
emergency 60 days, my lords, for sowing season.
Rejected, Mr. Counsel. Petitioner is before this court seeking for the following leaves. Wife of
Kindly pass over, my lords.
is only served 1 year, 8 months, 3 days. We rejected, reserving liberty to approach this court after serving substantial portion of the sentence.
18, Vijay Prasad.
Yes, Vijay?
For the petitioner, my lordship.
Hmm?
Filing the endorsement certificate, my lordship.
Filing
They
the?
have rejected the parole, my lordship. So the
Rejected.
endorsement certificate I have filed an amendment. It's a copy.
Why was it rejected?
There was another pending matter, my lordship, which has been stayed by the Honorable High Court. And as far as
When was that offense committed?
my lordship, when he was in the prison, he was implicated for 302, my lordship.
Implicated for?
302, when he was inside the prison.
143, 148.
My lordship, imprisoned certificate is in page number 8, my lordship.
He's already been granted parole earlier.
Yes, granted parole, my lord. Last surrender date is 27/2/2026, my lord.
So today, 6 months are over.
But today is 6 months ago. And he had gone on emergency parole on 10/7, my lord. The case, the next date of hearing was on 13/10, my lord. That is the reason they have rejected the parole. The pending case, SC 665, and he has been convicted for 3 cases, 3 convictions, my lord. As per the parole rules, they are not eligible, my lord, if they have 3 convictions. We have to follow.
My lordship, I would like to draw your kind
He's
attention to
been
page 20.
imprisoned. It's not a matter of right. Those matters we rejected. 13 years he's been there. You can't correlate them. In 13 years, 1 month, 21 days had been granted parole. General parole on 4 earlier occasions, court parole on 3 occasions, and emergency parole on 7 occasions. The only ground on which it is rejected was that there is a pendency of another criminal proceedings in SC number 665 of 2010 for offences under section 143, 148, 302, 120B of the IPC. I mean, granted parole on 14 occasions when there is no complaint against the petitioner. It ought not to have been rejected this time. 90 days commencing from 7th September.
Grateful, my lordship.
19, Sirajuddin Ahmad.
Undergone 90 years, 19 years.
19 years?
Yes, 19. The Lordship has earlier granted parole and they were placed before the LCRC committee, my lords. And the LCRC has rejected stating that there is a pending case. The pending case is of 2005, my lords. It is almost 21 years has been lapsed. That is 380, my lords.
Yeah, why are you before us? On LCRC or parole?
For parole, my lord, till the LCRC.
When was the last parole?
December 25, my lords.
He was surrendered on 14/7/2026. This court has granted him the parole and he has surrendered on 14/7/2026.
My lords, this court has granted 90 days, have passed on the order, my lords, on 21st
When was the
December.
last parole, Mr. Sirajuddin?
Last parole is on December 25th, 1st December 2025, my lords.
So what is this 14/7?
Surrendered on 14/7, my lord. That's my instruction, my lord. And the LCRC committee has rejected his remittal.
That he has to challenge. He is
Yes.
here only for parole.
Yes, that I have challenged, my lords. That is the challenge at annexure A, my lords.
Your prayer is only for release the petitioner's brother on general parole till committee considers the premature.
Premature
release.
release.
Till considers, aste.
Yes, my lord.
You are not challenged it.
My lords, only I should mention that to set aside the endorsement. That's all, my lord. But
We
my
can't
prayer,
tell you what.
My prayer is in the prayer itself is same, my lord. Because your lordship, he has
We
already
can't
undergone
grant you
his
parole.
entitled.
We can't grant you parole if you are surrendered on 14/7. You'll have to wait for 6 months.
That's after the coordinate bench has observed that after 14 years, no cooling period will come in the way for grant of parole because
Give
already
us the
14 years.
judgment.
The date may begin. I will give the
The request of counsel for the petitioner released on 17th September.
20, Naveen Jain.
I'm looking for petitioner, my lord. I'm seeking general
Under
parole.
process, my lord. Because they have given the wife has given the application on 37, my lord. They have taken the form application from the prisoner, my lord. It's still under process, my lord.
So when will you,
The 2 weeks time, my lord. Okay.
before this court seeking for the following?
That
notice?
is-
And AG on instruction submit that the application is being processed, given 2 weeks time, necessary orders will be passed. Placing the said submission on record, petition stands disposed. Much obliged.
230 matters, list number 4. Admission, serial number 1, Bhargav D. Bhatt.
Counsel's name was directed to be shown on the last occasion. Akiva.
Mr. Sangamesh Nawadgi.
Why are they not appearing? Email ಕಳಿಸಿದ್ದೀನಿ, I filed the email acknowledgement.
Yes, where is the arbitration clause?
There are 3 agreements, my lords.
Hmm.
First arbitration clause, my lords will find on page number 62.
62.
There's one lease agreement, there is one warehouse lease agreement, and there is one loan agreement. All 3 are interconnected, my lords.
62 first.
62, my
What is
lords,
this agreement?
2.12, Article 26.
What is this agreement?
This is the lease agreement which was registered, then subsequently amendment was made to the lease agreement by way of another registered document. In that, the arbitration clause has been
This is a
incorporated.
deed of amendment, this is.
Yes, the original deed is on page number 17.
17. So where is the arbitration clause in that?
In that, it's not there. In the amendment, it's added. By virtue of the amendment, it's added. Article 26 C. Upon issuance of an arbitration notice, the dispute shall be referred to a panel of 3 arbitrators, all of whom such shall comprise of retired district or high court judges, one of whom shall be nominated by the claimant, one of whom shall be nominated by the respondent, the presiding arbitrator who shall be nominated by 2 arbitrators so nominated. The arbitral proceeding shall be conducted in accordance with the provisions of the Arbitration and Conciliation Act as amended from time to time. The seat and venue of arbitration shall notice, my lords, is on page number 139. Paragraph number 22, page number 145. Paragraph 22.
Page?
Page 145. Paragraph number 22. We are further instructed to inform you that our client proposes to appoint
This
Mr.
is
Soul.
your nominee arbitrator. No reply.
No reply. No.
Oh.
Lords, there is, however, my lords, a catch in this. Like I said, my lords, there are 3 agreements.
You've shown us.
I showed my lords one agreement. The second agreement, my lords will find the arbitration clause on page number 96. 96 2.13 C, same arbitration clause.
This is also by way of amendment.
This is also by way of amendment, subsequently included 96 2.13 and C.
Yes.
And then the catch, my lords, is here. Then there is a last loan agreement. That the arbitration clause is on page number 103. Clause 9. There is a problem. But they are very interconnected. And the loan agreement was supposed to be set off as against the rental dues. That is the arrangement that was arrived at.
Then you will have to approach the HKIC.
My lords, then I've prepared a memo, my lords. I will not press insofar as this agreement is concerned, leaving my remedies open in respect of the other 2 agreements. Arbitrator may be appointed. And the consolidated arbitration, my lords, it's permitted. That is a judgment to that effect.
So why don't you approach HKIC for arbitration of all 3 together?
Not there. There is India and Bangalore. I don't have HKIC there. They have made the agreement in such a way, my lords, the client is in a catch-22. That's why I was hoping, my lord, that my learned friend will be here and there could have been some consent
He
in appointing.
consents, then yes. Otherwise,
That is one issue, my lord. The second issue, I was hoping that my learned friend would be there is a panel of 3 arbitrators for a dispute of about 80 lakhs. That also may not be financially viable at all for the client.
going to HKIC is also not viable.
It's not. In fact, under the loan agreement, it's only some 18 lakhs. This
We'll
claim
have
is.
it 2 weeks later, see if he can come.
ಅಪಾಯಿಂಟ್ ಆಗ್ಬಿಡ್ಲಿ ಪರವಾಗಿಲ್ಲ 2 ಅಗ್ರಿಮೆಂಟ್ಗೆ ಅಪಾಯಿಂಟ್ ಆಗ್ಬಿಡ್ಲಿ ಮತ್ತೆ ಅದು
If there is no arbitration, you will get into trouble later if the third one is not there.
not third one I'm not pressing at all. I will file a memo. I have
You're
instruction.
not pressing for now, that can be held against you.
Not eventually I'll have to hold it.
Just speak to him and ask him to come so that if he consents, then we can appoint by consent.
Yes, my lord. In fact, the way
None appears for respond, relist on 10th September.
Serial number 2, G. Suresh.
Thank you for responding, my lords.
Petitioner, my lord.
Yes.
My lords, one submission.
Hmm.
We're finding little difficulty to procure the relied upon documents with regard to the departmental administrative issues, my lords. I kindly seek another short adjournment to procure.
We'll
this.
allow it. If you don't have the papers, how did you initiate action?
Please, my lords. Due to some administrative issues, my lords, because the officer, the concerned officer for the case is actually transferred. And because of that, we are facing some issues.
Already taken sufficient time, my lord.
Just seeking for one last short adjournment.
One last adjournment.
Please.
And counsel for respondent seeks for and is granted 2 weeks time finally. It's made clear that no further adjournment would be granted. Relist on 10th September.
Much better.
Serial number 3, Varun Kumar and connected matter.
DRT.
My lord,
Connected with GMRE.
I complied that order, my lord, regarding I paid DCF 100 rupees I paid on 1/4/18/2026.
26 rupees extra you have paid.
ಮತ್ತೆ
Who is respondent number 1? Respondent number 1 and 2 yaar.
Hinduja Housing.
I had and summons also served.
Hinduja Housing Finance, there's no counsel who appears?
ಇಲ್ಲ ಸುಮ್ನೆ ಅದಕ್ಕೆ hand summons also this honorable court passed the order. I served the hand summons also. I filed in the office, same as not put up, my lord, by mistake.
Counsel for the petitioner submit that the deficit process fee has been paid on
1/8/2026.
1/8/26.
And the hand summons returned also, that same also produced.
And summons,
Acknowledgement also.
you're filing an affidavit also?
No, my lord, the hand summons, yes, I returned that.
Affidavit of the person who was served. Adu kodbekala.
Yes, my lord,
You're filing the affidavit.
affidavit not filed, my lord. Just
Counsel for the
acknowledgement.
petitioner submit that you would also be filing necessary affidavit of having served the hand summons. So, since process fee has been paid, registry is directed to issue notice to unserved respondent number 1 and 2, returnable by 28th September.
My lord, in this connected senior citizen petition, next matter is there. My lord, that is the same, it came to be taken disposal, my lord, because I'm a widow. My son.
Without service of notice, how can we take it?
My lord, my son has obtained a loan. I paid amount 3 lakh by mortgaging my gold ornaments. Now, in that second writ petition, he has undertaken to going to pay that entire EMI, but he has not complied that.
Without the service, can we take it up one?
Yes, my lord.
Service ಆಗಬೇಕು.
ಆಯ್ತು. Interim order.
Immediate notice returnable by 28th September. Interim order earlier granted is extended till next date of hearing.
Another second writ petition ಅಲ್ಲಿ ಐವೋ ಇದೆ my lords. That may be.
Interim order in both the matters.
ಅಲ್ಲ ಅದನ್ನ ಸಪರೇಟ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ, ಅದನ್ನ ಫೈನಲ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು ಅದನ್ನ.
ನೀವೇ ಕನೆಕ್ಟ್ ಮಾಡಿಸಿರೋದು ಇವಾಗ ಸಪರೇಟ್ ಎಂತದ್ದು?
ಅಲ್ಲ ಅನ್ನೆಸೆಸರಿ ಮೆಂಟಲ್
ಸಪರೇಟ್ ಮಾಡಿ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ದಕ್ಕೆ ಎರಡು ಇಲ್ಲಿ ಬಂದಿದೆ.
But they are not complying that affidavit filed by them, my lord, regarding the payment of EMI.
You're not.
Today he paid, my lords. Up to date EMI
Counsel
has
for
been paid, my
respondent is
lords.
directed to place on record by next date of hearing
Yes,
the details of the amounts which have been paid by the petitioner to the concerned financial institution as regard the payment of the monthly EMIs with proof thereof by the next date of hearing.
None amount, none, 2.5 lakh I paid on behalf of.
My lord, so even today she is in possession. my
EMI
lord. That
ಆದ್ರೂ
is what
ಬರತ್ತಲ್ಲ.
question. Grateful, my lord.
Further hearing, serial number 4. Srikara PK.
So happy for public premises matters, my lord. Your lordship on last day it said we will be
1 year.
for 1 year and payment of arrears by 8 months. Only request payment of arrears also may be permitted within a period of 1 year, my lord.
It will have to be before.
At least 10 months, my lord.
It has to be before.
Inila.
That is why we told you.
I agree. For them, the income per month ಇಂತ ಇದು 5 times ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ.
ನೀವು ಅವ್ರ 3 ತಿಂಗಳಲ್ಲಿ ಇದ್ರೆ ನಾವು 1 ವರ್ಷ ಕೊಡ್ತೀವಿ. ಇನ್ನು ಅದ್ರಲ್ಲೂ if your clients become
No, my lord. I personally I cannot say anything.
Mr. Ravi Shankar accepted so
I agree,
graciously.
I agree, my lord. I personally cannot say anything on that.
He is accepted. We should not push it. Really, where is your joint memos?
ಜಾಯಿಂಟ್ ಮೆಮೋ ಅಲ್ಲ, ಅಫಿಡವಿಟ್ ನಾನು ಹಾಕಿದ್ದೆ ಲಾಸ್ಟ್ ಟೈಮ್.
ಅದರಲ್ಲಿ ಬರ್ದಿದ್ದೀರಾ ಇದೆಲ್ಲ ಪೇಮೆಂಟ್ ಎಲ್ಲ ಬರ್ದಿದ್ದೀರಾ?
ಎಲ್ಲ 1 ವರ್ಷ ಅದು 2 ವರ್ಷದಲ್ಲಿ ಮಾಡ್ತೀವಿ ಅಂತ ನಾವು ಅಫಿಡವಿಟ್
ರೀವರ್ಕ್ ಮಾಡ್ಬೇಕಲ್ಲಪ್ಪ. 8 months and 1 year ಅಂತ.
ಆಗ್ಬೋದು ಸರ್, ಆಗ್ಬೋದು.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ?
ಮುಂದಿನ ವಾರ ಹಾಕ್ತೀನಿ. ಅವರು ರವಿಶಂಕರ್ ಅವರು ಇದು ಬರ್ಬೇಕಾದ್ರೆ ಜಾಯಿಂಟ್ ಮೆಮೋ.
He's on his legs on other court. My senior is on his legs on another court, my lords.
You are here. Counsel for the petitioner submit that a revised affidavit would be filed indicating that the petitioners would vacate the premises without demur and raising any issues within 1 year from today, and all the balance amounts will be paid within 8 months from today. He seeks for a week's time to file such revised affidavit, pre-list on 7th September.
Small submission. I told the parties, they said they want to submit something. I said I am submitting, it's not proper.
They may lose what is there now.
I know that. What to do? I had to.
Yes, agreed, gracious.
I agree. Obliged.
Serial number 5. Ravi Shankar.
Interim order may be extended.
Interim order is extended.
This
My
case,
lords,
the respondent
filing
number
memo.
4, my lords.
Reporting the death of respondent number 4, my lords.
On 19/8/2026, my lords, the respondent number mother of the petitioner died, my lord.
Within in what service? A bit.
Please, my lord. Another sister is there, my lords. I will bring a party to the petition.
The memo has been filed reporting death of respondent number 4. Counsel for the petitioner seeks for and is granted 3 weeks time to file necessary application. Relist on 22nd September.
Please.
Serial number 6. A.V. Amarnathan.
Also interim order may extend.
Interim order earlier granted.
Petitioner, my lord.
Appearing for
Yes, who appears for the state?
respondent number 6 to 8, my lord.
Yes. Ready? Last time ಏನೋ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರೆ ಆಮೇಲೆ
Jafar is handling this.
where is Jafar?
He'll come here.
ಮತ್ತೆ ಪಾಸ್ವರ್ಡ್ ಆದ್ರೆ ರೀಚ್ ಆಗಲ್ಲಮ್ಮ.
He had appeared, ADLR, AGA Bopanna had appeared in this matter, my lord. ADLR report was supposed to be filed. I think previous.
Who is going to appear? He is not there.
Kindly pass.
So it won't reach again. They'll have to wait only.
Tomorrow, my lord.
So tomorrow we'll
Please,
have ask him to be
please.
here. 6 at the request of learned AG, release tomorrow at 2:30 p.m.
May I request for day after, ma'am?
Day after tomorrow,
No trouble.
29.
7.
Yes, Mr. Karthikeyan.
For the respondent number 4, ma'am.
Layout owner is here.
Yes.
Mr. Karthikeyan. Have they taken any action?
Appear for BS Karthikeyan in this matter. Well, as far as East City Corporation is concerned, they've started taking action. Notices have been issued to the respective PGs and for they're awaiting responses from the PGs. In respect of other city corporations, West we had filed the report. There are some more in North one. That's it.
When will you file that?
With respect to North, my lord, they have already filed in
on 13/2/2026, they have filed the report. But till today, they have not taken action, my lord. And last occasion, your lordship had directed to take action, my lord. Till today, they have not taken action.
So you'll have to place
Illegally,
on
they are
record how
running,
many
Malad.
actions you have taken, this oral submission.
I'll place it on record.
That counsel for
Without
respondent
license, my
number
lord,
1
they are running the PG. Without license, without permission, they are running the license. In view of the writ petition, they are taking.
for respondent number 1 to 3 submits that action has been taken by East Corporation. And insofar as the other corporation are concerned, the action is being processed.
Yes, ma'am. And in respect of North as well, we have issued notices before conducting the inspection.
North and East action has been taken. In respect of the other corporations, the action is under process. He is directed to place on record the details of the action taken in respect of all the corporation by next hearing. Relist on 10th September.
Great.
Serial number 8. Siri Rajshekar.
Let's, last occasion,
The new notification.
now there is a gazette notification, my lords, which the lordship will find that page number 4, my lords. That, my lords, 3, my lords, in the principal rules in rule 86 after sub-rule 3, the following sub-rule shall be inserted, namely, independent fireworks or independent fireworks shop shall maintain a minimum clearance of 3 meters to open sky from any adjacent structure or building. Fire shop, the fire shop shall maintain a minimum clear distance of 50 meters from educational institution, hospital, medical diagnostic center, and religious places. My lords, for that is an exception, my lords. Exception, the provisions of sub-rule 4 and 5 shall not apply to the existing fireworks shops covered under the licensed form LE5, my lords.
Why do you make this exception, madam? What is the point in doing this exception?
Instructions are, my lords, from you're covered within that.
They'll be very happy if you make these exceptions.
But the exception also, my lord, it is not that they are not bound. They also have to follow the rule 112 also, my lord. There's a safety precaution which has been also laid down.
Yes,
So
that
they
is
have
fine.
to follow so far
Namely,
as.
so and so anta ella kottidirali.
Please, my lords, please.
But now this one, as what we noticed, is abutting. They share the same compound wall or the wall of that building.
In this, what happens, my lord, it is not the central government which has issued the license. It's the state government which has issued the license to the petitioner. So
This by the central government.
this is the central government notification, my lord. My instructions are, my lord, the deputy chief controller of explosives have not granted a license to the petitioners here.
My lords, it is the district magistrate.
That becomes a formality now.
Please, my lord, so that the instructions are, my lord, so far as these notifications, the amendment will be applicable on the date, my lord, from 2/3/2026, my lord. That's the instructions, and provided that, my lord, the existing parameters which has been stipulated under rule 112 has to be followed.
They'll follow that.
We have followed that, my lords. As such, we were granted the license, my lords.
They are only worried about
2023.
the space,
Please, my lord, that's
because that is the one which is premium. And you have given them a.
This has to be.
My lords, they only rely on some guidelines framed by them, my lords, that they don't have the power to make such guidelines, my lords. It has been held by
One
the
exception,
Allahabad
my lords.
High Court also, my lords.
You're ready to address arguments on that, or what do you want to do now?
My lords, your lordship may have this matter on 3rd, my lords. I'll address the arguments.
Request of counsel for the petitioner relist on 3rd.
Serial number 9.
And the substantial progress. There has been. It's got down to progress.
Well, it is not to find fault with anybody, but the next date before the learning mediator is 7. So, 7. So, probably it is likely to close. But we also have their proposal, our counter proposal. Some people will be pitched in court. We are ready, we are ready to close it at any point.
My lord, for the respondent, my lord.
Yes, Mr. Ajesh.
My lord, we as learned counsel for the petitioner submitted, we are quite close, my lord, and I hope in the next few days we should be able to reach a.
You will be able to close, you need intervention from the court, or you'll
My
be
lord, I
closed.
think Mr. Umesh is leading the way, my lord.
Mr. Umesh,
Well, it's-
Gautam,
my lords, the proposal that was given by us and the counter proposal which was given by them, there is a substantial gap, there is no dispute. But today, my lords, we are willing to come to their counter proposal and close it, my lords, with a little bit of negotiation. Either it can be before the learned mediator, or, my lords, if Sajesh,
what do you want? You want it to be taken up after 7th, or you want to disclose your proposal, counter proposal?
we can disclose the proposal and counter proposal, my lords. What they have given, what we have said, we have no objection.
Then
It's
could
up
it
to
be
you.
tomorrow, my lord?
Want it to be before the Swan, it is different. If you
My
want
lords,
it
I don't, because since Mr. Adesh is not here personally, I don't want to take
I
him
just had
by
a
surprise
bad
on
throat.
anything.
That's why I couldn't come.
So it's on 7th, so 10 days from now.
Yes, sir. We want to close it all of us want to, my lords.
You need to close it because they need to get
My lords,
possession.
it is, my lords. We all want to close it, my lords. It's in all our interest. Let me say that.
But if we can close it today, then they'll get possession
My
immediately.
lords, could I then, my lords, just share what their
Yes, Mr. Ajesh, do we ask for it or do we wait till 7th?
My lord, it could be waited till 7th or even tomorrow, my lord, because I would like to explain my stance. If they are disclosing.
Then we'll have it tomorrow
very
because
well, my lord, very well. I will come.
Yes,
today again 4 of them are purchasers are here. It
yes,
is
ma'am.
not,
Yes, yes, ma'am.
if it is some minor thing, let us close it and finish it.
Please, ma'am. Please, ma'am.
If it's a larger thing, we'll wait for the mediator to try and
Yes. Or could it be
get
taken on
more
Monday,
sense
my
into
lord?
both of you.
Instead of tomorrow, Monday, my lord? Monday.
Monday?
Monday.
Oh, just one minute. Don't be in a hurry. This is not McDonald's, please. They have been having their dispute for so many years. At least they have now said substantial. So now only small little is there. If they sort it out by Monday, it is good.
Yes, my lord.
Monday.
Great.
One solution,
Hmm. What is the consolidated?
consolidated.
Monday. In the meantime, Monday, let us try to use Mr. Rajesh one to last time.
This is again very general. This is 6/5/26. Issued on 6/5/26 before all these issues came up and you resolved them. Those issues also have to be part of it. As to if the Aadhaar is of the owner, here somebody else's power of attorney did it and then you have cancelled it. Those aspects are not covered here. See, your process should be such that your process should be such that there is minimum litigation. Firstly, minimum misuse, then minimum litigation.
Detailed one,
A detailed one, because now look at the situation, because your rules are so vague. Somebody used or misused or abused 150 people who have paid money are stuck. Their entire family cannot occupy the premises because there's no kata. The bank will not. There's so many implications. So not only these two, you are equally to blame for this mess. At least they have some financial motive. What motive is there for you? You have to put it properly so that they don't misuse it. So this is so vague. They're like, e-kata is so and so. Ashta. What is e-kata ಅಂತ explain ಮಾಡಿರೋದು. Please, this is not, you won't keep your special commissioner present on next day through VC, we'll explain to him what we feel of this, so that he can do a better draft of it at least. Policy has to be done properly. Because this is the second time you're filing and second time same issue is coming.
It was already made, this particular part, so I thought I could share.
You have to be, you see, there are, law always follows, you have to adapt. That changes have to be made from time to time. If it has already been made and you continue to be at that, then a lot of people will suffer. Once you saw that there is a loophole which has been misused, you should cover that loophole immediately. So at least that loophole is not available. Please keep him present on Monday. We'll explain to him. If you file a better thing by Monday, fine. If not, no, it's nothing for, so you'll also understand what the issues are. You may not know what matters come up before us, the tax matters which have come before us, all these things where we are, all these are related. If a comprehensive outlook is taken on the policy level, this will be sorted out.
Give an opportunity. Please give an
Monday.
opportunity. We'll file it and
Keep him present, it doesn't matter.
My lord, I've just messaged the mediator also, so that because of his assistance and guidance, we've progressed so far. So I was just thinking, my lord, instead of Monday, could it be Tuesday, my lord? Because if he is traveling, that's what he had told both of us, so that I've requested him for a VC hearing, so that we both can, instead of
When
Monday.
did this matter then?
This Tuesday, my lord, only
Tuesday.
Tuesday.
Both the councils submit that they are close to a settlement. And if the matter is taken up on 2nd, on the 1st September, they are likely to report a settlement. A memo has been filed by the Council for the Corporation enclosing a letter addressed by the Special Commissioner Revenue and IT dated 6/5/26 to indicate that this is the methodology which will be followed for the purpose of registration of e-kata, even in respect of apartment buildings. A perusal of the said letter indicates that it's only an introduction to a e-kata system and not the manner and methodology of application, dealing with the application, processing the application, finally issuing the application. There being numerous issues which have arisen from the as regards the e-kata system, it is required that these are to be resolved as and when they arise, proactively if possible, if not proactively, on coming to know of the issues that have arisen. The e-kata system, this court is conscious of the fact that the e-kata system is a new system which has been introduced, and there would be several teething problems in respect of the said system. However, that would not mean that the learnings from the system, when there is an abuse or misuse of the system, is not addressed immediately and letting the loophole persist for further abuse and misuse. Hence, the Special Commissioner, Revenue and IT, is requested to look into the matter and make his submissions by next date. He is requested to be present through video conference on 1st September. Interim orders wherever granted are extended till next day.
Serial number 10.
Pertains to the interstate powers of the police in investigating, my lords. The crime comes to be registered in Maharashtra. My lords, I'm a distributor in Tumkur, in pan masala and other products. Now, my lords, the Maharashtra police, through Vadgaon police station, they come and conduct search and seizures in Tumkur. Now, my lords, on the last occasion, my lords, that specifically directed...
What are the provisions?
Provisions, my lords. My lords, I have also prepared an outline note on this. My lords, under the CRPC or the BNSS, my lords, there is absolutely no bar for a foreign state police to come into the home state, a visiting state to come into the home state. But my lords, the code is designed such that there are safeguards at every stage, my lords, whether it be at arrest, at a stage of seizure, or at the stage of visiting, my lords. Now, my lords, the scheme of the constitutional scheme itself is such, my lords, that police comes under the state list. My lords, item 2 of the state list. So far as, my lords, criminal procedural laws are concerned, they come under the concurrent list. My lords, entry 80 of list 1 carves out an exception saying that when any other state has to visit another state police, then, my lords, the consent of that state is required.
Constitution.
No, my lords, if I may just
there in the
place the relevant entries first.
Entry?
If my lords may kindly have entry 80 of list 1. Extension, my lords, has entry 80.
Yes.
Extension of powers and jurisdiction of members of a police force belonging to any state in an area outside that state, but not so as to enable the police of one state to exercise powers and jurisdiction in any area outside that state without the consent of the government of the state in which such area is situated. Extension of the powers and jurisdiction of the members of a police force belonging to any state to railway areas outside that state. My lords, this is traditionally what is understood in the CBI context, my lords. But though there is another specific entry for CBI, that, my lords, would also have at entry 8. CBI specifically come, CBI, NIA, those acts specifically come under entry 8 of list 1. But, my lords, the consent comes under 80.
Yes.
Now, my lords, so far as the state list is concerned, if my lords may kindly have
entry 8 will not be applicable. Because
entry 8 is not applicable, my
will
lords.
not be
Entry 8 is not applicable.
members of police force belonging to any state.
My lords, but when permission is granted to CBI to come into another state, it comes through entry 80, my lords. So let us take a hypothetical situation where the central government enacts a particular law for Karnataka saying that the southern states are empowered by taking consent of the state of Karnataka. Then, my lords, the law could be enacted by the central government under entry 80. Today, there is admittedly no law like that, my lords. There is no dispute on that. So, my lords, what actually governs the field is, so far as state police is concerned, it comes under entry 2 of list 2. Police subject to the provisions of 2A. Then, my lords, may kindly have the concurrent list. Entries 1 and 2. Criminal law, my lords, has
yes.
Criminal law, including all matters included in the penal code to the commencement of this constitution, but excluding offences against laws with respect to any matter specified in list 1 and list 2, and excluding the use of naval, military, air force, so on. 2 is also important. Criminal procedures, including all matters in the CRPC at the commencement of the Constitution. So, my lords, the BNSS or the CRPC traces its powers exclusively to the concurrent list entry 2, being criminal procedural laws. So far as a state police of any state is concerned, its powers are restricted to entry 2 of list 2. My lords, there is only that limited exception carved out under entry 80 of list 1, subject to the consent of a state if a law is made by the union government to permit a visiting state to come into another state to come into a visiting state. This is the constitutional scheme, my lords.
So even if it's a neighboring state,
yes,
neighboring district, neighboring taluka, they cannot come.
No, they cannot come, my lords. In fact, this is, my lords, what is happening today, my lords, and we did some research on this. As a matter of convenience, my lords, many police, be it our police or their police, they come into another state, into a visiting state, conduct their procedure and go back. My lords, but that actually they are a citizen. They don't have police authority. When they come into another state,
suppose a offense is committed on the border of between two districts, between two states, and the offense is committed at the one border, and if that police is chasing him and he enters the border in the other state, he has to say bye bye. Sorry, I can't follow you.
There 45 of CRPC BNSS carves out an exception. On a chase you can go, but there are safeguards where you produce him before the magistrate and you take the local police into consent. I've dealt with that, Malad. In my note, I'll just come. All those situations have been dealt with. Now, my lords, 2 judgments of the Supreme Court dealt with the entries. My lords, from my note itself, I won't trouble my lords with the judgment compilation. From the note itself.
This was the trailer, is it?
Yes. I heard a lot of people not very happy.
It will not be, will not be. You face the ire later. Yes.
My lords, now, my lords, in the case of Bhavesh Jayanti Lakhani, that was an extradition case. My lords, where a person had to be extradited, but what the Supreme Court says at para 95, the police power of the state in respect of any offense committed in a state comes within the legislative competence of the state. The state may exercise some extraterritorial jurisdiction only if a part of the offense is committed in the state and the other part in another state or some other state. In such an event, the state before an investigating officer to that part of the offense which has been committed in any state may have to proceed with the consent of the state concerned or must work with the police of the other state. It is jurisdiction over the investigation into a matter is limited. Keeping in view various entries contained in list 1 of the 7th schedule of the Constitution, there cannot be any doubt whatsoever that in the matter of investigation of the matter committed in a state, the jurisdiction of the central government is excluded. Then, my lords, in the judgment of West Bengal, this is, my lords, the judgment on CBI. The issue there was whether court under 226 can direct CBI investigation or not. The answer was in the affirmative, saying that a constitutional court can direct CBI investigation, but one para from that, my lord. From a bare reading of the aforementioned constitutional provisions, it is manifest that by virtue of these entries, legislative powers of the union to provide for regular police force of one state to exercise power and jurisdiction in any area outside the state can only be exercised with the consent of the government of that particular state in which such area is situated, except the police force belonging to any state to the exercise of power and jurisdiction to railway areas outside that state. My lords, there is no law enacted by Parliament under List 1 which provides for the extension of powers of Maharashtra police or any other state police within the state of Karnataka. Thus, the statutory scheme under the general criminal procedural laws needs to be examined in light of the constitutional provisions when determining the scope of the limited extraterritorial jurisdiction or actions exercisable by the police of one state to investigate into another state. Now, my lords, the statutory scheme, we have dealt with both the BNSS and the CRPC as it existed, my lord. On a reading of the provisions of the BNSS and CRPC, it is evident that there is no absolute bar on a police of one state investigating in another state. However, such extraterritorial investigation is not unregulated and is subject to certain checks and balances at every stage of the investigative process, particularly in relation to arrest, attendance, production of documents, search and seizure. To ascertain the jurisdictional limitations, extraterritorial operations, certain relevant provisions for adjudicating the present list are dealt with hereunder. Now, my lords, the first category we have dealt with, my lords, this is the most common category because so far as arrest and all, there is already inbuilt safeguards. The first category is, my lords, where you require the attendance of a witness. My lords, this is section 179 of the BNSS and 160 of the CRPC. What has happened in our case today? A notice has been issued under 179 directing me to come to Maharashtra. Now, my lords, before proceeding, may I just, and my lords, the high courts, my lords, about 5 high courts have taken the view that it is territorially confined. Of course, my lords, the High Court of Delhi, in the context of the NIA Act, has said it is not territorially confined. The Andhra High Court has taken a different view, but the Andhra High Court was dealing with a very different issue. The Andhra High Court was dealing with the issue of CID being a police station and the Reorganizational Act coming into force, and they said Hyderabad is an adjoining police station. I'll place those judgments, my lords. Now, my lords, in this light, if I may request my lords to have the Bear Act 179.
Now they have issued you a notice.
Yes, my lords, under 179.
Go before them and tell them
My
what
lords,
it is.
this would be beyond their jurisdiction, my lords. Such action would be beyond their jurisdiction.
If an offense has been committed in that jurisdiction, they have issued you a notice to come before them. They have not come to your place.
They have, my lords. They have come to my place. They have come in the process of search. They have come to my place.
They have done search at your place.
Yes, my lords.
That is different. But insofar as the
Even
notice
this,
is
my
concerned-
lords, would be wrong. Even this, my lords, high courts have held that it is wrong.
Yes, sure.
My lords, if my lords has 179 of the CRPC, BNS. Any police officer, my lords, has 179. Any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself or of any person being within the limits of his own or adjoining station who from the information given or otherwise appears to be acquainted with the facts and circumstances of the case, and such person shall attend as so required. Provided, my lords, this proviso is not very relevant. It says a male person within so and so age and a woman shall not be called. The second proviso is important. Provided further, if such person is willing to attend at the police station, such person may be permitted to do so. That is, my lords, the exempted categories. But, my lords, the words governing this provision would be in the main section, within the limits of his own or adjoining station. These are the governing words, my lord, so far as this provision is concerned.
So adjoining station could be in another state also.
No, my lords, this in fact courts have interpreted, and those judgments I have produced in my compilation.
So adjoining station would also have to be within the state.
Within the state, my lords. The only exception taken to that was Andhra. Andhra said CID is a police station in itself, and having regard to the Reorganization Act, now Hyderabad becomes an adjoining state, because that was a case where in one of the states in Andhra, they said Hyderabad also becomes an adjoining state, and it was very peculiar to that. Now, my lords, if I may just take my lords through the judgments on this, and I'll be very quick on this, my lords. It is my mark copy. If my lords may have compilation page 130. Sorry. Oh, no, first we'll start with 99.
Yes.
My lords, this was a case from the Guwahati High Court. Identical, my lords. Maharashtra police go to Guwahati, conduct a search and seizure. Para 5, my lords. In the course of investigation, the stock of so-and-so of the named accused so-and-so was seized, and he was arrested subsequent to the FIR. Various notices were served on the petitioner company at New Delhi for production of certain documents under 91 of the CRPC, and the petitioner immediately responded to the same by detailed reply along with documents. Suddenly on 3/9, the respondent number 2 is the investigating officer of the said case, visited the factory of the petitioner at so-and-so and entered the said premises along with police officials of so-and-so without any document search warrant from the court of law, and respondent 2 forcibly seized the entire machinery and articles. Now, my lords, if my lords may kindly have para 15, the issue posed by the court. 15.2 is concerned, my lords, at compilation page 103, foot of the page,
Yes.
whether respondent 2 has the power to seize factory, plant and machinery in Guwahati in connection with an FIR that has been registered in Maharashtra, which is not against the present petitioner. Thereafter, my lords, if I may request my lords to have para 18, the investigating officer, while carrying the investigation, came to the premises of the informant, which is a manufacturing unit of pan masala, without obtaining any order of that court, and no document whatsoever has been produced at the time of such search seizure to the persons in occupation of the aforesaid manufacturing unit. Neither the respondent has been able to produce the same before this court while filing the affidavit. Para 19, my lords, deals with another very important issue following our High Court decision of Christie Graham Food, which says that FSAI is a special act and all these are food products. FSAI has jurisdiction, not very relevant. My lords, 21. In view of the above legal proposition, it can be held that investigation so far carried out by the IO, particularly so far as regards the present petitioner, is beyond the jurisdiction under law. He was also not bothered to apprise the court of the competent jurisdiction in Guwahati while seeking permission for such search and seizure, nor any intimation has been forwarded which has been vitiated entire search and seizure and liable to be interfered with. The petitioner herein, without there being any criminal culpability, has been thrown to utter hardship and inconvenience by the seizure of the building as well as the articles valued more than so and so. Now, my lords, coming to the next judgment at 108. Sorry. H? Oh, you want to issue 91? Sorry, my lord. I missed out one judgment at 91. My lords could come back to 91. But this was a direct case under 179.
You have missed it out here also. After 90, there's 99.
Yes. No, my lord, 90. Huh?
It's no. It's not there in the compilation.
My lord, that's actually a very important judgment. Yeah. I'll come back to that, my lord.
This is where you missed it out. It's not there.
They'll come back to that.
Yes.
My lords, may kindly have the Delhi High Court at 108. Take a printout of that. That's very important. 108, my lords. This is the view of the Delhi High Court, and this was a case, my lords, where Punjab, my lords, issued a notice to Delhi. The Punjab police issued a notice, identical like in our case, to the Delhi police. My lords, may kindly have paras 22 onwards. My lords, 160 is extracted. 160 at page 117 is extracted. 160 corresponds to 179 of the new act.
Yes.
It is evident from, my lords, as 118. It is evident from a bare reading of the provisions that a police officer may require attendance of a person who is apparently acquainted with the facts and circumstances of a case, and that such police officer is investigated. A summons or notice to such person is to be issued following due procedure of law. The extent of this power is, however, limited by the bounds of jurisdiction. The concerned police officer may issue notice requiring attendance of any person who is within the limits of his own police station or that of the adjoining station. The language itself defines the extent of powers of requiring attendance, and the same is to be abided while proceeding with the provisions. Thereafter, my lords, there is an analysis at para 23, 24 at 119. To answer the first question, the consideration before this court is that at what stage a notice under 160 of CRPC can be issued. The words used under the provision are police officer making investigation. The CRPC itself defines investigation as so and so. Then, my lords, various judgments are extracted. My lords, may kindly have para 26 at 125. From the it can be deduced that summons or notice under 160 can be issued by a police officer who is making investigation under and in accordance with the provisions of CRPC, and to set into motion such investigation, there is a prerequisite. Without registration of FIR, an investigation cannot be said to have been initiated. Further, even for an inquiry to be held legal and valid, the police officer has to act in accordance with the provisions of CRPC, and he may not act beyond his powers by conducting a preliminary without making a report to the matter. Therefore, at the instance of an inquiry was valid or legally carried out by the concerned authority, even for the limited purpose of so and so. Now, my lords, may kindly have 28. The second consideration, which is before this court, is whether the concerned authority, respondent 3, acted within his powers in terms of territorial limitations while issuing notices under 160. The provision says that a police officer, while making investigation, may require the attendance of any person being within the limits of his own or adjoining station, thereby clearly and unequivocally setting the limits of jurisdiction within which the police officer is permitted to act. For this point, reference is also made to the judgment of so and so, wherein while referring to 160, a coordinate bench of this court noted as under. I'll place that when I come to that judgment, my lords. Then, my lords, at page 128, foot, the bar of jurisdiction under 160 of CRPC is indisputably applicable to the instant matter, and in such case, the notice is rightly said to have been issued without jurisdiction. This was the case, my lords, where the Mohali police issues it to the Delhi resident. Thereafter, my lords, the next judgment, the reason we place this second in line, my lords, this is actually a pending matter at page 130. But this judgment, my lords, though it is still pending before the Delhi High Court, it is being followed all over, my lords. The facts of this case, my lords, were such. Page 130. My lords, the West Bengal police itself issued some notices to the ED officers. And once the West Bengal police issued notices to the ED officers challenged that notice before the Delhi High Court. This was a case and counter case, my lord. The investigation started against an MP of a particular political party. And thereafter, my lords, the West Bengal police registered cases against those officers who were investigating. My lords, what is relevant here, my lords, kindly see para 18, at page 134, the contention of a department, the ED. Learned counsel, my lords, has that?
Yes.
Learned counsel for the petitioners further submitted that notices issued under 161 CRPC can only be issued to a person who is within the local jurisdiction of that police station or is within the jurisdiction of any other adjoining police station. My lords, why I place this submission, my lords? It is an investigating agency itself which makes this submission. And thereafter, the finding of the court, my lords, it also distinguishes, my lords may kindly note para 22. My lord, this is a contention of the respondent therein. He further submitted that the word adjoining occurring in 160 implies vesting of jurisdiction outside the state as well. In this regard, he relied on the judgment of so and so. This judgment was distinguished, saying that that was a case of NIA. It was not a case of local police. Now, my lords, coming to the findings at para 27, foot of 136. By a mere reading of the said provision, it becomes apparent that power of the police officer to require attendance of a witness is circumscribed by the words within the limit of his own or any adjoining station. It is to be noted that if said powers was to be in the nature of pan-India power, as has been sought to be argued by the respondents, there was no reason for the legislature to use the terminology quoted above. To the contrary, if the same was to be the intention of the legislature would have clearly stated so and bestowed unlimited jurisdiction on the police officer by using the terminology in the nature anywhere in the country or even anywhere in the state. The clear departure from the legislature and the use of the terms within the limits of his own or adjoining station points towards a legislative intention to limit the jurisdiction in this regard. The reliance placed by the respondents in this regard on the judgment of Anant Brahmachari may not further the case of the respondents, as clearly the said judgment was dealing with the separate statutory setup in the nature of NIA, which would have a strong bearing on the issue as the said agency has jurisdiction across the country. Thereafter, my lords, the Delhi High Court. Now, my lords, I've more or less repeated. I'll be very quick, my lords. At 140, this was a case, my lords, of journalists who were covering certain events in Kashmir. And my lords, they were residents in Delhi. Notices were issued to them in Delhi. And my lords, what the court says, they follow, my lords, at 144. At 143, my lords would see the provision is extracted. 144, the judgment of ED is extracted. The petitioners at 145, my lords. The petitioners have pleaded that they are residents of Delhi and have filed in sealed cover their affidavit, so disclosing their address along with copy of their respective Aadhaar card. Learned Counsel submitted that petitioner's address be not relieved on record as the petitioners obtained threat to their life on account of so-and-so. The petitioners have also so-and-so. Finally, my lords, at 7.0, in view of the above facts and circumstances, petitioners being residents of Delhi and having their office address at Noida, UP, could not have been summoned under 160 by the JK police. The summons issued to them are without jurisdiction and therefore quashed. Now, my lords, this portion that I further read, this is also subject to interpretation, my lords. What few courts have said is, however, this shall not come in the way of the investigating agency to examine the petitioners as per law in New Delhi if so required. My lords, this as per law if so required, the only connotation that can be given to it is by taking the permission of that local police station or by taking the permission of the local. But that issue was not there, so the court did not go into that. It leaves it saying that you can examine them at New Delhi as per law. Then, my lords, the next judgment, my lords, at 147. Again, my lords, mainly an extract. 15 to 21. I won't trouble my lords reading that at 154 to 155.
And this 147 is a separate judgment. 149.
Yes, my lords, 147 is another judgment of the Delhi High Court. Relevant paras are 15 to 21. Here, my lords, what they do, this was a case, my lords, where from Haryana police issues to a resident in Delhi. But my lords, may I kindly see para 21, what the court does there. Sorry, not Haryana police. This is a case of Andhra to Delhi. Andhra to Delhi. What the police does at page 155, what the court does at 155, in the result, the writ petition is disposed of. However, the police officer making the investigation relating to crime number so and so on the file of CID Guntur is at liberty to take necessary steps to examine the petitioner at his place and correct relevant documents in the presence of the advocate who can sit at 10 feet away. This is following Nandini Sakpati, my lords, to an extent. But my lords, whether this, my lords, an order being by a constitutional court, to the facts it may be applicable, but under the scheme of CRPC, such directions could not be given, my lords, would be my respectful submission. Then, my lords, the next judgment is of the Himachal court at 157.
Yes.
I'll just read at 158, my lords. It's a simple order. There is no, at 158, there is no evidence whatsoever to show that they were in Shimla at all. Expressly, the order under 160 of the code is without jurisdiction. The order did not proceed from a public servant legally competent to issue such a public servant to issue it. So he says that here, my lords, what the Himachal court does is it says that notice has to go lock, stock and barrel. But in the subsequent follow-up judgment, what Himachal does, my lords, it dilutes this position. My lords, in the judgment at 159, again of Himachal, the entire law is extracted. Judgments for and against have been taken. And my lords, what they do at page 176, my lords, they extract all judgments, and at 176, they say their finding is only limited to this. Thus, there is a divergence of opinion regarding the interpretation of 160 CRPC. However, this court is bound by the judgment of Krishan Bans and respectfully holds that a police can only serve notice under 160 upon a person residing within the limits of its jurisdiction or adjoining police station. Hence, notice upon the petitioner number 1 at Ludhiana asking him to join investigation is without jurisdiction. What they do at 19, my lords, consequently is allowed and notice is served on the petitioner asking him to join the investigation at Nalgara is quashed. However, it is expressly made clear that this order will not prevent the police officer from carrying out investigation and integrating the petitioner at Ludhiana, otherwise permissible under law. My lords, this again, this word otherwise permissible under law would have great significance with this statutory scheme, would be my respectful submission. Then, my lord, the Orissa High Court at 178.
There's nothing of the Karnataka High Court?
No, my lords. Karnataka and even Supreme Court, my lords, has really not gone into this issue in depth. I'll place the two judgments of the Supreme Court. My lords, there was a case of buffaloes gone missing in the Supreme Court judgment. I'll come to that. 178, my lords, the Orissa High Court. Again, more or less extract, but finally they say, I won't trouble my lords with that. But 181, foot of 181,
Yes.
thus notice under 160 of CRPC is thus ex facie illegal and the petitioner need not comply with such notice. It has been held it is ex facie illegal, my lords. Now, my lords, the Ranchi High Court
So
at
if it is
182,
outside the jurisdiction of the police station, how do they issue the notice then?
my lords, that, my lords, would be traceable to, I've dealt with that,
So
my lords,
there
that
won't
would
be
be
any
traceable to 186.
investigation at all if this
It
argument
is permissible, my lords. It is permissible.
How is it
under,
permissible?
It is permissible under 186 BNSS, which says you have to intimate that local police and take that local police into confidence and go. And
No, the notice under 160 or now under 179,
cannot go, my lords.
if somebody in Maharashtra cannot issue it into Karnataka, who will issue that notice under?
It has to be under 186 would be my respect. It cannot go, my lords. 160 would be my submission that Maharashtra police cannot issue.
180?
186. 186 BNS. My lords has 186. When officer in charge of a police station may require another to issue search warrant, an officer in charge of a police station or a police station not being below the rank of so, my lords may skip that. My lords may have subsection 3. Whenever there is reason to believe that the delay occasioned by requiring an officer in charge of another police station to cause a search to be made under subsection 1 might result in the evidence of the commission of an offence being concealed or destroyed, it shall be lawful for an officer in charge of a police station of making an investigation under this chapter to search or any place in the limits of another police in accordance with the provisions of section 185 as if the place were within it. My lords, it is only in those exceptional circumstances can he go. And my lords, the Delhi High Court in another judgment said guidelines have to be issued for interstate investigation. I'll place that also, my lords. While issuing guidelines, they said the general diary of each police station should have corresponding entries. There were checks and balances. My lords, it is not a situation where one state cannot go in. That is not my contention, my lord. It has to be with inbuilt safeguards and checks and balances. And my lords, what could be the checks and balances? The checks and balances could be by intimation, recording in local diaries of each corresponding intimating of the superior officer, and of course magisterial approvals in the case of arrest and search warrants. The only exception carved out is, my lords, when you are summoning for a document, like under 91 of CRPC, when you are summoning for a document, you can sit in your home state and summon for any document. There, my lords, because you're not asking that, you are not going there or asking that person, you are simply sitting asking, please give me the document. And if you don't comply with that, they are free to take subsequent action by way of a warrant or something. That would again be controlled by magisterial approvals. Sorry? Illa Nandi there. It's okay. My lords, one judgment of the Meghalaya High Court which I had missed out, my lords, which was missing in the compilation.
Yes.
My lords, that was actually a missing page 91 of the compilation. My lords, this was a case, my lords, where the Shillong police issue a notice to a resident of New Delhi. My lords, this was both a case of section 91 and section 160. It was a mixed issue, my lords. My lords may kindly have 94, para 4, internal para 4. Insofar as section 91 is concerned, there is no difficulty. If a court or a police officer considers production of a document or a thing for the purpose of investigation, inquiry, trial, or any proceedings under the code, it can require the person in whose possession or power such document or thing is believed to be to attend and produce it at the place stated in the summons or order. However, the personal attendance of the person in whose possession or power the document or thing is believed to be cannot be insisted upon for the production of such document or thing. The mere production of such document or thing will not obviate his personal attendance. Now, my lords, at para 5, they come to 160. Section 160 authorizes a police officer making an investigation by order in writing to require attendance before himself any person who, for the information given or otherwise appears to be acquainted with the facts or circumstances of the case, and who is residing within the limits of his own police station or any adjoining police station. The expression who being within the limits of, I read with the words following it, namely, or any adjoining police station, can only mean the person who is to be summoned must reside within own police station or within the adjoining area. Secondly, that in case of a male person under the age of 15 years, we are really not concerned with that, my lord. Finally, at the foot of the page, if the contention of the learned WAG that under section 160, the police officer making the investigation is not disabled from requiring the attendance of a witness residing beyond the local limits of his police station or adjoining is accepted, that will amount to ignoring the words being within the limits of his own or any adjoining station. And then, my lords, they in fact go on to say the rule of purposive construction cannot be brought in. They say this is not a case of purposive construction. Yes. Then, my lords, if my lords may kindly have page 149. 149 I placed, my lords. Sorry. 184, my lords. Well, this was the judgment of the Andhra High Court, which dealt with CID as a police for the state, and the adjoining station becomes Hyderabad. But the general proposition was accepted. If my lords may kindly have para 14, 194. I'll also place para 11. Now the crucial question for determination is whether the petitioners are residing in Hyderabad in the state of Telangana would come within the ambit of the phrase being within the limits of the adjoining station or not. Before para 14, 194, before embarking upon any inquiry on the said issue, at the outset it is relevant to note that the crime was not registered by any regular law and other police station in the state of Andhra Pradesh, which would have its own delimitations within the state relating to the territorial limits of the said law and the police station functioning in the state of Andhra Pradesh. And this was a case of CID, my lords. However, para 15, however, when a crime is registered by the CID police station of a state, and when the Office of the Crime Investigation Department, which exercises jurisdiction of the entire state itself, is declared as a police station for the entire state under 2S of CRPC, and when similar notifications under 2 are issued by the government of neighboring state, which is the adjoining to the said state, declaring the Office of the Crime Investigation as a police station for the entire state, whether CID police station of the neighboring state can be construed as an adjoining station for the purpose of exercising the power of the investigation under 160 is the main controversy involved in this question. Then, my lords, may kindly have para 27. The entire law, my lords, the entire gamut of law was taken. Meghalaya, the Guwahati High Court decisions which are already placed, all these judgments which I have placed, my lords. And at page 205, in all the above referred to judgments, the courts found that the persons to whom notice under 160 was issued by the police officer are not residing within the limits of police station of the said officer or within limits of the adjoining police station. In the present case, the petitioners are found to be residing within the limits of the adjoining station. And then, my lords, they went into the Reorganization Act, really not relevant for our purpose. My lords, and also I have a duty to place the judgments which are against the proposition. That's at 2 and 3. Well, this is a judgment of the Delhi High Court, which the Delhi High Court itself distinguishes. saying that this is a case of NIA. My lords would kindly have at 213, at 222 para 12. Section 3(1) of the NIA Act starts with the non-obstante clause, providing that notwithstanding anything in the Police Act, the central government may constitute a special agency for investigation and prosecution of offences under the Act specified in the schedule. Further, subject to any orders which the central government may make in this behalf, officers of the agency shall have throughout India in relation to the investigation of the scheduled offences and arrest of the persons concerned in such and all powers, duties, privileges and liabilities which police officers have in connection with the investigation of the offences committed therein. Thus, an officer of the NIA has jurisdiction to investigate and arrest any person relating to the scheduled offence anywhere in India, coupled with all the powers and duties of privileges and liabilities of police officer. My lords, this, my lords, of Anant Brahmachari, the Delhi High Court itself in ED and in the journalist case, they dilute this, saying that NIA was special, it is a special enactment, therefore it stands to be read down by those judgments. Then, my lords, the other judgment against this proposition is of the Bombay High Court, that is at 234. In this, my lords, in fact, the court has expressed its genuine concern, my lords, saying that investigation will become impractical if such a interpretation is given. It will have far-reaching consequences. Para 11, as regards section 160 is concerned, my lords, at 240, my lords. Yes. As regards section 160 is concerned, undoubtedly it states that summons can be issued to any person being within the limits of his own or any adjoining station. We are concerned here with the main body of section 160. We are not dealing with the proviso thereto. The said proviso of law nowhere states that such person must be within the limits of such police station or adjoining police station at the time of issuance of the summons, but it specifically refers to the fact that such summons can be issued to any person for the purpose of gathering information from such person, he being acquainted with the facts and circumstances of the case. Obviously, the provisions is made in that regard in order to enable the investigating officer to collect required information from every person who is acquainted with the facts and circumstances of the case in respect of which the investigation is being carried out. At the same time, it is also to be noted that under 162, it is provided that the state government may, by rules made in that behalf, provide for payment by the police officer of the reasonable expenses of every person attending under subsection 1 at any place other than his. In other words, a person residing at any place can be required to appear at a different place, and any expenditure incurred by such person for such attendance can be reimbursed in accordance with these rules framed by the state government in that regard. This apparently discloses the investigating officer to secure the attendance of a person in a police station or at any other place required for investigation. Now, my lords, this finding, my lords, of the Bombay High Court, on the face of it, my respectful submission is wrong. If my lords may kindly have the bare act itself, 179. My lords, the 171, 179, 1, I won't trouble my lords reading it. Now the proviso, the first proviso says, provided that no male person under the age of 15 years or above, the age of 60 years, or a woman who is mentally or physically disabled person, or a person with acute illness shall be required to attend at any place other than the place in which such person resides. Now the second proviso provided further, if such person is willing to attend at the police station, such person may be permitted to do. Now, my lord, subsection 2 governs the two provisos. It says the state government may, by rules made in this behalf, provide for the payment by the police officer of the reasonable expenses of every person attending under subsection 1. Now, my lords, what the Bombay High Court says is, this is not for the purpose of the provisos, 1 and 2 provisos, but it overrides and it goes to the main provision 179(1). And any person can be summoned, and the state government, it is only those category of persons, let us say, my lords, a male above 60, he is willing to come to the police station. Subsection 2 says you pay for him. It does not say anybody you can get. It can't, the proviso cannot override the section itself.
The provisos are to subsection 1, and subsection 2 is a different aspect of rules.
Payment of expenses for a person coming.
Subsection 2 is not tied to the provisos also. It is separate, distinct, independently standing provision.
Yes, my lord. Rules for it says the state government shall make rules for payment of the compensation to a person visiting the police station. Who is permitted to visit the police station, my lords? Would be only those people under the provisos.
So, are there any rules made by Maharashtra or Karnataka?
My lords, we tried, my lords. I couldn't lay my hands on that, my lords, because I think most of these come under the standing orders, my lords, and in the police manual under the standing orders, we did make an effort. We could not get that, my lords.
Then that will bring us back to the first question. Will this court have jurisdiction to direct the Maharashtra police?
My lords,
They might have come here to Karnataka.
My lords, may I say this, my lords? This court, in my respectful submission, would not have jurisdiction to direct the Maharashtra police from acting or not acting in a particular manner. But this court, my lords, in my most respectful submission, would have jurisdiction to control actions within the territorial jurisdiction of this state.
Control
And that, my lords, would have to conform with CRPC.
Control in what manner?
My lords, if they want to do it, my lords, courts have held that a simpliciter notice under 160, not complying, not informing the local police is ex face bad in law. My lords, probably since there are no standing orders in this regard, my lords, like how my lords has done in the missing case, my lords.
That you could not lay hands on.
Yes, my lords, in the missing case, my lords has called for interstate cooperation, and that, my lords, is monitoring that case, and it is, my lords, because the standing orders, my lords, what we
Because
saw,
that is the
we had-
reason why, see, there are a lot of crimes, lot of offences which require interstate jurisdictional investigation. So if it's cut off,
that would be a very, very absurd proposition, my lords, to say it is completely cut off, because it can lead to anarchy, my lords.
it will be.
It can.
Another thing, the next other issue is, if it requires that kind of a cooperation from the authorities and paperwork and bureaucracy, how would it impact on the investigation?
My lords, therefore, my lords, the check and balance is in it, my lord. It is a simple intimation to the local police. And only that exceptional circumstance, if you feel the accused is going to abscond completely and I have to carry out his arrest, you chase him into a visiting state, arrest him. If you feel the evidence is going to be destroyed, you chase him, you go into the visiting state, collect the evidence. But my lords, that has to be with a counter check. It cannot be an unbridled power, my lord. And the counter check is only in the form of information to a magistrate or the local police. It is not at all my contention that there cannot be interstate cooperation. There has to be, my lords. But that has to be with a check and balance. Otherwise, my lords, let us take a situation, my lords, where some police of Maharashtra come into Karnataka, they just become ordinary citizens. They may have a 160 issued. Their local police officer may have a one, because the reason being this, my lord, he is not subject to any disciplinary or accountability in this state.
It will be subject to in Maharashtra.
My lord,
Whatever he does here
but
will also
the
be
action infringes in the home state. That action would infringe, and no action can be taken against that officer.
Yes.
Now, my lords, the Allahabad High Court also has taken a contrary view.
Just give us the para numbers. We'll go.
Yes, my lords, I'll just place those paras.
Hmm.
The Allahabad High Court, my lords.
Unless there's something specific that you want to bring us, because
No, my
now
lords,
it has got repetitive.
I'll just place the Supreme Court judgment on that.
What do you place?
At 243, relevant at 244. Para 5, my lords. This is the Allahabad High Court decision. Then, my lords, the two judgments of the Supreme Court at 246. My lords, the Allahabad is against me, against the proposition. I won't say against me, my lords, because there they say it is permissible. I'm not even contending that it is an absolute bar. That is not my case, my lords. 246. Now, my lords, we move to section 186 of the BNSS.
Yes.
And my lords, 186 contemplates interstate cooperation. Unlike 179, 186 contemplates interstate cooperation subject to informing. Yeah, para numbers are marked. Sorry.
What do you have to say to subsection 3 of section 186?
Yes, my lords.
There is reason to believe that delay occasion.
Yes, my lords.
This is exactly the question that we are asking you.
Yes, my lords. Clause 4 also, my lords. Clause 4. Any officer conducting search under subsection 3 shall forthwith send notice to the search to the officer in charge of the police station within the limits of which the place is situated, and shall also send with such notice a copy of the list prepared under section 103, and shall also send copy to the
magistrate.
That is a check and balance, my lords. Nobody could have a problem if 186 is invoked. The only grievance somebody could have is.
So it is notice of the search. Is it pre the search or post the search?
My lords, 186, my lords, in exceptional cases, there is no requirement to give notice. Post search, you'll have to give notice. Exceptional cases.
In this case, that is also not been done.
My lords, and it is actually a matter of, because we even tried to inquire with the local police, my lords, what is happening. Because they say it is a impractical, let us say today,
Mr. Panini will have to answer.
It is very impractical at every stage to inform somebody, my lords. So they say we go in, but law does not permit that.
Yes.
We do it, they do it, my lords. Both sides are.
Yes.
Now, my lords, at 246, my lords, this was a case which dealt with old CRPC 165, 166, new BNS 185, 186. The relevant is at 266, para 29. Section 166 is an enabling provision which enables an officer in charge of a police station to require another to issue search warrants. Subsection 3 of 166 provides that whenever there is reason to believe section 3 of 160 provides that whenever there is reason to believe that by requiring an officer in charge of another to cause search to be made under subsection 1, that section might occasion delay and result in evidence of the commission of an offense being concealed or destroyed, it shall be lawful for the investigating officer or team making investigation under chapter 12 to search or cause to search any place in the limits of another police station in accordance with the provisions of the section 165 CRPC as if such place were within the limits of his own police. Subsection 4 requires that after conducting the search as contemplated under exactly to what my lord posed to me. Subsection 4 requires that after conducting the search as contemplated, the officer shall forthwith send a notice to the officer in charge of the police station within the limits of such place and a copy of the list, if any, prepared under section 100 to that police station and to the nearest magistrate empowered to take cognizance of the offence along with copies. Well, this is the check and balance. This is the check and balance.
So it will have to be sent to the magistrate who will take cognizance, not the magistrate of that local jurisdiction, not the magistrate of the police jurisdiction.
But first, after informing the local police, my lord.
After informing.
After informing the local.
Nearest magistrate would also have to be
that magistrate.
In Tumkur, not. And Tumkur is not bordering Maharashtra.
My lords, then at 276, my lords, this was in fact, we didn't get any other citation, my lords, the reporter citation. Another judgment of the Supreme Court.
Yes.
My lords, this was again a case of 185, 186 of the BNSS. Judgment of Chief Justice Sudhir Tela, as he then was, my lords, at 278. About 10 lines from the bottom, my lords, at 493, my lord would see 493.
Yes.
Therefore, the statement of the appellants that they took the raiding party to the dacoits is not true, and we do not therefore believe it. The argument, however, was raised that under 165, the powers of the search of a station house officer are limited to the limits of his police station, and he cannot make a search within the jurisdiction of another police station house officer. reliance was placed upon provision of 165 to establish this. There is no doubt that it is the normal and ordinary provision that of the code that, but then there is section 166 also to be read. Under subsection 1 of that section, a police officer may invoke the assistance of a police station house officer of another jurisdiction and ask him to conduct the search. It is submitted that this is what the sub-inspector in Kesar Singh ought to have done. The powers of the police station house officer, however, are not confined to this only because subsection 3 of the same section gives the right to authority to police station house officer to conduct search in the jurisdiction of another police station house officer if he has reason to believe that the delay would be occasioned by requiring the officer in charge of the other police station to cause the search to be made as result of evidence of the commission of the offense would be concealed and destroyed. Then thereafter, well, as actually the facts here are slightly, it is a case where buffaloes had gone missing, my lords. And they said that if cattle goes missing, you can't immediately, if the cattle get mixed with other cattle, you can't trace it. Therefore, it was permitted. But they said there is no reason to doubt the bona fides of a police officer that he had intimated the local police. So they didn't really go into the other statutory aspects of it. They said it is an action done by the police in good faith, and this was a post-conviction matter in appeal. And they said no cross-examination was done on that. Then, my lords, I would want to place this judgment of the Delhi High Court at 280, where guidelines were issued, my lords. My lords, this was a case of arrest, but a committee came to be formed of a retired High Court judge. My lords, may kindly have page 286. It extracts an earlier order of the committee, formation of the committee, para 12, my lords, 4 lines from the bottom. The committee will also be provided with all relevant circulars, instructions, and rules governing the procedure to be followed by the police of one state when they go into some other state or union territory while investigating a complaint or FIR. As a part of the remote of the committee, will give suggestions on how the system can be improved and so and so. Thereafter, my lords, the findings of the committee. My lords, this was in the case of an arrest. All provisions are taken. My lords, may kindly have 295.
Yes.
Though in the context of interstate arrest, my lords may have 296. I'll also place 295.5 before, sorry. And my lords, thank you. But 295 top, my lords, is important. The first para, the last 2 lines of the first para, the committee also examined the procedures followed in Andhra, Karnataka, and Kerala.
But not Maharashtra.
Then, my lords, para 5. My lords, all these are checks and balances which they give, my lords. You make an entry in your local station, come to the visiting station, visiting state, make a entry. Point 9, my lords, at 296. While returning, the police officer must visit the local police. To a pointed query put by my lords, what should happen? When returning, the police officer must visit the local police station and cause an entry in the name of the daily diary.
So none of these at para 15 have been followed.
Nothing, my lords. But my lords, these were only recommendatory in nature, my lords.
And that will apply only to Delhi because it was Delhi judgment.
Yes, my lord. And 299, my lords. Para 16. There is a further suggestion by way of addition to the report which reads as under. In partial modification of the joint report, it is suggested that if in case of urgency or other considerations, in the interest of investigation, it is not found feasible to inform the police station encompassing the jurisdiction of the search, seizure, arrest, or investigation before the event. This should be done soon after the search, seizure, arrest, etc. has been conducted. In all cases, a diary entry should mandatorily be made in the police station of the jurisdiction, extent and so. Yes. My lords, we did try, my lords, to get Karnataka. We could not get it. We tried our level best from the police manual.
They're here. So yes. Anything else?
My lords, then quickly coming back to my note, my lords. My lords, page 4 and 5
are all the judgments.
I've dealt with, and my lords, at page 5, I have given the notes against Andhra and against Bombay, my lords,
Yes.
and Delhi. I have given the distinguishing factors. Now, my lords, at page 6, I have dealt with how other interstate investigations will have to be done. Now, my lords, the next part would be at Roman number 3, execution of summons warrants outside the local limits. Section 69, 80, 81, 80, and so and so. Corresponding section. These provisions regulate the execution of warrants beyond the territorial jurisdiction of the issuing court or police officer. In such cases, safeguards requiring intimation assistance from the local jurisdictional magistrate are already incorporated. Such an endorsement by the local executive or police authority or order from the concerned. Well, so there is already an inbuilt safeguard in the code itself, which says you go get an endorsement from the local magistrate or the police concerned. And these are dealt with in these provisions, my lords. I won't trouble my lords. I've just flagged those provisions. It is 69, 80, 81, 102, and 104 of BNS. Corresponding CRPC provisions are given. Then, my lords, summon to produce documents. This provision empowers the 91 of old CRPC. This provision empowers the court or the officer in charge of a police station to require the production of any document, electronic so and so, though such a requisition for production of document is issued outside the jurisdictional limits of the concerned state. This does not require physical appearance of the person on whom such requisition is made. Then, my lords, arrest. Arrest has specific safeguards, my lords. Those are dealt with, my lords, under 45 itself. I'll just place 45 of BNSS for completion, only 45, because this is one of the provisions which specifically provide for chasing. 94, yeah.
Into any place in India.
Yes, my lord.
Yes.
But, my lords, that comes with its safeguards. It is not an unbridled power. The safeguards would be the 24-hour safeguard, informing the immediate magistrate. So they have all its inbuilt safeguards, my lords. And, my lords, the last submission, my lords, the last submission would be, my lords, even assuming I am, my lords, today a distributor. I'm not even the manufacturer. I am the distributor of pan masala in the state of Karnataka. It is their contention, my lords. Maharashtra is a prohibited state for certain products. It is their contention that I, as the distributor, they are behind me as the distributor, saying that these products were found in Maharashtra. Now, my lords, these are subjects which are exclusively governed under the Food Safety Act. My lords, it is for the concerned food safety organization to come. Otherwise, my lords, it is not a prohibited activity.
That's not something that we are dealing with in this matter.
Yes, my lords. But even assuming, my lords, there is some wrong on my part, it is falling in the exclusive domain of the FSAI Act, not under. Very well, I leave it.
Only examining the jurisdiction of the Maharashtra police entering into Karnataka, coming all the way to Tumkur and searching and seizing
Very well,
from your property, from your premises. That's the only thing that we are looking at.
Just made a comparative provisions of the old and new act, my lord.
Of the VNSs and the
CRPC, what is relevant? Grateful. Huh? Anything I missed out?
First, my lord, 230. I'll just state what is the procedure followed by the Karnataka police, my lord.
What is the procedure followed not by Karnataka police? What
Generally,
is the procedure followed by Maharashtra in this?
Okay.
And whether we'll have jurisdiction, that also you'll have to.
Yes,
so the submission made is that we'll have jurisdiction because the actions have been taken in Karnataka. If it was only a notice, we would have said no jurisdiction, go and reply there. But if they have come into Karnataka and seized, their submission is that they could not have done that.
They have not seized. They have seized the food product, my lord. There was a search with the assistance of local police in this case.
That is what you will have to show us. If you had been informed and the check and balance has been met, then everything goes. Last time you had made a submission that no, you did not know.
No, that as per the instruction, my lord, they have assisted. The local police have assisted them.
No, my lord. In fact, that was the categorical submission that
you have assisted. Then there's nothing which is there in this matter.
Yes.
Because this is an ongoing thing, my lord. I can say it as a.
Then the checks and balances have been met.
Yes, ma'am.
You should have told before only. We could have stopped Gautam long ago.
No, my lord, it is not with the assistance of the law.
My lord, for the prayer, this is not required, my lord, because their prayer is mandamus directing the respondent to not to harass the petitioner or interfere with the lawful business under the grab of investigation.
How do we do that?
Yes, ma'am.
If they are entitled to investigate, we can never say that.
Yes.
If they are not entitled to investigate within state of Karnataka without your assistance, then we can pass that order.
Yes.
Their contention is that. So if you have been informed and you have assisted, then all his arguments will go. Nothing will be there.
And in fact, my lord, this is an ongoing thing which happens to all distributors of these thing.
We are concerned only with this particular
Yes, my lord,
instance.
this definitely, my lord, there has been no locally, at least to our, nothing was placed before us or when they came into our premises. There was no.
The Gautam and counsel for the petitioner for reply arguments of DGA released on 31st at 2:30 p.m.
There was one 1962 standing order under the police manual which we had got, which provides for interstate cooperation of police. Just this is the only thing we could get.
Give him more.
I will give it, my lord. Court of
Yes.
Well, it's the interim protection.
Interim order earlier granted.
Grateful.
Number 11.
Hearing for the 4 and 5. I think government has filed, madam. Filed an affidavit.
Yes. Yes, madam.
My lords, they have filed an affidavit stating that the link is not opening, my lords.
Yes, madam.
ಇದೆಯಲ್ಲ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ
Direction was to open their financial bid also. That is the direction, my lord.
What is the order date?
My lord,
19/1/2026, my lords.
19/1/26.
Please, my lords.
The work order is not issued, it shall not be issued. Where the petitioner's financial bid shall also be evaluated for a complete adjudication.
please, that is the direction. My lords, may kindly now peruse the affidavit which we have filed, ma'am.
Have you issued the work order?
Not yet.
Not yet. Now it's only the evaluation.
Evaluation which is complete. On, my lords, that's the reason I filed this affidavit. My lord sees the second page.
Yes.
Para 3, my lords. Para 2 onwards, I'll read. I state that the rejected, my lords, para 1, the last few lines I'll start, my lords. Para 1, my lords. DMA as fitness certificates of the leased vehicles had expired. My lords will guess the last 6 lines. The technical bids were submitted for approval to the Directorate of Municipal Administration on 14/10/25 and the same were approved by the DMA on 148 Tender Scrutiny Committee meeting held on 30/10/25. The technical bids of the following were accepted and the technical bids of so-and-so and both indents were rejected by Tender Scrutiny Committee on 30/10/25. That is the remarks, my lords, indent, bidder and the remarks. I state that the rejected bidder so-and-so submitted an appeal in Karnataka Public Procurement for the both indents to the Appellate Authority, Urban Development for the consideration of the technical bid on 31/10/25, though the rejection was already updated in the KPP portal. The petitioner was communicated about the rejection of his technical bids by respondent number 2, letter dated 28/11/25. The Appellant Authority, Secretary of the Government so-and-so rejected the appeal of the KM so-and-so, that's the petitioner, my lords, on 30/12/25. Accordingly, the financial bids of the technically qualified bidders were opened on the so-and-so portal on 2/1/26. I state that the financial bids were already opened on 2/1/26 in the portal. The petitioner so and so had filed the writ petition on 12/1/26. The financial bids were placed in the district level tender scrutiny committee on 14/1/26 and the financial bids were recommended for approval to DMA. An oral order by the Honorable High Court to open the financial bid was passed on 19/1/26. The authorization so and so was communicated on 7/2/26. It was humbly submitted that the financial bids were already opened on 2/1/26 in the KP much before the filing of the case by the petitioner. Hence, the financial bid was rejected. The bidder, that is the petitioner, was not available in the portal software for opening. In this regard, as the portal doesn't allow access to tender inviting authority, that is respondent number 2 and 3 to open the financial bid of the rejected bidder, a request letter was made to the e-procurement to open the financial bid. My lords, this is the communication by the e-procurement. The translation, my lords, next page.
ಕನ್ನಡದಲ್ಲೇ ಓದಿ.
ಓದಿ.
ಏನಕ್ಕೆ?
ಟೆಂಡರ್ಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ಸದರಿ ಟೆಂಡರ್ಗಳನ್ನು ದಿನಾಂಕ 19/5/25 ಪ್ರಕಟಿಸಲಾಗಿದ್ದು ಟೆಂಡರ್ ಸಲ್ಲಿಸಲು ಕೊನೆಯ ದಿನಾಂಕ 3/6/25 ನಿಗದಿಪಡಿಸಿರುತ್ತದೆ. ಸದರಿ ಟೆಂಡರ್ ನಿಗದಿಪಡಿಸಿರುವ ಬಿಡ್ ವ್ಯಾಲಿಡಿಟಿ ಪೀರಿಯಡ್ 90 ದಿನಗಳಾಗಿದ್ದು ಅದರಂತೆ ಬಿಡ್ ಸಿಂಧುತ್ವ ಅವಧಿಯು ಈಗಾಗಲೇ ಅಂತ್ಯಗೊಂಡಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಟೆಂಡರ್ಗಳು ಅಂಡರ್ ಇವ್ಯಾಲ್ಯೂಯೇಷನ್ ಹಂತದಲ್ಲಿದ್ದು ಈಗಾಗಲೇ ಟೆಂಡರ್ ಆರ್ಥಿಕ ಬಿಡ್ಗಳನ್ನು ತೆರೆಯಲಾಗಿದ್ದು ತುಲನಾತ್ಮಕ ಶ್ರೇಯಾಂಕ ಸಿದ್ಧವಾಗಿರುತ್ತದೆ. ಆದುದರಿಂದ ಕರ್ನಾಟಕ ಸಾರ್ವಜನಿಕ ಸಂಗ್ರಹಣಾ ತಂತ್ರಾಂಶದಲ್ಲಿ ಆರ್ಥಿಕ ಬಿಡ್ ತೆರೆದ ಹಂತದಲ್ಲಿರುವ ಟೆಂಡರ್ಗಳನ್ನು ಪುನಃ ಟೆಂಡರ್ ತಾಂತ್ರಿಕ ಮೌಲ್ಯಮಾಪನ ಹಂತಕ್ಕೆ ಮರಳಿಸಲು ತಾಂತ್ರಿಕವಾಗಿ ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ.
That is not what it is.
It's not going to be.
What is required is
Please.
whether the financial bid
Please.
is still available. Because now if we ask them to give a physical copy, which they'll be very much ready to do so, they'll give you a nice financial bid which will be lesser
Because
than
that is the
theirs.
difficulty. The software, my lords, lapses everything. We will not have any access to what they had bid in the first place. And my lords heard the matter completely. By my lords, I'll just read two sentences, my lords. This is a case where they admit that there are errors and it's a rectifiable defect. There is an admission that they were not eligible on the date of the bidder. They are not qualified. They come to before my lords and there is an interim order to evaluate
Now
their
this financial bid is not available on the
not
website.
available. That's the reason I placed the affidavit. So the only way would be if they have something genuine there, but and
We
for that
cannot go
also
by
they should
what
be.
they have. It should be available on the portal.
My lords, the software doesn't allow us to access any information after we open.
Is it available?
It lapses, my lords. The software just does not open. The information just.
All the thing that you are saying is not access, not open, is something is there and it is not opening or not accessing.
My lords,
But is the bid submitted by them available on the portal?
My lords,
If it's only an access, they can be directed to give you access.
my lords, my information is once, that's what I'm trying to explain, my lords. When a technical bid is evaluated and bidders are selected, rest all the information is erased from the system, is what is my information.
It's not there, we can't do it. We can't allow you to give it now.
Last occasion, that is what was suggested, my lord, that if the financial bid documents were given, that they would consider, because they have to comply with the court order, my lords.
You know everything now.
My lords, the thing is, my lords, ultimately they'll have to comply with the court order, my lords, because it was passed on 19/1/2026, my lords.
Court passed the order, yes.
Please, my lords,
But
and
this was opened on
2/1,
2/1, my
which
lords,
is prior
2/1,
to
my
that.
lords. My lords, they were very well aware on 19/1/2026 itself, my lords, because the financial bid was opened on 2/1, my lords.
Madam, if we'll also ask you every time that you stand up to argue, you should be
7/2,
aware
my lords.
of everything. Next time, don't ask us, I'll get instructions from your client. Government advocate, the order was passed on the assumption that this would be there. Now they're being very clear that 2/1/26, once it is opened, it goes out of the system. It goes out of the system, it is not available. Now to permit you to furnish, you will furnish obviously a better proposal than anybody else.
But my lords, the court order is there, my lords, so that's because last occasion your lordship observed that, my lords, that.
Yes, the
have to
coordinate
come-
bench had passed that order,
Yes,
that
my
is why
lords.
it had to be implemented. But if there are practical difficulties which don't allow it to be, we'll have to take cognizance of that. Otherwise, we would definitely have got them to do it. But if it is not there, it is not there. You can argue on the merits of the matter if anything more is left.
My lords, on 3rd, the matter may be taken up.
An affidavit of The project director, Department of DUDC, Chikbadapura District, Chikbadapura has been placed on record. Based on the said affidavit, learned Additional Advocate General categorically makes a submission that once the financial bids were opened on 2/1/2026, all the documents which had been received would then be made available to the tender issuing authority and the approving authority, evaluation authority. Thereafter, the documents would not be available for it to be again accessed once the document of a particular bidder has been rejected. And it is in that background she submits that the direction which had been issued by this court, by court and bench of this court on 19/1/2026 to evaluate the financial bid of the petitioner could not be complied with, since the said financial bid went out of the system on 2/1/2026 and was not available even as on the date on which the order was passed on 19/1/26. A submission is placed on record. Counsel for the petitioner seeks for and is granted a week's time to make a submission as regard the other aspects, other remaining aspects. Relist on 3rd.
Please.
Great.
Serial number 12, Vinay N.
Fee not for the court commissioner not is not fixed.
It is after seeing the report. We haven't seen. You must have seen it. We have not seen.
Yes.
Where's the report? Whoever it is against will have to pay the cost. When was the report filed?
It was served on 21/7.
21/7 report code. So you are ready to pay?
It is for them, Lord. The report
That means
says
it is in your favor.
it's in my favor.
It's in nobody's favor. Nobody's favor.
Nobody's favor.
Nobody's favor.
It is whatever facts are there is that.
Then both of you share.
As is.
Okay, we will see it. How long will you take to address arguments now?
I have not virtually covered everything. I'll just not refresh and not leave it at, because the report not says that there is a dead end.
Yes,
It's
Mr. Chinappa,
not
what about
18-meter road.
We'll argue on the issue of the interpretation of
Take it
those-
up on Saturday and
Yes, can.
not too many matters that day.
We'll finish it on that.
A report of the commissioner has been filed. The same is taken on record. Relist on 29th.
Saturday.
Lordship. 13.
Saturday, too many matters are listed on Saturday.
We thought too few matters.
ಆಯ್ತು ಇರ್ಲಿ ಅವ್ರು ಮಾಡ್ಲಿ ಆಮೇಲೆ ಏನಾದ್ರು ಇದ್ರೆ.
ನಿಮ್ದು ಹೆಂಗೂ ಇಲ್ಲಿ 2 ಮ್ಯಾಟ್ರ್ ಇದೆ. ಅದ್ರ ಜೊತೆ ಇದು ಒಂದು ಮಾಡ್ಬಿಡಿ.
One request, Lordship.
Yes.
Can I be on VC if I'm not able to make it?
You are not required, don't worry. Only we'll have to say who will have to pay your fees is what we have to decide, that's all.
13.
The interim order would be
Interim order.
grateful.
ಅದಾದ್ಮೇಲೆ ಅದು cash coming.
Last date of hearing in this matter, my lord has directed to file the affidavit.
But can it be on a Monday, my lord, instead of Saturday? Because ಎಲ್ಲ Saturday ಬೇರೆ ಅಲ್ಲಿ second court, third court ಎಲ್ಲ ಹಾಕುಮೆ, fourth court. All the
Monday again, we have lot of matters. It will be like this only.
Tuesday,
Saturday, since it's a working day, which we had not given many dates.
other courts will have given, my lord, all.
No, and we'll see on Saturday, they can address. And only for your arguments, we may have it on Monday. Mr. Chinappa, you are free on Saturday.
It's the same thing, no, but I'll come. I'll be there. Every day is maybe something.
We have to make use of the best available.
ultimately, my lord, when we look at your lordship's list, we get scared.
Looking at all of them, we are a little this one that we are unable to take everything. So that's the problem.
Nothing can be done, my lord. This is how we are. So many matters are there. This roster is one of the heaviest.
482, highest.
Correct.
My lord has directed
Enidu?
to file, my lord, 2%, my lord, the equal.
2%,
Yes, my lord.
3%, 5%.
Yes. And directed the KMF to file the affidavit and my
No
lord, state
instruction.
government, finance.
Finance secretary.
Yes.
Finance secretary's affidavit as well. Next week sometime. Instructions
He has to seriously look at this.
next week, Wednesday.
One submission, my lord. Though there is an interim order with respect to the work order is concerned, even though that, my lord, they violated and my lord, work is going on, my lord, it has not stopped. My lord.
I made submission, my lord, before interim order was granted. Work order has already been issued to the respond number 5.
Sumant, you are taking a big risk.
I'm not saying that we have.
Today we won't be passing any order. On Wednesday, after the affidavit comes on record, you address arguments. If we find that you have violated, we'll straight away initiate criminal contempt.
Please.
So put your client to notice on that. Once there's an interim order passed by any bench, it will be implemented.
Please.
I don't think the bench changes, therefore you can get
No,
away with it.
I'm not that.
That won't happen. Irrespective of which bench and which point of time has passed, it will be implemented.
That
if it is found that you have violated, there will be consequences.
That to interim order after hearing the opposite side, my lord.
Even worse. The AG submit that the affidavit of the finance secretary is under preparation. If the matter is taken up on Yavatto, when do you want it? Wednesday is 2nd. If the matter is taken up on 2nd, the affidavit would be filed and arguments advanced. Released on 2nd September.
Applies.
Affidavit of respond number 2 is taken on record. Copy thereof has been served on the councils.
2:30.
2:30. 2:30 ಅಲ್ಲ further hearing.
Oblige.
ಇದೊಂದು ಮುಗಿಸಿ 14 ಆಮೇಲೆ ಅದಕ್ಕೆ ಬರೋಣ.
Serial number 14, B.R. Vishwanath.
ಯೇಸುಸ್ ನಾಗಭೂಷಣ್ ಏನಾಯ್ತು?
ಏನಾಗಿಲ್ಲ, your lordship may have it on 7th or 8th.
ಇದು ಯಾವ್ದು ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಇಲ್ಲ ಹೊರಗಡೆ
Bangalore city. Bangalore.
ಸೊ ಇಟ್ ವಿಲ್ ರಿಮೈನ್
It will remain here.
ಇನ್ ದಿಸ್ ಕೋರ್ಟ್ ಓನ್ಲಿ.
7th or 8th.
ನೀವಿಬ್ರು ಇದು ಸೆಟಲ್ ಆಗ್ಲಿಲ್ಲ.
Spite of best efforts, my lord, sorry we could not. Your lordship, both of us are quite anxious, but in spite of our best efforts, my lord, sorry we could not achieve it.
The 2004 matter.
Yes, 7th, your lordship.
How long will you take?
May take about 45 minutes, both of
Both of you?
Yes, my lord. I'll take. Unless my learned friend takes little more time. No, my lord, no. I will be precise and I will also take only 20 minutes.
Because we don't know after 7th what is the roster. 29th Saturday ಏನಾದ್ರು ಆಗುತ್ತಾ?
ಈ Saturday.
ಬೇಡವಾ? ರೆಡಿ ಆಗ್ಬೇಕಾ ನೀವು? 14th ರಜಾ.
During next week, my lord, if lordship feels.
4th ರಜಾ. We'll have it on 10th. 14 released on both the councils submit that despite their best efforts, the matter could not be settled. They submit that they will get ready and address their arguments on the merits of the matter. Released on 10th September. The income, end of the list. Income and cash certificate ಇದೆಲ್ಲ. End of the list ಕೊಟ್ಟು ಮುಗಿಸ್ಬಿಡೋಣ.
Yes.
You got the
234
instruction on,
matters.
but income and cash certificate, last date is there.
My lord's here and
Shatabish Shivanna.
Petitioner, my lords, is a members only recreational club. And they're subjected, my lords, to harassment by the police and regular interference by the
Same.
Third point, my lords, is to subject themselves to the terms and conditions, my lords, laid down by the coordinate bench in WP number
And
30.
AGA accepts notice for respondents, the interim order granted and so and so, benefit of so and so is extended so and so. Connect with serial number 2, relist on yavatide?
29-9.
29-9.
Very good. So great. Sir.
My lord, on submission, say number 15, number 15, fourth list, say number 15.
We won't be taking up that. End of the list.
So this is cash and income certificate, my lord.
Hmm?
Cash and issuance of cash and income.
Cash and income, pass over.
Please.
Party in person, Rajalakshmi Shankar Janardhan Murthy.
My lords, I have filed a wakalat in that.
You filed wakalat.
My lords.
What's your name?
Bipin, my lords.
Shri Bipin BS has filed wakalatnama for the petitioner. Registry direct print his name as such. Then Form C Agilala.
Yeah, my lords.
Yes, there would be no requirement for placing the matter before the party in person committee for securing Form C. Yes,
My
Haley.
lords, petitioner is the champion of the Para Asian Championship, my lords. Now, my lords, for the next Para Asian Games, my lords.
When is the games?
Para Asian Games, my lords.
When is it?
October, 15th October, my lords.
15th October.
Yes, my lords.
Yes, so we have time.
Page number 17, my lords. The last second para, my lords.
Hmm.
My lords, there is a eligibility criteria, my lords. The NFEs are eligibility nominate the athlete either the weight category event athlete has achieved 6th or better finish in the category event at the last senior Asian championship held within 12 months, or his or her words ranking up to 6 of the Asian national international ranking as 10th before the submission late, my lords. Now, my lords, this is given by the Ministry of Youth Affairs, my lords. But my lords,
For the first
You are
respondent.
appearing for whom?
Only for the first respondent.
First respondent. Shri
My lords,
Mahesh Arkal accepts notice for respondent number 1. Sports Authority of India manne yaar appear agi?
D. Basuraja.
So and so for respondent number 2. Indian Olympic Association. Manne matter ittalla. Bimal. So and so for respondent number 3. Paralympic Committee.
Central Government.
Separate council ಇದೆ. ಮೊನ್ನೆ ಅದರಲ್ಲೂ ಆಕ್ಟ್ ಪ್ಯಾರಾಒಲಿಂಪಿಕ್ so and so for 4 and 5, 4, 5 and 6. Council for the petitioner to furnish 2 sets of the petition along with annexes on the said councils.
My lords,
seeking for your stopping forwarding the selection list. We can't do that.
yes, my lords, my lords, one submission. This document, my lords.
Your consideration, yes, but not stopping the others.
Yes, my lords. The thing is, my lords, that TTFI, the Table Tennis Federation, my lords, they have given the criteria, my lords. In that criteria, my lords, page number.
See, your relief is only for amendments to consider your representation.
Yes, my lords, but one submission. Because, my lords.
Grant that relief.
My lords.
We'll grant that relief right now.
Yes, my lords. But if tomorrow is the last selection,
That is
they
why
are releasing, my lords.
We are not going to stop a list which is being sent.
Yes, my lords. Because, my lords, Table Tennis Federation has given the list, my lords. But that federation is itself is their recognition is been cancelled, my lords.
Mr. Counsel, this is representing the country.
Yes, my lords.
So we can't stop a list which is going or gone.
Yes, my lords.
If your request is required to be considered, it will be considered in accordance with law.
Yes, my lords.
Just because you cannot say that because I am not going, nobody else should go.
No, my lords, not that's
That is
not
why
the
we
thing.
won't grant you the interim order.
My lords, one
Serve it on them, let them come and we'll hear them.
one submission, my lords. In page number 2, my lords, in the document,
Can we grant the interim order to you now?
Yes, my lords.
Stop that list.
My lords,
Even if we can, we are not inclined to do that.
yes, my lords. But my lords, the criteria which was given to the candidates, my lords, the criteria which is given by the Table Tennis Association, that is what they want. Their criteria is given. My
You
lords.
want to us to pass an order. The interim order which has been sought for is to stay the finalization, submitting and forwarding of the selection list of the para table tennis players to the Asian Paralympic Committee for the Aichi Nagoya 2026 Asian Para Games to be held by respondent number 4. The submission of learned counsel for the petitioner is that the same are being finalized tomorrow. This court is not inclined to grant any interim order today, since the stay of any such finalization submission of the finalized selection list would result in the country not being represented in the said games, which is not permissible. The aspect, what can only be considered is the aspect of the entitlement of the petitioner, which shall be considered on the appearance of the respondent. Relist tomorrow. You serve it on all of them.
Yes, much of this.
Tomorrow in preliminary hearing.
Serial number 4. Dariappa India.
General parole, my lord. Is in
Yeah,
cus-
is it?
is in-
End of list. Yes.
General parole, my
Pending
lord. is in-
matter.
General parole, my lord.
Pending matter, why did you move it?
It's my lord. The matter why I moved, my lord. The matter was listed on 12th, my lord. By oversight, my lord, this matter was adjourned to 15/9, my lord. That's the reason I moved on previous date. Also, this matter was listed. I moved memo, my lord, and this honorable court is directed to list this
Yeah,
matter.
what is the next parole matter?
Lord, I have sought the instruction, my lord.
My lord.
You got the
Yes,
instruction?
yes, my lord.
Yes, what are the instructions?
My lord, the Palakkad Kerala police station has rejected because he may influence the witness, my lord. But the reason he is given is genuine. His parents are, the Palakkad police has rejected, my lord, out of state parole. He has sought because the prisoner's parents are suffering from cancer, my lord. For that treatment, he has sought. That reason is genuine, but they have rejected because he may influence the witness, my lord. There's
No.
an ongoing trial.
No. It's already convicted matter, my lord. My lord, he has been already granted once, my lord, parole. Kindly see the imprisoned certificate, my lord. Page number 11, my lord. And serial number 11, my lord.
What is the policy regarding out-of-state parole?
I'll just verify, my lord, out of state.
Because you won't have jurisdiction.
No, my lord. The prison manual doesn't state of how, because the
You're
issue
not
problem
dealt
will be, my lord, if he absconds, my lord, we cannot arrest him. The state
Like what Mr. Gautam argued, you can't go there.
without their help, we cannot arrest them if he violates the parole.
My lord.
That's why usually the out of
My lord.
state parole will not be granted, my lord.
It will be granted, my lord. There is a judgment, my lord. So with the local two sureties, my lord. That cannot be with the strict condition that may be imposed, my lord.
It's not something that is an emergency for you. You wait till he makes his submission. You go through it and
Yes,
make your submission. Let us see how it has to be dealt with. And if there are any judgments on out-of-state parole, please place it on.
Yes, my lord. I'll place the judgment.
May be also permitted to produce judgment.
When will you get ready?
It may be listed along with other paroles, my lord. Third.
3rd or 17th? When will you get ready? We'll need to do some research on this.
17th.
17th.
My lord. It may be taken on 3rd, my lord.
You will do research for him?
No research.
Let him do his research.
Because his parents are suffering from cancer, my lord. That's the reason I moved, my lord. There is urgency.
Yes.
His father is already bedridden, my lord. He's not able to walk also, my lord. That's the reason. At least 3rd, my lord.
Yes, my lord.
Research.
3rd.
Yes.
Caste certificate.
21 and 41. Serial number 21, list number 1.
This with regard to that, in order to overcome my lord's order, now they have issued annexure A, my lords.
Yeah.
Appointment of
We are taking only that income come cash certificate.
23 and
21.
We have, my lord,
Lords,
they had
granted
given
interim order.
representation, my lord. Petitioners had given representation. Endorsement is not issued.
21, my lords.
21 kodi. ನೀವು 21 ಅಂತ ಕರೆದಿದ್ದಕ್ಕೆ ರಾಜಶೇಖರ್ ನಿಂತು
Today is the last date, my lords. That is why, otherwise I would not have troubled.
They also have last dates. How many last?
My lord's order is at page 57. Operative portion is at my lord's page 62.
Yes, madam. Any order passed?
No, my lord. They haven't.
The grievance of the petitioner. Third, the grievance of the petitioner is that without complying with the direction issued by this court on 3/11/2025 and WP number 31740/2024, Annexure A has been issued inviting application from applicants for appointment of members of the Committee of Management of Sri Vidyanatheshwara Temple, Kokoda Village, Beltangli Taluk, DK District. This court by order dated 3rd November 25 had directed the respondents to consider the representation within a period of 4 weeks. Until such representation was considered and necessary orders passed, the notification at Annexure A could not have been issued. In that view of the matter, the operation of Annexure 4th September. And AG accepts notice for respondent number 1 to 4.
Lords, may I request, my lords, let them communicate the order, my lords.
ಇದ್ಯಾವ್ದು ಅಮ್ಮ ಇದು?
23.
23. Yes. Yes, Mr. Kantraj. ಯಾವ್ದು ಇದೆ? 23.
23 and 41 and the end of the list.
23, 41.
41 and end of the list.
End of the list. ಮೂರೇನಾ? Yes, Jafar. At 5/9, you're still filing objects.
Xeroxing and all, we got the instructions.
Let him argue then.
Yes, sir. In the meanwhile.
Yes, Mr. Kantraj.
The petitioners are seeking directions to issue the caste certificate. That is the non-creamy layer certificate. On the ground that their parents' income is less than the
8 lakh rupees.
8 lakhs rupees. But that is being refused by the concerned Tahsildars.
Refused or they including your income? Either, what is the situation?
In this case, see, the petitioners are teachers.
Your income is also being included.
Yes. But our case is, the parents' income is to be taken into consideration as it has been held by this honorable court, including Supreme Court judgments also. Including March 11th, 2026, Supreme Court has held, saying that even it has gone further from Sukhinder Singh case, saying that not only the criteria, so far as the money is not the criteria, it is the status of the candidate.
What are the judgments?
Judgment I have produced.
Page?
ಹೇಳ್ತೀನಿ. Annexure G. One second. Para 26 to 31.
Page number.
Page number. 26.
Page
186.
186.
Yes.
The above extract makes it clear that the income, salaries, agriculture or other sources cannot be clubbed for the purpose of applying the income wealth test to determine the creamy layer status of a candidate. It is also evident from the comprehensive reading of the 1993 OM along with the clarificatory letter dated 14/10/2004, and income from salaries alone cannot be the sole criteria to decide whether a candidate falls within the creamy layer. The status as well as the category of the post to which the candidate's parents or parents being essential. The exclusion under categories 1 to 3 of the schedule is status based rather than purely income based, reflecting the policy understanding that the advancement within the government service hierarchy denotes social progression independent of fluctuating salary levels. Mere determination of the status of a candidate as to whether he or she falls within the creamy layer or non-creamy layer of the OBC cannot be decided solely on the basis of the income. In fact, para 7 of the 2004 letter makes it amply clear that the mechanical application of income thresholds may in certain situations produce inequitable outcomes. To that limited extent, 2004 letter may be understood as reinforcing the scheme of 1993 OM, provided it is construed as explanatory and not altering the substantive framework.
Mr. Kantraj, the whole
is.
issue here is.
And then, Milord, you will ask me.
93 was issued by the DOPT for the Union of India.
Yes.
And the DOPT letter was as submitted in the other matter.
Yes.
It was accepted in Punjab and Haryana.
Yes.
And because Punjab and Haryana had accepted it, it was extrapolated to the ESCOM of Punjab. And in Surinder Singh, they said that since it has been adopted by the state of Punjab, it would be applicable.
But here also, Milord, in our state.
Is it been, as that DOPT been accepted and adopted in Karnataka? You'll have to show us that.
No, Milord, even see, in addition to that, my submission is, even in Karnataka also, Milord, creamy layer policy has been discussed and accepted by this honorable court.
But this argument which has been raised was not considered in those matters.
May I make one submission, Milord, you last, subject to Milord, result of outcome of the writ petition, kindly they may be permitted to take the examinations, Milord. We will contest the matter, no problem. Yeah, otherwise, Milord, they will lose the last chance, Milord.
My lord, won't be able to decide it by.
Yesterday, my lord, on 26, we have given a clarification, my lord, with regard to the Form H and Form F. F is the normal creamy layer certificate, caste income certificate. H is a certificate issued for those persons who are already serving. But those people can get the non-creamy layer benefit only if they are serving in the same department. For example, my lord, if somebody is working in the police department, let's say he's in the constabulary. Now what happens is he wants to apply to a higher post when such an examination is called. If he applies, my lord, then Form H will be issued to him only for the purpose of getting that non-creamy layer. That will not be applied. Now here in all these
only
cases.
The certificate which is to be issued, examination
Yes,
scheduled.
Now, my lord, the simple question is whether the candidate's income, all these candidates, all these petitions.
What, Mr. Khan? See, we won't be able to decide it by 31st. So if today you issue the certificate without taking into consideration the applicant's income, which shall be subject to the result of this.
Result of the writ.
You are filing your objections. We'll have it next. When is the examination?
31st is
31st is the last day to file the application.
File the application. When is the examination?
Examination.
Date is not fixed.
November 15. In a bada time. September second week we'll have it. You get ready and address your arguments. If you succeed, then
Yes,
they won't be
ma'am.
writing the exam. If you don't succeed, they'll write the exam and then it'll have to be seen whether they succeed in the exam.
Then in that case, now your lordship may kindly have it as parted, but not then.
Fair enough. They've heard you enough. This, all the citations have also been placed.
Yes, my lord.
Parted and.
In none of those matters, my lord, 12/12/1986 or even that 2002 notification.
None of them are challenged.
Not challenged, not set aside. It's only the Akshata Chaugula, what they are all referring, my lord. Surinder Singh is, my lordship has made it very clear that it does not apply to our state. But 342B, we have our own state commissioner. Leonard Senior also should know much better than me, my lord. In fact,
he knows everything about it.
All that is required is, if they are entitled to, they should not.
See, their ratio is also important. That if already a person has crossed a threshold and is able to take care, then he should not get. That is the whole concept of creamy layer.
Yes.
Somebody else should get the benefit.
Yes, my lord.
That is what the government is
Let them
trying.
file the blood objections. Blood, we will contest the matter. We will argue the matter.
My lord, your
In the meanwhile,
lordship, in that case, my lord, the
we may
lordship is
permit it
allowing
to
them
file the
file the application, my lord. They will not claim any matter of as a right. There are by virtue of this interview because they have filed the application. Then if they say that since we are allowed
Make
to
it an order of the court.
yes, very well, very well.
Make it an order.
Very
of
well.
the court. I mean, interpretation la better.
Yes.
23. No? And AGA accepts notice for respond number 1 to 3. KPSC Garo.
KPSC, my lord, Shamir.
Mohammed Shami.
Mohammed Shamir.
Mohammed Shamir for respond number 4. The above matter gives rise to requires the consideration of a matter of seminal importance. as regards the creamy layer of a backward person belonging to a backward class. The submission of learned counsel for the petitioner by relying upon the decision in Surendra Singh was so and so, and the decision in Union of India versus Rohit Nathan and another civil appeal number 2827-2829 of 2018 is that the income of the candidate is not to be considered for the purpose of issuance of a income and cash certificate for purpose of determination of the creamy layer of the candidate. And in that regard, Reliance is in that regard. Learned AGA would have a content that the said decisions would not be applicable since those decisions were rendered in the background of a 1993 official memorandum which had been issued by the Department of Personnel and Training, Union of India, which had been adopted in Singh's case by the state of Punjab and as such was made applicable to the state of Punjab. His submission is that the said official memorandum, 1993 official memorandum has not been adopted by the state of Karnataka and as such the OM will not be applicable in the state of Karnataka. The subsequent clarificatory letters which have been relied upon by the petitioner would also not be applicable to the state of Karnataka since the original OM has itself not been adopted in the state of Karnataka. His submission is that it is not the 1993 OM, but it would be the various notifications which have been issued from time to time by the government, by the state of Karnataka, which would be applicable for the purpose of determination of the creamy layer of a person belonging to the backward class. This as objections you are filing now?
No, my lord, we'll file the update. Let's have a copy.
This matter requiring consideration, the last date for submission of the certificate for
31st.
last date for submission of the certificate along with the application to the fourth respondent for the exams to be held by the fourth respondent being 31st August 2026. It would not be possible for this aspect to be determined decisively before that date. Learned AGA submit that the objections would be filed within a week from now, after serving a copy thereof on the council, respective councils for the petitioner. In that view of the matter, this court is of the considered opinion that at this stage, the respondents could be directed to issue a caste cum income certificate, income cum cash certificate. Respondent number 3, Tahsildar. Respondent number 3 alla bere bere lane.
Respective Tahsildar.
The Tahsildar, the jurisdiction Tahsildar could be directed to issue the caste cum income certificate. Two caste cum income certificate. One taking into account the income of the applicant, the other without considering the said income. For the immediate purpose, the petitioner would be permitted to submit the certificate without the petitioner's income. However, the said submission and consideration by the respondent KPSC shall be subject to the result of the above writ petition. The petitioners shall not be entitled to any equities on account of the submission of the said certificate in the event it being found that for the purpose of determining the creamy layer, the income of the candidate would also have to be taken into consideration. Then the application filed by the petitioner would stand rejected. The respondent, the Tahsildar, is directed to issue the above certificates by end of day 29th August to enable the petitioner to submit it. 2 days bad in the applicable form.
That is common. Form F is
End of
common.
day 29th August to enable the petitioner to submit the same on 31st August 2026. Objections to be filed by 11th September after serving advance copy on the petitioners. Released on 22nd September. All the councils are directed to file their respective synopsis of dates and events, list of authorities, along with authorities, as well as synopsis of arguments by that date after exchanging the same with each other. 22nd at 2:30 p.m. for further hearing. 23, 20,
23.
next year, 40, 41, same order. And AGA is directed to inform the concerned Tahsildar about the above order. It won't get typed till at least 7:30. You won't get it. 41, ಬೇಕು ಅಂದ್ರೆ ಸಿಗಲ್ಲ.
We will inform all the Tahsildar.
40,
41.
same order. ಆಮೇಲೆ end of the list.
End of the list, one matter.
List 2, IA1 of list 5, CL number 2, IA1 of 26 is allowed, same order, connect to each other.
We will inform you.
The jurisdictional Tahsildar ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದೆ. Passed over will repeat tomorrow. Who is your respondent? Who is the respondent?
The state has verified. Verified, my lord. Charge sheet was filed. Their names are as of now not in the charge sheet, but we've asked for the court for permission for a further charge sheet, my lord. To file a further charge sheet. Extension has been sought. The investigation is still ongoing.
173 report has been filed. I'm not an accused presently. Even
They've asked for further, in a court has granted them.
compliance with the bail conditions, they are not.
Then we'll have to hear you on that.
Then I can submit this. I only want to go to my. I only want to go to my native in Delhi, madam.
What is the problem in going to Delhi? And
Stay, madam.
He reports back
Delhi
in
is within
Bangalore.
the country.
If he reports
Yes.
back in Bangalore in a day, my lord,
Yes, when will you go and come?
Tomorrow morning, I can come back anytime. Whenever the state would want me to, they can just issue notice. I'll immediately come.
Tomorrow you will go and come back when?
So I'm a resident of Delhi, it's a permanent resident. I'm
Now,
not going in Bangalore.
you said you are going only for Raksha Bandhan. Now you are saying you are going to Delhi.
I came only for compliance with the bail order, nothing else. The investigating officer did not even give.
Release tomorrow.
Your Lordship may permit me to make a mention.
ಅದು ಆರ್ಡರ್ ಆಗಿದೆ
Court officer, list 1, serial number 121.
ಚೇಂಬರ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಡಿ ರೆಡಿ ಇದೆಯಂತೆ ಇದು ಜಜ್ಮೆಂಟ್ ರೆಡಿ ಇದೆಯಂತೆ ಅಲ್ಲಿ ಕೊಟ್ಬಿಡಿ ಅಂದೆ ಪಾಸ್ಟ್ ಓವರ್ ಇವತ್ ಪಾಸ್ಟ್ ಓವರ ಇವತ್ ಪಾಸ್ಟ್ 39 ಹಾ ನೆಕ್ಸ್ಟ್ ಬಂದಾಗ ಕೊಡಿ ಇವಾಗ ಬೇಡ ಇಲ್ಲ ಕೌಂಟ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ಬಿಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಇದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಅಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಡ ನಡಿವಾಗ ಕೊಡ್ಬೇಕು ಈಗ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಲ್ವಾ ಡೇಟ್ಸ್ ಒಂದೇ ಒಂದ್ ನಿಮಿಷ ಲಿಸ್ಟ್ 1 ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ 18/9 ಪಾಸ್ಟ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ಟುಮಾರೋ ಪಾಸ್ಟ್ ಓವರ್ ಸುಮಾರು ಬೇಡ ನಾಳೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಲಿಸ್ಟ್ ಎಲ್ಲ ಫಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್ ಲಿಸ್ಟ್ 4 ಫಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್ ಫಸ್ಟ್ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ 18 ಸೆಪ್ಟೆಂಬರ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ನೋಡಪ್ಪ ಈಗ ಹೇಳಿದೀನಲ್ಲ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ
ಅರ್ಜೆಂಟ್ ಇದೆ.
ಆಯ್ತೈತೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಇಷ್ಟ ನಂಗೆ ಹೇಳಿ ಎಲ್ಲ ಅದ್ರಲ್ಲೇ ಇದೆ.
Court officer, madam.
ಎಲ್ಲ 18 9